suspecting that none of these House bills will actually be the ones that get to the governor's desk, that we'll be dealing with the Senate bill next week. So legislative process aside, because you and I do not know the final answer on this, but we do know that that's what's expected to happen. So knowing that, you know, what the current injunction says in terms of our current regulations, and also knowing the cost of this today, day 3 of $20,000 a day, knowing that litigation will most likely happen if this was to become law in your proposals, and that would also involve more state costs in terms of litigation. So just wanted your responses on either one, and I'd like to have both of you respond.
Is it your position that there should be no regulations on abortion facilities?
I am not the one testifying here, so again, Representative, can you ask, would you like to answer the question too?
The decision from the Western District left us in a situation where it struck all of the ambulatory surgical center requirements. So in the absence of passing a bill, all of those requirements are out the window. Do you believe that that is a good state of the law, that there are no regulations on abortion providers in the state of Missouri?
Well, I believe that the federal judge was actually following the Supreme Court landmark ruling. So if that's what we have to do, that's what we have to do. Representative, would you be like to answer the question?
Did it say?
Some of these answers for people who would like to testify.
Where in Hellerstedt did it say that states cannot regulate abortion facilities at all?
I will leave that your question for those who would like to testify further on this.
So you don't have an answer to that question.
Excuse me, Representative, this is my inquiry. I need to remind you again how legislative process works. I'm asking you a question, and
it's the fact that it's not true. I'm challenging the basis of this, the assumption at the basis of your question.
All right, thank you, Representative Swan.
Yes, in answer to your first question as to whether this is justified, it is not our authority to call it, nor to.
I was just asking your personal opinion.
My personal opinion is, when you consider since 2003, we were looking at 4 or 5 years of post violations of the facility with numerous ambulances being called. Take the numbers of women patients being treated at that facility, considering the potential for substandard care, divide that time to cost of a special session. What's that like worth to you? Secondly, just because there's a potential of future litigation, court action on something does not prevent or should not prohibit one from doing the right thing.
Right, thank you.
Representative Breeze.
Representative Barnes, I'd like to hear a little bit more about the Hellerstedt verdict that you were just talking about, that you really didn't get the opportunity to explain. Could you please explain that to me?
Well, I don't know that I wouldn't call it a verdict, but the Hellerstedt opinion struck down specific regulations in the state of Texas. It does not state anywhere in Hellerstedt that a state is prohibited from regulating abortion facilities in total. And in fact, I think it's page 2 of the published opinion, it notes that the provision of Texas law, which it struck down, had changed previous Texas law that it required an abortion facility to maintain a written protocol for managing medical emergencies and the transfer of patients requiring further emergency care to a hospital. So the Supreme Court in Hellerstedt says, look, we're not reaching this previous Texas law that requires a plan for patients who need emergency care. We know in St. Louis that there are patients who very likely had abortions, who had to be transferred to a hospital via ambulance. In the wake of the current opinion that we have, there is some doubt as to whether the department has the authority to have any regulations at all on that facility as it relates to the ambulatory surgical center. And so in the absence of state action, there is a regulatory desert. And we are coming in and saying, look, Hellerstedt says you can't do X. The court in the Western District said, yeah, as it's currently constituted, this is not going to survive. What we're doing is saying, okay, if you say that's not going to survive, we are still going to come in and we're not going to allow this regulatory desert to exist. And we are going to have some reasonable regulations on abortion facilities.
Okay, thank you very much. So we're making sure that there are regulations with this bill and caring about the safety of the people that are there.
That's correct.
Thank you.
Other questions from the committee? Representative Cookson will come back over to the ranking member.
To inquire.
You may.
Thank you, ma'am. Representative Barnes, you indicated there that that was, the Heller case dealt with Texas law. Is that correct?
It dealt with a law in Texas that was similar to current law in Missouri. I don't think it's identical, but it's similar.
Okay.
And there was different facts regarding our state, different facts on the ground as there are in Texas, which also goes into a court's analysis.
Okay, my question is here, are they in the same district, federal district of appeals as what Missouri is?
No, Texas is in the Fifth Circuit, but there's a
Yes.
Supreme Court opinion. So, and the Western District is using the Supreme Court opinion. It issued this preliminary injunction.
All right, my
For the
question
Eighth
is,
Circuit.
I mean, the way I understand it is that circuit, that means that that would apply to that circuit, not necessarily to our circuit. Is that, am I reading that wrong?
Hellerstedt applies nationwide.
So that would be the same as a Supreme Court ruling?
Well, Hellerstedt is a Supreme Court ruling.
Okay, all right, I'm, okay, that clarifies it for me. Thank you.
Ranking member Meredith.
To inquire,
You
please.
may.
Representative Barnes, I am not sure I heard you correctly. You were talking about the reason all of these individual items and the length of the bill is there is because we want to make sure that all these regulations are in place and not leave that up to the department. You said the department now is fine, but who knows what's going to happen in the future. Did I get that right?
I don't like statutes. In general, I oppose statutes that give blank checks to departments to write rules and regs. Not just in this space. Across the board, I don't like blank check statutes that give blank checks to departments to write rules and regs. Now, we can't, statutes can't do everything. We can't possibly come up with every factual situation that the department may want to regulate, but we also have to set some standards.
Well, my understanding is that the legislature is made up of people from all over the state, from all different walks of life. And our department people are specialists in the area in which their department is. Like Health and Human Services would be the experts in health rather than the legislature. Education would be the experts rather than the legislature. And I'm wondering, I mean, these bills are getting bigger and bigger. Mine has 28 pages, but I understand from what Representative Swan was saying, the bill is something like 48 pages or something.
I think that was just a matter of formatting from a draft that she had. And I think the language of the draft is identical to the language that was filed, but they haven't.
I could follow
Yeah,
so many
it's-
pages, but then
It's
it's
not the
kind of
first
run
time
out.
Representatives testified on their draft and had all the committee members.
Right. So,
I
was
think
one
that
that
happens in
confused
the
it.
regular session. I think that happens, every day somewhere.
we should all have the same copy, so we can read the pages and follow along, because I think it's real important. Because this issue is crucial to a very large number of people. And we have to look at our Constitution as the whole. And I appreciate you saying that we all have our own beliefs. And Representative Moon stated, much to my pleasure, I suppose, that we all have our own beliefs and we all have to respect one another's beliefs. And I want to thank you, Representative Moon, for saying that, because I really appreciate that, because I think that's incredibly important. Kind of a reiteration of our First Amendment, freedom of religion, freedom of assembly, freedom of speech, and so on. I just want to clarify that with you, because it sounded like maybe you didn't have so much faith in the departments.
As a general rule, I think the legislature should set general standards, let the department work out the details. But we do need to set some standards for departments in making rules and regs. And again, not just in this space, in every space. I feel like I've had this conversation 25 times in 25 different subject areas.
Thank you. Representative Stacy.
Thank you, Madam Chairman. I'd just like to inquire again, just to clarify, Representative, you made a point, Barnes, about maybe the administrative portion of our government, its role relative to the legislative portion of our government. Some would say that there are professionals that ought to establish law, and people who know more than the elected officials. And some would say the elected officials should decide what law is, so that the people can vote on the laws that are made. I just would like to see, in fact, just clarify just a little bit, if you'd like to speak to that point. You kind of started down that path, but I would like to understand a little bit more your position on that.
Sure. William F. Buckley famously said he'd rather be governed by the first 100 names in the Boston telephone book than the faculty of Harvard University.
Representative Barnes, I'm just going to break in and say that if you will answer his question in context to how you brought it to in relationship to this bill, not broadly to every 25 or whatever it may
fair.
be, but
That's
just
fair.
keep it within its lane, okay? Thank you.
Sure. We have an administrative state that comes in to fill in the details, including in regulation of healthcare professionals. But I think it's important for the legislature as the elected officials to set the basic requirements and basic goals of what those administrative regulations are going to be. We can't possibly legislate every single detail of every single regulatory system in the state of Missouri. We can set some simple rules and tell the department and regs on these statutes, here are the guidelines. And this is one of those situations.
Representative Ruth, to inquire, you may. Representative Barnes, I'd like to stay on this line of questioning, please. In dealing with the departments, I sat on appropriations for health and health. I've sat on health and health policy committee before, dealt with a lot of different issues within different departments. And I think we try the best that we possibly can to put those guidelines in place. But certainly, even with the department we're speaking about and other departments, would you say that there have been times where things were so loose that the departments took it upon themselves to enact their own and not necessarily always in line with what the guidelines were that we set in place? I can think of a
Yeah, and there's a
couple of times.
process by which people can challenge that. And the danger is when the legislature writes a blank check for a department to promulgate regulations. If the department promulgates regulations that the legislature doesn't like, there's nothing we can do about it anymore because we wrote them the blank check in the statute to promulgate the regs.
So
Other than, I should say, there's nothing we can do. We can change the law. That much is clear, but the person affected can't win a lawsuit if it's a blank check, and JCAR can't disapprove of a rule if it's a blank check.
So by putting this in statute, this is going to hopefully give better guidance and make sure that some of this is followed through on.
So some minimal requirements, and I have every confidence in the current administration, but when we make statutes, we ought not be thinking about just the current administration, but future administration.
These statutes could be there for years unless someone comes in and changes them. Thank you.
I will comment on this particular topic because those members of the committee that were here in 2015 and we had the investigation into how the department was handling the reconciliation between the abortion reports, the pathology reports, and submitting them to the department. And we found that there were over 16,000 reports that were not reconciled. So having statute in place that clearly protects the health of women, following through on that statute was, the Senate had to have an investigation in order to bring out all of the details as to why statute wasn't followed through or department regulation wasn't followed through on this issue. So I think we're revisiting. We found that the direction to the department was perhaps a bit weak. And today, with some of these bills, we're affirming what the intent of the legislature is with these regulations. All right, any other questions? I can ask you a question.
I just want to make a comment.
Sorry, no, in that case, it ought to be, unless you're an ex officio, which you are, Representative Walker.
Thank you, Madam Chair, to inquire.
You may.
I want to, Representative Barnes, I want to go back just your kind of beginning breakdown about the impetus for you bringing this legislation forward and what you call the distinction between surgical abortion and medical abortion. Could you just explain a little bit more about why you felt that it was necessary to make that distinction, specifically as it relates to the Hellerstedt case?
Let me talk about the Planned Parenthood versus Williams. The court, I have page 3, I use Google Scholar. Sorry, that's page 4 of Google Scholar. Talks about where are we here? The Kansas City clinic, where there were only surgical abortions, only medicinal abortions exclusively used in Kansas City. The language of the case breaks apart its analysis between the medicinal abortion and the surgical abortions. And I think if you look at the medical literature on complications, there are different types of complications for the two different types of procedures. So to me, that means that different regs, courts would say different regs are appropriate for those different types of procedures.
Okay, sure. And your, I guess, proposed legislation or language
So
the complication, sure.
Let me give you an example. So the medical abortion, I don't think you're going to have a hemorrhage in a clinic with a medical abortion. With a surgical abortion, you could, and I think there's likely at least 23 cases from Planned Parenthood St. Louis where that in fact happened and an ambulance was called to the facility. That's a distinction between the two procedures. The courts would generally, I think after Hellerstedt and Planned Parenthood versus Williams, would call for different requirements on the facilities.
Sure, I think that you're right. Typically, it's my understanding that with the medical abortions or the chemically induced abortions, patients will leave the facilities where they have received the drugs, and so if there's certain complications, those would not typically occur at the abortion facilities themselves.
And I would think that there's actually vast underreporting of complications in medical abortions, because if there's a complication from a medical service that someone had at facility A, how likely is that person to go back to facility A for the follow-up? Obviously, some people will go back for the follow-up on the complication, but other people would say, you know what, I have this complication that occurred from Dr. A. I'm going to go to a different doctor now.
So that actually gets me to my next point about the complication plans that you are proposing that seem to only apply to the medical abortions and not the surgical abortions. And so I'm trying to understand just kind of what you envision those sorts of rules and regs possibly looking like, considering the fact that typically these complications arise outside of abortion facilities.
I think the complication plans can and should apply to both examples. I think that there are physical.
Do they in this
They
though?
do not
Okay.
at the
And
current time.
it's-
You're correct.
Yeah,
But there's a legislative process. One reason to have House committee hearing bills, even if you think that Senate bills are going to go through, is the committee hearing process tends to bring things out like this, that you might need to fix that we might need to put it in both sections.
okay, well, before we get
So
to,
the surgical
Mhm.
requirement, I think some of the physical requirements that are in current statutes would still be appropriate to apply to abortion facilities that do surgical abortions.
the surgical requirements in terms of just the standards for abortion facilities, and I guess, the ambulatory surgical center requirements from Hellerstedt being
Yeah,
applicable?
I've got the current regs, if you want to go one by one.
Okay,
and
I've
decide
got
which
them too.
one might
Yeah,
still
I have
be
done that,
capable of
yeah.
being applied,
Sure.
which ones might not. But I think that where you're talking about a procedure that's invasive, that it's important to have certain physical standards. I mean, I think it's important to have hallways and doorways wide enough to get a patient on a bed to an ambulance. If they have 23 ambulances showing up for hemorrhages
I want to get to that.
and taking people away, don't you think it's important to make sure that there's a safe way to get that patient to the ambulance?
I think it would be more important to make sure that where they're going has standards, like, and typically hospitals, typically I understand that if there are ambulances that are called, they will be going to hospitals, and those places absolutely have standards in place.
But anything goes in the facility where births performed? I mean, because that seems to be your position. You've got to have
No, it's
standards
not.
where
I
they
think
arrive.
we're
but
just
not
talking
where-
about the complications, and then I guess the plans surrounding the complications, and whether or not it's appropriate for this complication plan to only apply to medical abortions, or should they apply to surgical and medical abortions, and just kind of what the kind of practical implications are. I also want to talk a little bit or get a little bit more clarification about the department's, I guess, requirement under the proposed language to require a follow-up visit. Could you elaborate on that a little bit more? What exactly does that mean? Where exactly was that follow-up visit occur? Like you just said, you don't anticipate that someone who had an issue at a specific, like a facility or with a specific doctor would go back to that doctor. I'm not sure about that. Certain patients develop relationships with their doctors, and so I'm not sure if that might necessarily always be the case, but I'm interested to know a little bit more about what you mean by follow-up visit and exactly how that would work.
A couple things. I think the current FDA regs on the drug say that that's the standard of care. Planned Parenthood's expert in the case in the Western District said that was the standard of care, that you have to have a follow-up visit. I think the Senate, having said that, I would propose taking that out of this bill and going with the Senate
The
language.
Senate language.
Although maybe I reserve the right to change my mind on what I think is the best thing to do.
Absolutely, understandable. Okay, the next thing that I want to ask you about, and it's something that we didn't really delve into as much as I would have liked, but I am quite happy that a fellow attorney is here to talk a little bit more about the Attorney General's concurrent original jurisdiction and the language around that specifically. So I want to first just look at the language itself. And
Can you just remind me what page we're on?
the version that I've got, it's page 12, starting at line 11, it's section 3, starting at line 11.
Okay.
Got it, Julia?
Yes.
Okay, so a couple of things. This is only applicable to what we are now trying to define through this proposed legislation to abortion facilities. Why is it that you think that the AG should only have concurrent original jurisdiction to enforce laws around abortion facilities?
First, I think the AG does have some additional concurrent jurisdiction, I think in chapter 407. I think there are some others, but it's not universal by any means. I think there are some other areas of law in addition to this where the AG ought to have concurrent jurisdiction.
Such as?
We'll leave that question for another day. Let's keep the chairs fortunate to stay on this bill. Let's not have a debate about the general powers of the Attorney General. The fact is that where the clinics are located now, I don't foresee any scenario in which a case will ever be brought based on where they're located. I mean, for example, we know that there are 23 examples of an ambulance showing up in Planned Parenthood in St. Louis by public records for hemorrhages. Those were likely abortion complications. At least one of them was an abortion complication.
Sure. And
There's never been a report of an abortion complication in St. Louis, though. That violates state law. And who's been asking questions about that? How can you have these 20?
Like this legislature has, based on the reports and things that have gone on. And so I think that questions have been asked.
But by no one locally.
Okay, sure. And so your position is that the Attorney General should step in because those questions have not been asked by prosecutors on a local level.
I think that where you have situations where a prosecutor is highly unlikely to ever bring a case where there's been a violation of state statute, that those are situations where it's appropriate for the Attorney General to have some level of concurrent jurisdiction. Or to transfer, or to have the other place, file a bill to have require local prosecutors in cases of police shooting, refer the case to your neighboring prosecutor or the Attorney General. There's another case another example where I think because of the dynamics of the situation, it's appropriate to have a third party
Okay.
with concurrent jurisdiction.
Sure. I think that there are probably reasonable minds can disagree about that, but okay, that's your opinion. I do want to talk now about some of the specific language. And you as an attorney and someone who was on the short list for the Missouri Supreme Court, I think will appreciate this. And
I never made it. The list was not short. There were 31 of us.
I
put myself on that list by applying.
considering the number of attorneys that.
Representative Walker, now, don't stroke the ego, okay? It won't help, all
Looking
right?
a little bit before I get it.
Yeah,
Okay,
the sweetness before you're gonna administer the sour,
Well,
I get it.
Thank you. That's my view. Okay, so the part that I'm particularly concerned about is in line 15,
We're still on page 12.
yes, we are, where, and you talked about the 23 ambulance calls and the lack of the records and whether or not that may or may not be a violation of state law. That's one piece of it. But there's also a piece in here that gives the AG concurrent original jurisdiction for violation of state law for a person who performs or induces an abortion. And that's the language that I'm particularly concerned about. There's certain people, providers, the qualified medical providers that we are attempting to clarify the definition of in this, that could be considered performing. But the inducing an abortion piece, what is to stop? And we just talked about the difference between a medical and surgical abortion. And with medical abortions, how typically the RU86 pill is taken by someone. What's to stop the Attorney General or prosecutor, for that matter, from bringing a case, a charge against an individual who takes RU486 and induces an abortion. I'm extremely concerned about that language. It's not clear if we have defined anywhere in statute what induces an abortion means, but just using the basic rules of statutory construction, just looking at the text of this language, what is to stop an AG from doing that?
Okay.
Or the AG from doing that?
So, the first place is I think you need to point to a particular statute that the process of inducing the abortion would violate. The second is that I think all of these apply to medical providers. So, I mean, I could foresee a situation which I think the guy's name was Kermit Gosnell from Philadelphia, right? Is that the right name? Does anybody represent has left? He was violating Pennsylvania law and the way he performed abortions, likely in the way he induced abortions, and it's appropriate for him to be criminally charged. If you have a...
So you can't foresee in any situation where an individual who is inducing an abortion via a medical abortion could potentially inadvertently violate some sort of state law. Let's say that it's a minor who has a fake ID or something and is able to go and get. I mean, I'm thinking that it's not clear when you just got induced an abortion that it's only limited to medical providers, and it cannot possibly be also applicable to individuals who would be having abortions.
Well, first of all, I think you want it to apply to potentially more than medical providers. I think we would agree on that. Now let's get the patient. Obviously, we agree that the patient is outside the scope of what we want.
Okay.
But you want it to apply to more than just medical providers. If someone who's not a doctor opens up a back alley abortion facility in St. Louis, you want the AG and the local prosecutor to be able to prosecute them, right?
Let me ask
Okay, so we want it to apply to more than just healthcare providers.
Yeah, I think that we can agree on that. Considering though that there is only one abortion provider facility in the state right now, it's not entirely just kind of outside of the bounds of what one I think could contemplate as happening is that a young woman who is in dire straits and desperate situations going online. I mean, I've seen documentaries where a woman has drank Clorox in order to terminate her pregnancy. What's to stop the Attorney General from going after that individual woman?
First of all, can you name a case in which such a prosecution has ever been brought?
I can't, but the way that the language, I can't right now, but the way that the language is currently written, it absolutely gives the Attorney General the authority to do that.
I do not share your fear that the Attorney General will start prosecuting individual women. That is not a scenario in which any real world fear exists.
Yeah, let's hope not. Thank you, Madam Chair.
Are there other questions for the sponsors of the bill? Representative Calvi?
To inquire. You may. Representative Barnes, I just wanted to follow up and affirm what you were talking about with the importance of this applying to individuals who may not be medical professionals. I'm sure you've heard the same as I that, as you said, correct me if I'm wrong, just to affirm what was discussed, that there are people who own these clinics who are not medical professionals.
Well, I don't know of any scenario in Missouri that's obviously
For as far as in the
if you
national.
want a person
Right.
who would, someone pretending to be a doctor, whether they're performing abortions or anything else, they ought to be prosecuted.
Right, absolutely. Just wanted to reaffirm that because I myself have met someone from Texas who previously owned an abortion clinic and was not a medical professional, and it just kind of brought that to memory. Wanted to clarify what you were saying, and thank you.
All right, other questions for the bill sponsors? Yes, Representative Mitten.
Thank you, to acquire.
You may.
Thank you.
Patience is a virtue.
Well, and actually,
There you go.
most everything I would have asked has already been taken care of, so there's that. What I'm curious about is your thoughts, really, on the limitation of the definition of qualified professionals as contained in your bill, and how that interacts with the Hellerstedt case. And in other words, if we have a Supreme Court saying that requiring admitting facilities places an undue burden, and you know, we don't need to hash out the rationale of the court and all of that. My question is, what's the difference when you're limiting the, in other words, when you're limiting who is a qualified professional, even to refer somebody to have an abortion? Doesn't that create the same sort of burden scenario that the court discussed in Hellerstedt? That's really what I'm coming to.
I don't think so. I mean, there are thousands of doctors, if not tens of thousands of doctors in the state of Missouri.
Okay, and
So there's no,
but right now, I mean, again, under current law, well, let me
I
ask
think
you
what
this.
Hellerstedt says is basically, the court came to the conclusion that the way Texas changed its statute basically made it impossible for so many women to perceive this definition as making anything impossible.
Well,
That's a very brief, that is about as brief a.
I mean, I think that reasonable people can disagree sort of about whether or not the term impossible.
Undue burden.
Right, an undue burden,
Undue burden.
which is not impossible. It's an undue burden.
You're right, undue burden.
So I don't think that I don't think that the impossibility was necessarily the criterion. And so.
But is it an undue burden to require health services to be provided by a doctor? That's the.
Well, it depends on what you're talking about when you're talking about health services. Again, and you're talking about just referring somebody for an abortion. I guess that's my question for you is, what is it that you're seeking to accomplish by that particular language? Which, of course, I can no longer find in my copy of the bill.
I think first is the definition's on page 7.
Thank you.
Of what I outlined, 174.
Right, so in other words, you're removing physician assistants, registered nurses, licensed LPNs, psychologists, social workers.
I don't know, I think, was there a question mark?
Well,
there?
well,
Okay.
I mean, in other words,
I'm not,
tell me what you're trying to accomplish by removing all of those healthcare professionals from the term qualified professional.
that said referrals come from the doctor. In addition to that, I think there are other areas of statute regarding consent procedures, regarding notification procedures that use the term qualified professional that are not present in this bill.
Okay,
Those particular statutes aren't, but the change of the definition of qualified professional was.
I get it. Is the term referred defined?
Not that I'm aware of, Lee.
Okay, so again, when you say the physician that referred, the qualified professional shall only refer to a physician who referred the woman to the physician performing or inducing the abortion. So again, my question is, you know, an 18-year-old young woman is pregnant and tells her psychologist about that. The psychologist can't say you can go to Planned Parenthood or NARAL or whoever, you can't go to the abortion provider, or they're subject to criminal prosecution. I'm just confused about it.
I don't think so.
I'm not trying to get you, I'm just.
No, I don't think so, because if we go, and I need to go look at the computer and do a Control-F search in the chapter for everywhere the term qualified professional applies.
Right.
And it,
But again, I guess, why is a registered nurse not allowed to sort of give that kind of referral, or an
well,
LPN?
what the definition doesn't speak to referrals.
Right.
The definition is just the definition. It's not that,
Right, but you're changing, what I'm saying is that the qualified professional shall only refer to a physician who referred the woman to the physician or to an APRN in collaborative practice with the person performing or inducing abortion. So you're injecting the word refer and limiting who can do that, and that's where I'm like, wait a minute, does this mean that a psychologist is violating the law and subject to the Attorney General coming after them?
But hold on, because you're in a definitional section. Let me come, I will get you an answer, I will.
And I can't
I will
control
do a
that.
control F for chapter 188, everywhere the term qualified professional
Okay.
appears. One of them is the consent section, I know.
Get it? Okay. So that's what you're trying.
Yes, that is one such section. I
And my
believe there are
concern-
some other sections that put requirements on qualified
There
professionals
are.
that say they have to do this.
Right, and let me put it this way, from, again, when you're talking about from the medical perspective and obviously performing direct medical services, I'm with you. But when you use the word refer in relationship to this limited definition of a qualified professional, and you're doing that in conjunction with language that gives concurrent original jurisdiction to the if it's just a typo sort of thing, or you know what I'm saying?
We're
Or
in the definitional section, so the operative sections are everywhere else.
I understand that, I understand that. Okay, well, thank you very much.
And listen, if you
Go ahead.
find operative sections for which you think it's a problem, please,
Well,
specific operative sections.
it's the word refer that concerns me. And, guess what? There are lawyers out there, they can twist stuff around. It's amazing. So thank you for the inquiry.
Are there other questions for the bill sponsors? None. We'll call witnesses. Public's information. The committee had two individuals who could not attend this hearing, and so the speaker appointed two members to serve in their absence. Representative Hannah Kelly and Representative Jay Barnes. And I would offer to Representative Barnes if he would want to return to the committee during testimony, you're welcome to do so. All right, our first witness, please. I'm sorry, and let me say in favor of the bill. I'm sorry, we start with witnesses in favor, so forgive me.
Good morning, Madam Chair, members of the committee, Tyler McClay, General Counsel with the Missouri Capital Conference. Want to go over the support of House Bill 3 and House Bill 6.
Is your mic on?
Sorry, I'll speak closer to the mic. Just want to go on record in support of House Bill 3 and House Bill 6. Our effort to address Judge Sachs's decision by creating statutory language that would authorize new regulations to be put together that would address safety standards for ambulatory surgical centers. I think we've been through this quite a bit. I don't want to rehash what everything that Senator Representative Barnes said.
Thank you.
Just kind of leave it at that. So.
Are there questions for this witness? All right, Representative Cookson.
Doing part quickly.
You may.
And before you turned on your mic, you are representing who?
The Missouri Catholic Conference.
Thank you.
All right, thank you. Other questions? All right, seeing none, be sure to leave a witness form. Thank you. Others in favor, in support of House Bill 6 and House Bill 3. I'm sorry, step backwards.
Good morning, Madam Chair, members of the committee. For the record, Susan Klein, representing Missouri Right to Life, here to go on the record in support of House Bill 3 and House Bill 6. Representative Swan for carrying this issue all these years, and Representative Barnes for his legal expertise. But I also want to thank the committee on that did the investigations on the sanctity of life. I think throughout the years, we have found that there has been a need for legislation to be passed to address the health and safety needs regarding abortion. Obviously, this bill in its early stages, whenever you're looking at one part of it, was dealing with the reports that were coming back from the Department of Health, as Representative Swan has mentioned. So that began the process realistically many years ago, 3-4 years ago, on this legislation. We saw further need as there was question about whether the pathology reports through the investigation of the committee, whether the pathology reports were matched up or not. We've seen multiple ambulance calls being called to the Planned Parenthood in St. Louis, and then ultimately through, and I won't go into the detail on the Hellerstedt decision. Obviously, there are differences between what happened with the Texas law and what happened with Missouri, and the need and the opening there based on Judge Sachs's ruling. So when you combine all this together, you combine the reports that we've gathered throughout the years on the different health and safety needs. I think this bill is necessary whenever you look at women's health care and clinic safety in Missouri. And we strongly support every part of this bill. We appreciate the governor's call on this and hope that we come out of this session with a very strong bill addressing all these issues.
For this witness. All right, being none, so be sure to leave us a witness form. Others in favor?
Madam Chair, members of the committee, Samuel Lee with Campaign Life Missouri. I want to go on record in support of House Bills 3 and House Bill 6. And if I have to leave, I'll just want to turn in witness forms for the other two bills that you'll be hearing at some point in time to be in favor. And first, I want to thank the governor for calling a special session and giving lawmakers an opportunity to pass some legislation which will protect the health and safety of women. And I want to thank Representative Swan and Representative Barnes and all the other sponsors for the legislation. Madam Chair, I just thought, I'm not going to repeat what others have said. I will try to answer a few questions that you, if that would be helpful, but if it's not helpful, please just stop it. Regarding the new language in here about the adding jurisdiction to the Attorney General. Missouri law in limited areas already allows for concurrent original jurisdiction by the Attorney General and local prosecutors for certain areas. It would be, for instance, in the areas of gambling or gaming violations, Medicaid, mental health net fraud, water pollution, hazardous waste, grain dealer offenses. And also most recently on the right to work bill that this General Assembly passed and sent to the governor and has been signed into the law. That specifically gave prosecutors and the Attorney General concurrent jurisdiction to enforce that law. So it's not a new idea, but the Missouri Supreme Court has said in a case from long, long ago that the Missouri Attorney General has no authority to go in to prosecute criminal cases. He or she is given that authority specifically by statute. There's an old law passed in the late 1930s, which is still in effect today, which says that if the local prosecutor prosecute liquor control violations, that the Attorney General is obligated to go ahead and prosecute that. So even in one area, it's not just sort of discretion, but if it's not being done locally, then the Attorney General should do that. I have some written testimony from the Senate bill. I didn't have time to do it for the House bill, and I'll be happy to email it to you for all the committee members. I would say, Representative Walker, in terms of your question about performing or inducing an abortion and go after, and I would just refer you to, and it's a very good question, I appreciate raising that. I refer you to section 188.080, which makes it a felony for, and I'll just read it for the relevant parts, any person who is not a physician who performs or induces or attempts to perform or induce an abortion on another. So what the law says is if someone gets pills on the internet and self-induces the abortion, they would not be covered here. But if someone were to, let's take the hypothetical there, if someone buys it on the internet and gives it to that person, they're not a physician, yes, that would be a current violation of the law, which under the law now, a local prosecutor could proceed on. This would allow the Attorney General to do that in the future. Regarding, I know Representative Mitten had some questions about qualified professional. I guess she's gone now, but that's fine. I'll answer that anyway. And just so you know, the Senate bill is different than the House bill. What the U.S. Supreme Court ruled in 1992 is that when it comes to informed consent for abortion, that it is permissible, and that was a case out of Pennsylvania, it was permissible for the state of Pennsylvania to say that only a physician or the referring physician can provide the informed consent information in certain areas. So particularly we're talking about medical related, her medical condition, an overview of her medical condition, any sort of complications. Only a physician or the referring physician. But it also allowed for other persons to provide other informed consent information. So it could be social workers or counselors, and that could be on where they could go for to seek an order of protection or to get child support or other types of, for lack of a better term, social information. The 8th Circuit Court of Appeals in a South Dakota case in 2008, Planned Parenthood versus Rounds, upheld a similar South Dakota law. So it's permissible to amend this to return us where we were from 1979 to 2010 here in Missouri, which is that only a physician could provide this information. What it did differently is that it did not amend qualified professional. It left that alone. But it said for purposes of determining if there be any complications for a particular woman based on a particular procedure, that informed consent information can only be provided by a physician. That's not what this says here, but that's what, and I think that's probably a better way to go because it brings it back to where the courts have upheld it. But all sorts of other information about alternatives to abortion, a social worker, a counselor, someone like that could provide that information. I'm sure you'll work that out, and the Senate will work that out if it ever goes anywhere. I don't think that section is in the bill that came out of committee yesterday. I think that was taken out of the committee substitute. And lastly, Madam Chair, if you don't mind, I'll just talk briefly about the other new section, which is in both bills, 574-200, which is committing the offense of interference with medical assistance. And that came out of as you recall, Madam Chair, the Senate had their Sanctity of Life Committee, and they issued a subpoena, and Planned Parenthood complied with that subpoena by providing certain information. And based on the Senate Sanctity of Life Committee's statement, they discovered that there was a protocol of the Planned Parenthood abortion clinic in St. Louis that they would request that sirens be turned off, that certain things be done differently for their patients than maybe that would occur in other medical facilities. In the Senate's report. And I think from that, the governor said, you know what, we need to deal with that in this special session. Added it as part of the call, and to say whatever the protocols are for, whatever facility, it should be the same if they're going to an abortion facility. Okay? And if they're not, then that would be a Class A misdemeanor. So there's a evidence based on that subpoena that Planned Parenthood was requesting a deviation from the protocol. And I'm happy to answer your questions, Madam Chair, but I'll stop right there.
All right. Thank you, Mr. Lee. I do have a question about that.
Sure.
Now, so, I think that I feel requesting that of a emergency responder. I just wonder, how could that agreement come about? I mean, aren't they there to respond? And was it ever looked to see if it was in any violation of ambulance district or their protocols that they have in place?
Right, it may have been that, the information they got was through the subpoena was on the Planned Parenthood.
Right, I understand.
But to be clear, this law would apply not just to the physician at that facility or the nurse, but to the emergency medical services personnel. So if they violate their own protocols, then they could be found guilty of a Class A misdemeanor. So we're talking about, I guess, pointing fingers at a number of people here. And again, this is consistent with the governor's call to protect the health and safety of women, and which I know is what you and the members of this committee are all in agreement on. How we get there may be on the goal at least.
All right, that just is very troubling to me is, when something rises to the level of the hemorrhaging and calling the ambulance, that every possible second we usually hear counts, and being able to enter through the doorways and bring that patient out and get them to a facility that would be able to contain, the emergency that's taking place would be of the utmost importance. So I understand the governor's call on this very clearly. All right. Thank you. Other questions for this witness? All right, seeing none, thank you. Be sure the legal witness form. Are there others in support of House Bill 3, House Bill 6? We have one more in support. Thank you.
Chair Committee, thank you. For the record, Gary Messner on behalf of the Missouri Family Network. I do not want to belabor anything and repeat things. So I'll just say I have watched over 33 years this legislature respond hundreds of times to what everybody thought was just plain common sense things. But plain common sense doesn't always work until the legislature says you have to abide by something that's plain common sense. These bills do that. They simply say, let's live by common sense. Let's protect the health and welfare of the women in our state. Thank you very much.
All right, thank you. Is there anyone else to testify in support? All right, seeing none, we'll go to opposition. Yes. I see you have your witness form. Thank you very much.
I do. Good morning. My name is Bert Newman. I'm a lawyer from St. Louis. I had an interest in this issue for many, many years. I was one of the two attorneys who attacked the first Missouri abortion statute in 1974 in federal court in St. Louis. In that case, Planned Parenthood versus Danforth, in which later Senator Danforth defended himself, went to the Supreme Court. The Supreme Court struck down the statute. And I've been interested in this issue ever since. I've testified. I have argued cases in our Supreme Court on constitutional issues. And this particular hearing is of interest to me for a couple of reasons. First of all, it seems a bit chaotic to me when I think about constitutional law and what's happening here. It's been admitted that all the members of this committee have taken an oath of office. And that oath of office requires, and I think the chair mentioned this, requires that you must follow the laws of the state and the federal laws, and those laws as handed down by the Supreme Court. Well, the settled law on the issue of abortion hasn't changed since Roe versus Wade. That is the law. And since then, we've had talk now about this case just last year, the Hellerstedt versus Women's Health. We've had discussion of that case, and that case followed Roe versus Wade. And then what happened, the next tier of this settled law that you're arguing about, is that Judge Sachs, a fine federal judge in Kansas City, he issued a preliminary injunction. And what did he base it on? He based it on Hellerstedt, and he based it on Roe versus Wade. This is all settled law. You have an obligation as members of this body to adhere to and follow the settled law. Now, what happens if you don't? I've heard discussion here today that it's likely there's going to be litigation over anything you pass here or anything that the Senate passes. It's almost been guaranteed, I guess. Well, what happens when there's litigation? in addition to the costs that we all know are being incurred day by day here, $20,000 a day, what happens when with the settled law that we have, that these statutes, whichever one of them is passed, what happens when the plaintiff who challenged that statute wins? I'll tell you exactly what happens under Section 1988 of 42 U.S. Code. They get their attorney's fees. We're talking about hundreds of thousands of dollars that will be paid to attorneys who successfully attack these provisions which do not adhere to settled law. Let's talk about Hellerstedt just for a moment. Hellerstedt, and I think there was some earlier mention here of a trap law. That's what the Supreme Court called the laws of Hellerstedt. A trap law is a burden. A trap law is a restriction. Any of these provisions in any of these bills are burdens. The right guaranteed under our Constitution, according to Roe versus Wade, is going to be unconstitutional under Hellerstedt, under Roe versus Wade, according to Judge Sachs in Kansas City. And I just sit here and I just wonder, when are we going to talk about the fact that there's a body of law that prevents you from doing what you're doing, and yet you barge ahead and you go ahead and you challenge that law. That's really what's been said here. We're going to challenge the law. It's the law of the land. It hasn't changed since 1973. Judge Sachs knows that. The Supreme Court of Hellerstedt knew that. Please understand, this is a total waste of time, a total waste of money. There will be hundreds of thousands of dollars paid to attorneys. I don't plan on attacking any bill that's passed, but there will be attorneys who will attack. And when they're successful, they will be paid hundreds of thousands of dollars. And the state doesn't have that money. And it's because I believe there is in this room a total, I'm not going to say ignorance, a total ignoring of what the settled law is in this country. And I don't think whatever you do under any of these bills is going to change the fact that those bills are going to be unconstitutional. They're going to be attacked. The state's going to lose, and you're going to pay attorneys for doing it. I've just been sitting here just wondering, what's going on here? There's a constitution that we all follow, and it's been interpreted by the Supreme Court. And the Hellerstedt case wasn't 20 years ago, it was last year. The Supreme Court upheld what it has been saying since 1973. So I ask you to consider some of these factors and some of these matters, because we can argue back and forth. We can argue about whether the AG has concurrent jurisdiction. We can argue about it. But the fact of the matter is, any restriction placed on a woman's right to an abortion is going to be struck down. So thank you for listening.
Thank you very much. Do we have questions for Ms. Woodness? Sure, let the attorney go first, I guess so. Representative Barnes?
To inquire,
You may.
any relation to the good lady from St. Louis?
Who is that?
Oh, I used to hear your name was Newman, and yes, that's why.
She's a good lady.
She is a good lady. I just trying to figure out if there was indeed a relation. You stated earlier, and you just stated again, that any law that restricts or burdens abortion is unconstitutional. But that's not the test, is it?
The test in Hellerstedt is whether the burden or the restriction that applies to the provider that provides, that applies to the provider makes it unconstitutional.
No, the test is whether it's an undue burden,
Exactly.
right? Or if it's a substantial obstacle. And that's been the law since Casey. But that's far different than the test you just posited. The test you just posited was any restriction or burden on abortion is unconstitutional, you said. But the Supreme Court has never said that. You agree with that the Supreme Court has never said that.
Okay. But this is the Supreme Court in Casey. Okay. I'm reading from Casey, Supreme Court. But we added a statute which, while furnishing a valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice, cannot be considered a principal means of serving legitimate ends. That's Casey in the Supreme Court that you just mentioned. That is the test. And these provisions do not meet that, in my opinion.
Okay. But some provisions, some regulations, what you agree that the state can regulate abortion providers.
Of course, there have been regulations that have passed muster. But I certainly don't agree with your earlier statement, as if it has validity, that the Hellerstedt case didn't mention that you can't control acts committed by citizens of the state. Why would it mention that? Why is it necessary for the Hellerstedt court to mention that states have a right to control them? Well, why is that necessary? I mean, it's as if the Hellerstedt court would say, well, don't go to a rodeo because they're dangerous. I don't understand the point you're trying to make. This is the standard.
Well, but here's what you just said, and here's what I've heard from some opponents. And what you just said, and you agreed you said it, was anything that restricts or burdens abortion is unconstitutional. But that's not the test. And you agree that's not the test. It's undue burden. It's substantial obstacle. And so the question is,
Excuse me, sir, the word undue burden is not in the language of Roe versus Wade.
it's in the language of Hellerstedt. It's in the language of Casey.
Maybe it is, but Roe versus Wade is the leading decision, it's the landmark decision without question on the issue of abortion. So
the language of Hellerstedt, you disagree with the language of Hellerstedt and Casey? Because that's not, you're positing that the test is this abortion on demand with no regulation. And that's not the law.
You have this way of inferring things that haven't been said.
You said anything that restricts or burdens abortion is unconstitutional. That statement is not true.
I just told you what the standard is. I stand behind it. And if you misunderstood what I was saying, I'm saying that in relationship to all the decisions that have been decided since Roe versus Wade. But going back to Roe versus Wade, a statute which, while furnishing a valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice, cannot be considered a permissible means of serving.
And that's a different test than what you just said in your first testimony. Well, it's a substantially different test.
It's a different test.
It's a substantial, words mean. The first sentence of Hellerstedt says, it cites Planned Parenthood versus Casey. There exists an undue burden on a woman's right to decide to have an abortion, and consequently a provision of law is constitutionally invalid if the purpose or effect is to place a substantial obstacle on the path. And then that first paragraph uses the word undue burden. So can we agree that the test is undue burden or substantial obstacle? Okay, thank you.
No, I can answer you. Let me answer you. What I was quoting from, you know what case I was quoting from? Hellerstedt, quoting the Supreme Court on what the real standard is.
We've just agreed that the standard is undue burden and substantial obstacle.
We agree.
Under Hellerstedt.
It makes any difference when it comes to the statute that is under the bills that are under consideration. They are going to fly in the face of Hellerstedt, fly in the face of Judge Sachs, and fly in the face of Roe versus Wade. I don't know why we keep having to argue over is it this standard, is it that standard? The law is settled, Representative Barnes. You know that as well as I do.
Do you believe there are any regulations that the state, that are currently in the ASC regs, that the state can apply to abortion facilities under Hellerstadt?
I'm not familiar with those.
So one of them says the facility shall establish a program for identifying and preventing infections and for maintaining a safe environment. That could survive Hellerstadt?
You want my
Yeah.
Something has to decide that for it. I don't decide, I don't make law.
Okay, well, if the case from the Western District threw out all of these regs, and that's one of those regs, is that a reg which you believe the state should apply to an abortion clinic? Do you think that an abortion clinic
Excuse
should?
me, just one moment. Mr. Newman, we need you to speak into the mic.
Can you see me?
I don't think the folks in the back can
Okay,
hear.
can you see me okay?
I can see you, and I appreciate this pink coordination between the two of you.
Well, it was,
And you're-
it was incidental. I want you to know. It
Was
wasn't
it?
planned.
Well, and I have
You
had a
have
pink
on
on
pink
too.
also, so
So we
that
have-
certainly was incidental.
There's something going on here, huh? Some sort of karma?
Yeah, I
Huh?
guess. I guess.
Okay. All right, gentlemen, you may
So do you believe?
return to your exchange.
Do you believe it's appropriate for the state to require abortion providers to maintain a facility that has infection controls of some sort?
Do I believe?
Yes,
Yeah, I do. but
that's appropriate.
what's
Do you
the
think it's,
difference? Is that one- what's the difference when I believe the settled law of this country will decide all of these issues, not what you think, Representative Barnes, not what I think, not what the chairwoman thinks, not what my
out the injunction order, I don't think makes distinctions from the opinion I'm reading, makes distinctions between these regs that you and I can agree are reasonable regulations versus the regs that don't. So, for example, we're going to disagree on some regs. You just agree.
I
You just.
told you I'm not familiar with the regulations.
Well, I just gave you a sample. Okay, let me ask another. A patient shall be fully reactive and her vital signs shall be stable before discharge from the facility. That's reasonable, right? You don't want to put a patient out on the street who isn't with it, right? I mean, that's something that should apply everywhere.
We can, if you like, Representative Barnes, continue to play this game. And I'm going to continue to give you the answer that is appropriate and correct. And that is, it is not for me to decide anything. It is for the Constitution to be upheld by this committee and for the precedents, the settled law in this country to determine the answer.
Well, how do we get the determination of the answer to the question if we don't have a state regulation that requires for infection controls in an abortion facility? Would there not be a requirement of infection controls in an abortion facility? No, but I think the opinion leaves things in doubt because it strikes down the ASC requirement.
You know, he's a brilliant jurist. He's a graduate of Harvard. I've tried cases at Harvard.
I have not said anything negative about.
Brilliant.
I have not said anything negative about Judge Sachs.
No.
I'm asking you particular questions about, do you believe that there should be any regulations on abortion facilities in the state of Missouri? You will not concede that we should have any regulation at all.
I didn't concede anything. I'm just telling you that something.
Do you believe that any person off the street should be allowed to perform an abortion?
That's such a ridiculous question. I'm not even going to.
It is so ridiculous, in fact, that you won't agree to the obvious. To the obvious that any sane person would say it's important for medical facilities to have controls on infection, right? But you won't concede to that. You don't think an abortion facility should be required to have infection controls? You don't think an abortion facility should be required not to put a woman out on the street when she's non-responsive? You don't think an abortion facility should have a plan to get patients to a hospital when 23 times in the last 3 or 4 years it has been required to send patients to a hospital?
I understand your grandstanding, and I'm gonna give you the same answer. My personal point of view is not important. I believe that a person walking down the street is not skilled and capable of performing an abortion. But the courts, the system that we operate under, requires that the answer to these questions, these constitutional questions, be undertaken by our courts.
And so how does a court get to answer that question? Yeah.
A court gets to answer it by the submission of briefs and argument of the parties, stating the law and asking that the court follow the settled law in a particular area.
So if the state, after an opinion, has some doubt as to whether there are any regulations in effect against an abortion facility, how do you get up there? How do you get a decision that determines whether we can have infectious control requirements?
Well, there has to be a judge.
Well, what if there's no statute? Do you think it's reasonable to have some regulations on abortion providers?
Of course, I do know that.
Thank you. That's all. Now maybe we can argue about what those particular regulations are. But 3 minutes ago you just said, well, that's your personal opinion. You can't say.
You're missing my whole point of what I said. Representative Barnes, the gist of what I have said to this committee is there is settled law that determines the answers to the questions. And I would rely on that settled law to determine whether any bill passed by this legislature, if challenged, is upheld by the court.
One more question, Madam Chair, and I will cede you. So Hellerstadt, before they even get into the body, notes that this provision amended Texas law that had previously required an abortion facility to maintain a written protocol, and then I quote directly from the Texas reg, for managing medical emergencies and the transfer of patients requiring further emergency care to a hospital. The Supreme Court in Hellerstadt did not strike down that regulation.
Then it's the law.
And we can have that reg, right?
Right, yeah.
Okay. But we don't have, in the wake of the decision from the Western District, state law.
Let's pass it.
Thank you for your support.
All right, other committee members with questions, Representative Ruth?
To inquire.
Hello.
Yes, ma'am.
So I'm not a lawyer.
Okay.
So could you please give me, you kept using the verbiage settled law. What exactly is your definition of a settled law?
That is an issue, for example, in this case. It's settled law that a woman has a right to an abortion, a constitutional right under which.
But what is a settled law?
A settled law is, in that particular case, is a law that has been decided upon by the courts and has remained in effect for a continuous period of time without any detraction from other cases of the Supreme Court.
I don't want to interrupt your train of thought, but I'm going to ask you again to speak into the microphone. Just scoot over there close to you, whatever you need to do.
Okay.
Because I want everyone to hear. So in that definition of a settled Fortunately, law, you're tall enough that I can see you.
Good.
Thank you for your height. Makes a huge difference.
You're very welcome.
You're welcome as well.
So in that definition of a settled law, you also said that we shouldn't be challenging that law. It's the law of the land. Every day, I mean, all of the time, the Supreme Court hears cases, correct?
Right.
On laws that are settled laws, the law of the land. And that people challenge the laws that are already in place that have been there for a long time.
Well, what I would disagree with you about is most often the court is deciding there is not settled law.
But in many times there is settled law, because by your definition, you said it's been law, it's been decided on by a court for a long time, it's been in place for a long time. Testimony earlier, you stated that we shouldn't be challenging those laws, that it's a law of the land. So I would, I guess, remind you that
there are many cases that have, under your definition of a settled law, that would have changed the course of our history had they not been challenged, had they not been changed. Brown versus the Board of Education, Roe versus Wade, even for what you're talking about. So I guess I would question that whole idea that you had, that we shouldn't be changing the law, we shouldn't be challenging it because it's settled law. That those laws were in place for a very, very, very long time by your definition, yet they were challenged, and especially, you know, in Brown versus Board of Education, that was a good challenge. It was needed, that law needed to be changed, and it was, and because people were brave enough to challenge the law, even though it was settled law, we had history there, and much of that was changed. So I think that we as legislators, it is our job to look at our statutes. It's our job to look at the laws, and sometimes things need to be changed, especially as time has gone on and history has gone on, and that's very important. So I would just challenge what you said, that we shouldn't be challenging laws and that things are settled law and they're the law of the land. Thank you very much.
Thank you.
Madam
Thank
Chair.
you for your comment, and if I could respond, please. I don't think that any of the bills here that are proposed have the validity and the legal basis to result in a reversal of any law on the books about abortion. That's my answer to your question.
Representative Stacy,
To inquire.
you may.
And just to expand, I just want to understand and make sure what I'm hearing you say today. Is it your testimony that settled law is a static entity, and that settled law has never changed in the history of our country? Is that your testimony today?
Not exactly. What I'm saying is,
Into the mic, please. I can't
I'm
hear you.
sorry. What I'm saying is, when you have a situation like this, where since 1973, the law has been decided by the Supreme Court. 16, the Supreme Court upheld that law in a decision that affects what you're doing. And a federal judge in Kansas City has already issued an injunction consistent with the Hellerstedt case and Roe versus Wade. Then, in that situation, I don't believe whatever statute might be passed here would be a successful avenue for changing the law.
So you're saying that settled law can change over time?
Oh, of
and
course.
that it's not a static thing, and that, in fact, it is the job of the legislature to look at regulations all the time and current law to make the best efforts for our citizens. You would agree with that?
I agree with it 100% with this caveat. In this particular situation, I think you're barking up the wrong tree.
Thank you.
All right, Representative Neely, Vice Chair,
Inquiry, please.
you may.
Thank you, sir. There's probably no one in this room, or the very few people in this room, who have been affected by government intrusion into the practice. More than me.
No reaction from those who are here witnessing the hearing. We'll have to clear the room if you all are going to respond in that way.
If I may. Thank you.
You may continue.
Thank you. When I started out in medicine more than 3 decades ago, I didn't have nearly as much government intrusion in my life in the way I conducted my office. And in the process of this, where I left a surgery today where we were going to do a shoulder replacement, I would hope that quality of standards are maintained during that procedure. And it seems to me that you and others would want the same health standards, conditions in all facilities that conduct healthcare. Would you agree with that?
I would, except if in order words of Representative Barnes, they constitute an undue burden.
There's an undue burden on the way in which, what?
The undue burden on, in the case of Hellerstedt, an undue burden on the provider, but in earlier cases, an undue burden on the woman seeking to exercise choice.
And that's, you think the standard of care is the same, or the standards that are orthopedic clinic, a hospital, other ambulatory settings, offices, that there ought to be a difference?
Well, I'm not a medical person. I don't know the answer to that question, but I think there should be safeguards.
There should be. Thank you. I appreciate it. Thank you. Thank you.
Representative Walker.
Thank you, Madam Chair. To briefly inquire.
Yes.
Thank you. I wanted to just go back really quickly to the discussion about settled law and what constitutes settled law and what doesn't. Could you just very briefly explain to us, the members of the committee and the folks here in the room, what the principle of stare decisis is?
Yes, stare decisis is the Latin for what we commonly refer to as precedent.
Mm-hmm.
And when a court issues a decision, and let's say in this case Roe versus Wade, the court issued a decision upholding a woman's right to an abortion under the Constitution. That becomes the precedent on the rest of the legal system throughout the country until such time that the Supreme Court changes it.
And can you talk about, Brown v. Board of Education was brought up. Could you talk a little bit about instances in which the court decides to overturn established legal precedent, just kind of what the source of, let's just, without getting into the specific details of Brown v. Board of Education, but just kind of what some of the contextual, if you will, sort of considerations
Brown
going
versus Board in 1896, the United States Supreme Court issued a decision by Plessy versus Ferguson. And Plessy versus Ferguson said that in relation to facilities for African Americans, blacks, and whites, separate but equal was the law of the land. That remained the law of the land. In fact, it resulted in the construction here in Jefferson City of a university for blacks, because the University of Missouri was separate but equal. In 1956, or was it 1954, the Supreme Court said, no, that's not the law of the land. We're going to change that, and we now have a principle of integration in the public schools. And that took roughly 60 years for the court to change that. The court doesn't change decisions very quickly. Because if they don't, in my opinion, it detracts from the integrity of their decisions.
Thank you for the inquiry. Thank you, Madam Chairman.
All right, further questions for this witness? All right, seeing none, be sure to leave a witness form.
Thank you, madam.
Thank you.
Hi. Thank you, Madam Chairwoman and members of the committee. My name is Anna Shabson. I'm an attorney in Missouri. I'm a professor at Washington University. I am a proud Missouri taxpayer, and I'm also a woman. So I do care about women's health in the state. I just want to build on what Mr. Newman, the previous witness, was saying, just to make a little bit more clear what the court said in Hellerstedt, concerned that we're paying the taxpayers' money, spending the taxpayers' money to do this exercise during a special session, and what will most likely be resultant litigation. The court in Hellerstedt tightened up the standard that the Supreme Court laid out in Casey. And I'm not sure if any of you served on juries, and some of you certainly are attorneys, that you know that there's a legal standard that's applied in every case. And it was a little confusing after Casey about what the courts would apply. And in Hellerstedt, and then applied by Judge Sachs, the court made it extremely clear what standard would be applied. And that was a standard of heightened scrutiny. That's what the undue burden, as you were talking about, the undue burden case. And it has a three-pronged test, which I don't need to necessarily go into now. But one of the things that the court was extremely clear about was that they were going to balance any sort of state regulation or state law that had any sort of freezing aspect on a woman's right to get an abortion under Roe by saying we're not just going to say, well, the state said it's a state interest. We're going to just rely on what they said. That's called rational basis review. And the court in Hellerstedt said, no, we're not doing that. We're actually going to apply something called heightened scrutiny, which you may remember from law school in footnote 4 of Caroline Products, said that we have to take a stronger look at this. And one of the things that they said is we are actually not going to just take the state's word for it, whether it came out of regulations in the executive branch or legislation in the legislative branch. They said we are going to look at evidence, and we are going to look at evidence that has reliable methodology associated with it to understand actually if this helps women's health. And we're going to look actually if this furthers a valid state interest or if it's just politics. And the court was very clear that they're just not going to take any more of this political wedge issue being played around with women's health. As I said before, I'm a woman. There are a lot of women in this room. We all want Missouri to take care of our health, but in ways that are actually helpful and beneficial, and not in ways that play politics with our time, with our taxpayer money. We actually need to follow the law. And when Mr. Newman was talking about settled law, it wasn't, although I can see how people could be concerned that that might sound like, well, we can never challenge law. What we're talking about is law that is new and fresh on the books to mimic with these current, what you've got in your current legislation, very similar regulations and restrictions to what went on in Hellerstedt is actually just going to be a huge waste of taxpayer money. And Mr. Newman is right, we will be assessed lawyers' fees to go down that same path. And as a taxpayer, I don't think that's worth it. As a woman, I don't think these regulations protect my health, and I don't think that the evidence-based research that the court would require as evidence would maintain that or uphold that as well. And I think that if you want to protect women's health, you should actually look at where there are needs to protect women's health, but it's not in this, it's not contained in what you have in this legislation. So that's all I would like to say, but I'm happy to take questions.
Are there questions for the witness? Representative Barnes?
Can you hear me okay?
Represent, I can organize my thoughts. Here, let me just.
You like the footnote 4, didn't you? I saw you did.
Yeah.
Yeah.
Well, first of all, TRAP is not part of the majority, the actual opinion in Hellerstedt, right? It's a concurring opinion.
I don't remember saying it was. What I'm talking about is the standard that they'll apply.
Okay.
And that's
and
clear.
strict, the majority nowhere says strict scrutiny.
Well, it's been defined that undue burden is not more, it's more than rational basis. And the court was very clear in saying they are going to review what a legislator or what a legislative body throws up as evidence, which lends itself to at least rational basis.
It's not strict scrutiny. I mean,
I
Thomas
didn't
is.
say strict, I said heightened.
Heightened
It is.
scrutiny. Those words don't appear anywhere, but to be fair, even the dissents point out that that the majority has enacted a test that is basically higher, but it's somewhat akin to strict scrutiny, but it hasn't elucidated the particular test.
We could argue about what standard, but it's clearly more than just believing whatever the state says.
Okay. You would agree, though, that there are certain regulations. The state can still regulate abortion facilities, right?
I think that Hellerstedt did not in any way limit the state from doing the work that the three branches of government do. I think what Hellerstedt said is when you do that work, you have to rely on evidence-based material. You actually have to be, preserving a woman's health or women's health, and you can't play political games. So I understand that, you want to do a cross-examination, but I'm not going to
do a cross-examination. I want to ask you about two particular things.
Well,
okay, the first is, you heard me ask the question about Texas's previous requirement for a written protocol for managing medical emergencies and transfer of patients requiring further emergency care to a hospital. That's something that survives a Hellerstedt review.
I
You agree with that?
I am not going to pretend to be an expert in Texas law. So,
Well, I'm not asking,
that could be
I'm
applied in
saying,
Missouri.
because the Supreme Court purposely, the majority opinion in Hellerstedt purposely says, look, they changed the law. It used to be this, and the way they changed it, they struck down. They didn't reach back and say, well, even the way it was, we're striking it, right?
I think that if you want to pass that in Missouri, it would be looking at evidence-based. I mean, I would follow exactly the path that Hellerstedt lays out. It's a clear path. I would look at what the evidence shows in Missouri. I would
Okay,
look
so
to
let's-
see if that's medically prudent. I would look to see if it actually furthers a woman's health. I
So
don't know.
let's look at the evidence in
I would-
Missouri.
well,
If there's evidence that there were 23 to the one facility in the state that were relating to hemorrhages, there were actually more than 23 visits, but there were 23 relating to hemorrhages. And I think it's a fair assumption to say at least a portion of those were related to abortion. And they were transferred apparently in an ambulance to a hospital. You think it's reasonable to have a plan for transfer to a hospital for a facility which has had 23 instances requiring transfers to a hospital?
Here's what I would say. I'm a lawyer, not a doctor, and I would need to see the evidence and have someone who knew more about it say, if this is the correct evidence, are we looking at it right way? Is this the right regulation to solve the problem? I can't possibly comment on that.
Do you think, how about a provision that says there shall be a system of corridors, passageways, and elevators adequate in size and arrangement to allow a patient on a stretcher to be moved to a street level exit?
I'm going to give you the exact same answer. Lawyer, not a doctor. I can't
So-
comment on that without seeing evidence and have it reviewed by someone who's an expert in the field, which I am not.
You don't think that's a reasonable safety requirement to if there's if an ambulance has arrived on the scene of a facility 23 times to transport a patient to a hospital, it's not reasonable for the state to say, look, these procedures that require hospitalization, you got to have a plan to get the patient on a stretcher to the ambulance taking them to the hospital?
Yeah, I mean, I think it's tricky to go down that path because ambulances come to homes that don't have hallways big enough for a stretcher. But
They
what I would
do,
say-
except in the home, they're not providing medical
Here's what I
procedures.
would
They're not
say.
doing medical
Here's what
procedures
I
in a
would say.
home, are they?
Former answer and say, I would have to have an expert understand that. I am not an expert. I'm a lawyer, not a doctor.
So where in particular in House Bill 6 or House Bill 3 is there a provision which you think runs afoul of Hellerstedt?
I don't think that the provisions provided in those two bills actually apply evidence-based. In fact, I heard this very,
Name a single,
well, I'm
name
going
a
to have to
single
get back to you on that. But what I will say is I would need to see the evidence. I would need to have it reviewed by people who are experts. I would need to see if it places an undue burden, and I would need to make sure it would pass some sort of heightened scrutiny test before I would waste the taxpayers' money.
if we state that the regs need to follow the FDA regs, does that pass your test?
You know what, again, well, the FDA doesn't follow Hellerstedt. I mean, are you talking about?
I'm talking now about Senate Bill 1, which states that for medical abortions,
I
we
would have to
relate
have
back to
Senate
the
Bill 1
FDA
because
regs.
I haven't, I'm not prepared to.
The
talk about Senate Bill
FDA
1.
makes its regs based on evidence, right?
You are asking me to comment on something for which I do not have the firm answer. I could look at that. But I can't, I mean, it would be me guessing. I don't know if there's one tiny place in the FDA where they do or don't. So you're going to have to ask.
Is
an
it
expert.
reasonable for us, for legislators, to assume that when the FDA puts regs on the dispensing of a drug, that it's done so based on evidence?
I would hope that you would consult the evidence in place, but I think this is a little overbroad and kind of off topic.
It's in Senate Bill 1, it's likely to get in this bill. So
But what
you don't have
your
it,
job
you
about
can't
using
point,
evidence?
you
I have no
can't
idea.
point to any particular page and line in the bill which you say violates
Are you
Hellerstedt.
talking about 1 or 3 or 6?
Any of them,
Any
any
bill
of
in
them,
this special
any
section?
page, any line.
I would have to go through and have a cursory look. Right now, what I would say is I would apply the Hellerstedt standard, which they laid out very clearly, and I would go through each one of those and see if it passes.
But the problem is you've testified that you have concerns about the constitutionality of the legislation, and you can't point to any particular provision in any of the bills which you say are
Well, I read
unconstitutional.
Judge Sachs' opinion, and I read Hellerstedt, and I don't think we're extremely far off. So I
So
think.
which particular provision? You're a lawyer, if you're going to challenge a statute, do you just say in general, or do you say this particular sentence is unconstitutional?
No,
Which
I totally
sentence?
understand what you're saying, and I appreciate what you're saying, and I don't have the bills in front of me, but I tell you what, if I can call your office later, we can have this conversation.
Sure.
But I don't have it right now.
Thank you, Madam Chair.
All right, other questions? Representative Ruth?
May. Hi, how are you?
Fine, how are you?
You stated earlier that you're a woman, and that however, with this, You did, you stated that, because we're talking about women's health care and you're a woman but you felt like this would do nothing to protect your health.
Well, I think that the provisions that mimic what this body has tried to do over the last bunch of years, I mean, when we talk about ambulatory surgicals, when we talk about women's need to, or doctors' need to have different, I'm not going to get into the exact details of it, but I think we've found time and again, and I think Judge Sachs found, and I think the court in Hellerstedt, where we mimic Texas law, has found that it's not in furtherance of that. It's more in furtherance of trying to limit a woman's right to get what she has the right to get if she needs it.
Well, do you think, though, then that there shouldn't be regulations to guarantee the safety and the health of a woman? Because
No, I totally do, but I think it's a waste of taxpayers' money and a waste of time.
it's a waste
not
of
to
taxpayers'
follow-
money not to guarantee
No,
the safety
exactly.
and health of a woman?
That would be weird, right? If that was what I said, but actually, I think that.
I mean, because that's what I'm
You're
hearing,
right.
saying
No.
this
So
does
I
nothing
think
to
the
protect.
sentence has another half to it, which is that we would have to follow what Hellerstedt says, and I think it's a waste of taxpayers' money to run us down a litigation road where Hellerstedt has already said this isn't the standard we're applying. I think it is appropriate to apply what Hellerstedt said, to look at the evidence before we do anything for women's health and make sure we have the right evidence. And then it is not a waste of taxpayers' money if that matches. If the evidence shows that it's meeting and solving a problem that we have in the state or that women have in the state, I totally agree. No, of course not willy-nilly.
But an ambulance being called, you don't
You know what?
think that that's a cause for concern? And I guess I would ask, what would you say to those women who walked into this facility feeling that they were, going to be safe, well taken care of, and yet they ended up having to leave there in an ambulance? What would you say to those women because of the hemorrhaging? And when we as a body are trying to make sure that they are safe and that they are well taken care of, and that we see this as a problem with 23 times ambulance being called, that there needs to be some regulations in place so that we are doing our due diligence in taking care of them. So I would ask you, what would you say to that woman who had to leave that facility in an ambulance because of hemorrhaging when she walked in there feeling like all of the safety measures would be in place, but yet they weren't?
My grandmother desperately wanted me to be a doctor, and it just didn't work. So I wish I had a more medical answer to you about what I could say. I know very little about the point of when a hemorrhage occurs or it doesn't occur.
But you're speaking,
or what
you
right,
came here,
right.
so
what
would
I
say that
would
you're
say is-
speaking from a woman's perspective.
But what
So
I-
as from a woman's perspective, what would you say to that fellow woman who had to leave that?
I would say, I
place?
hope that you got the absolute best medical care, and
But apparently they didn't.
well, I'm not sure that that's the
23
case
times,
because, no,
23 times.
well, it sounds to me like a transfer to the appropriate medical facility gave them everything they needed. I mean, where they could handle a hemorrhage.
But the fact that they had to be transferred and that it happened
Sounds
23
like-
times,
actually,
it sounds
to
like
me-
it wasn't safe and that there needs to be regulations.
To me,
in
it sounds
place.
like that's good medical care, because sometimes
That's your
one-
standard of good medical care, needing to be transported by an ambulance 23 different times?
Sometimes you're at one hospital and you go to another hospital. I think that's pretty standard. But again, I'm no doctor, so I would refer to Hellerstedt and say, what does the evidence meet out?
I think we probably have some standards, and I'm not an expert in this area by any means, but when it comes to our hospitals and everything else, we have standards that have to be followed and protocols that have to be followed. And I think we regulate a lot of those things. So I believe this goes along the same lines, that this should be regulated and that we need to be doing everything we can to take care of those women. Thank you.
Representative Cookson.
To inquire.
You may.
Thank you, Madam Chair. In the course of your testimony, I've heard you say, I think, I believe, in my opinion. So those are assumptions on my part that you're giving your opinion. Correct? Words like think,
I mean, that's
Yes,
what the
yes,
what
yes,
it
those-
means.
yeah,
I'm
yeah.
confused about what I don't know exactly. what
well,
you're
I mean,
referring,
what,
but yeah,
I'm asking you, so you're just giving your opinion here.
just like every other witness, yes.
Thank you.
Other questions for this witness? Representative Walker, I think that you were waiting there.
Thank you. To inquire?
You may.
You are saying that you're very familiar with the Hellerstadt case and Judge Sachs' preliminary.
Don't have it in front of me.
That's okay, that's okay. I want to read to you a couple of lines from House Bill 3, and then I want hopefully to have you answer the question that was posited by Representative Barnes. So it says here, the Department of Health and Senior Services may adopt separate rules, regulations, or standards to apply to ambulatory surgical centers and to apply to abortion facilities. Any rule, regulation, or standard that applies to an abortion facility shall, at a minimum, be equal to any physical requirement of an ambulatory surgical center. Could you apply the Hellerstadt opinion ruling to that specific provision and give your opinion as to whether or not you think that that would be in violation of?
So, right, so Hellerstadt would look to see if what the state was proposing, what in this case Missouri, if it passes, it would be proposing, was something that was a chilling effect on abortion, or if it was actually something that would benefit women's health. And if there was a problem with women's health in that provision, and they would look to evidence, and they would look to evidence that was actually from reliable methodology, and they would really, really look hard to see beyond any sort of political grandstanding, which can happen at any political level, if this was actually a problem and this was actually a solution. In my personal opinion, it seems overwrought.
And do you recall, or can you recall in Hellerstadt what the opinion was, looking at that evidence or the record, specifically about those physical requirements?
In Hellerstadt, they said that that was overbroad and that it had no bearing on what, and I do not have it in front of me, so I'm not quoting directly, right? But that it was actually just to chill a woman's ability to access a legal abortion. Thank you. Sure.
Representative Newman.
Yes, to inquire, Madam Chair. Good afternoon, and thank you for being here and giving us a very much needed legal constitutional outlook on what we're trying to do here. You talk a lot about evidence. And I have sat in this body, again, just going into my 9th year here, and we do a lot of hearings, or we do a lot of proposing of legislation, sometimes, like you mentioned, based on ideas, not always based on evidence. We can look at lots of things that this body has done in terms of advancing things that we sometimes call solutions to problems that don't exist. So again, we are a legislative body, it's one of the 3 branches. However, we pass laws, but that's really what Missouri has done quite a bit since I've been here. When you talk about evidence, I mean, again, you've heard from the committee, and there's things that are in both of these bills that are, and we keep hearing this run around the room, in terms of ambulance calls, in terms of numbers, in terms of even the word hemorrhaging. Tell me, how is there evidence? How would we get that evidence? Is there such a thing as HIPAA? Are medical records private? How much does the state actually have access to that? Would there be numerous reasons why an ambulance would be called, or do we have reports from other surgical centers in terms of, or like you mentioned, even hospital to hospital transfers? Do we have any of that other information to even, apply it to the fact that there were ambulance calls? And again, is this evidence, and where would it be coming from?
So, yeah, thank you. So I believe that again, the regulations on HIPAA, I don't think we give people's names, but I believe that all of that evidence would be accessible, and that on transfer hospital, I think, I'm guessing, right? But what I would say is there are a lot of people sitting behind me who are wearing white coats, and my guess is that they can answer this a lot better than I can. I also know that we have fine educational institutions in this state that actually do very fine evidence, which is what the court in Heller requested and required, which is evidence-based research. And I think that if we had questions, that if this body had questions, so they wanted to make sure that they enacted a law, or the executive branch enacted a regulation that was within the bounds of Heller and not wasting taxpayers' money just playing games, that they could either access that evidence, someone has researched it, or that they could commission that research so that we make the very best laws for Missouri.
So along that line, would there be numerous reasons why an ambulance would be called to one specific surgical center.
Sure, and to guess that, I'd be guessing as much as any other any other person in here is guessing without the records.
Because again, we as lawmakers on this committee do not have that evidence. We just have, the rhetoric running around the room that calls were made, there was this many calls, and that's it. I mean, we don't know whether it be patient calls, whether it be staff calls, and then how do they relate to other ambulatory surgical centers in terms of their ambulance calls?
It seems to me that Hellerstedt, which again is the roadmap for what we're doing here, really makes sure that the evidence we get is not conjecture, and it's not based in politics, and it's not based in guesses, or it's not based in passion, but it's based in facts.
So could it be logical that any evidence, if we were to ever get it, if this really is an issue that we need to be spending $20,000 a day on, how would that relate to others? Shouldn't we be comparing that? How do we know if that number is normal, not normal? Should we be comparing that to other like surgical centers that do surgical procedures that may have staff emergencies even? Shouldn't we have all of the evidence?
It seems to me that Hellerstedt requires the very best evidence looked at in the highest standards from reliable sources.
So we as lawmakers hopefully should be making.
If I were running this trial, that would be the best evidence I would put in.
But you would have that.
I would, yeah.
And then so as lawmakers, if we're going to just determine if these two bills are necessary to become law, shouldn't we have that, or should we just be saying something we might have heard somewhere?
I think that having that and actually working towards, if there's a problem with women's health, working towards reliable evidence-based solutions in the state to keep the women of Missouri safer, not just guessing or wondering. I think that requires a hard look at the evidence and to make sure that, you do in here what you're elected to do, which is represent the people of the state.
Ambulance calls from other surgical centers? Should we be spending time looking at, are those abnormal?
So I don't really know. Again, I'm just a lawyer. But it would seem like you should look at all the evidence out there.
Thank you.
Other questions, Representative Barnes?
Madam Chair, permission to distribute what was an exhibit in the lawsuit in the Western District of Missouri that has a record of the EMS calls to Planned Parenthood in St. Louis.
Oh, is that evidence?
It's hard evidence that was entered into the record in that case via affidavit from the director of EMS in St. Louis. And rather than just relying on news reports, this has, I would want it to have patient names, but in the left-hand column of said chart, and I have my LA going to get the affidavit attesting to its accuracy, it has why the ambulance was called to the facility and includes hemorrhages in each case. And Madam Chair, to the extent there's evidence or not evidence about other ambulatory surgical centers, I would point out that those ambulatory surgical centers are subject to the regulations of ambulatory surgical centers to make sure that patients for whom have what's listed here as hemorrhage, possibly dangerous, are able to be transported to the hospital in a safe and efficient manner. I'd also note that there's evidence in the record in that case regarding the safety, relative safety of surgical abortions from doctors, and there's a battle of the experts in that case, and I don't want to go through and rehash the battle of the experts there, but especially in regards to surgical abortions, there is evidence that regulations are reasonable and fair. And actually, there's a page 2, I think. The backside has some stuff, but none of them say hemorrhage. So thank you, Madam Chair.
Reducing that. I appreciate that. Kind of gives us another perspective on the testimony that's been given and the questions that have been asked. Are there any other questions for this witness? All right, Tina, be sure to leave a witness form. Thank you. All right, anyone else in opposition, please?
Good afternoon. My name is Dr. Marta Perez. I'm a resident.
I'm going to stop you just a minute. You have a jacket on with an emblem. Yes, are you here representing the institution?
I am here representing myself and the patients that I serve.
So you're only here testifying personally. Why did you feel there was a need to wear your white jacket?
Because as a symbol of the medical profession, I
So
feel
you're
it's important.
testifying for the medical profession?
I'm not testifying on behalf of the medical profession. I'm testifying on behalf of myself and the patients in Missouri that I serve.
Okay, so why did you feel the need to wear your white coat?
Would you prefer that I remove it?
Told you.
If you would prefer that I remove my white coat, I would be happy to do so.
Well, what impression did you want to give the committee and those in the audience by wearing it? You already identified yourself as a medical student, is that correct?
No, I'm a physician. I'm a resident physician.
You're a resident?
Correct.
Okay. So what impression did you want to give the committee?
That I'm a
Other than
resident
your-
physician in the state of Missouri who provides medical care to all of your constituents, my patients in Missouri.
Well, you certainly don't provide it to all of our constituents.
I offer it to all of your constituents, many of whom take advantage of it. It is a privilege and an honor to serve the people of Missouri.
And as it is
today, and it's a privilege to be here.
All right. I just want to be clear that you're not here testifying in behalf of the institution in which you are displaying an emblem, a signet.
I understand that. That was in my opening remarks, for which I only got through my name.
Well, that's because I wasn't ready for you to proceed. Do you understand that?
I understand.
Okay, good. Now, my son just graduated from residency, so I understand.
Congratulations.
Thank you very much. And what we'll do is I'll finish speaking and then, you can begin, okay? All right. Now, your residency is in?
Obstetrics and gynecology.
Okay. All right. And what year are you?
A fourth year resident.
Fourth, and how long is that residency?
4 years.
4 years, so you're in your final year. I'm glad to hear. I hope you stay in the state of Missouri. We need all the physicians that we can. We do. Actually, Missouri is the second leading state for exporting our physicians. Did you graduate from a medical school here in the state of Missouri, or did you come in?
I did not. I came here to train at an excellent institution, and I was brought here by the excellent offer of training provided, and it's a privilege to be here. So I did not go to school here.
Okay. Well, I hope you stay, because we need physicians in the state of Missouri.
I appreciate that.
Okay. All right. Go ahead with your introductions.
So my name is Dr. Marta Perez. I am a resident physician in St. Louis. I come here to represent myself as well as the many patients in Missouri that I serve. In my training as an OBGYN, I provide comprehensive health care. I provide preventative health services, pap smear, breast exams. I provide prenatal care, contraceptive care, menopause care, the diagnosis and treatment of cancers of gynecologic origin, like ovarian cancer, uterine cancer, cervical cancer, to provide abortion services for the constituents of Missouri. So I provide a large range of services, from simple outpatient visits to simple and safe outpatient procedures to delivery of babies in cesarean sections to large inpatient surgical procedures. Abortion is one small aspect of the care I provide, yet it is siloed in a completely separate manner that with unjust and medically unnecessary restrictions placed on it. It is very simple and medically safe, and yet we, in Missouri, as well as in other places in our country, continue to single it out and subject it to a undue level of scrutiny that is both medically unnecessary and fails to actually increase the health and wellness of women, which should be the focus here, is increasing the health and safety of women. As a physician who takes care of women, well-being and health of women is my utmost priority, and I'm in full support of any legislation by bodies that helps to make women's lives healthier, to help make their access to care easier, and enrich their lives. However, there are provisions that are being recommended today in House Bill 3 and House Bill 6 that are medically unnecessary, and they exceed what has been proven or evidence-based to increase women's health and wellness. It's been brought up multiple times, our recent Supreme Court case and the injunction against, in the state of Missouri specifically, again, as brought up. I'm a doctor, so I'm not a lawyer, so I don't want to get into those details, except that in my medical opinion and in my medical training, there are a number of medical procedures and medical treatments that I offer and I provide. They have varying levels of safety, but abortion in particular is singled out to a regulation that is undue. And extra regulations that don't improve the health and safety of women is a waste of taxpayers in Missouri's money and funds. And as was repeated before, as a doctor, I can assure you that these provisions in these laws today do not stand up to the evidence that it will increase the health and wellness of women in Missouri. Abortion truly has, in the medical field, an enviable safety record. It is one of the safest and most common medical procedures in our country. And I think that measures that are proposed to help the health and safety of women, like we're proposing here today, but don't actually increase the health and safety of abortion, because already it has an enviable safety record. Already it is under the same medical scrutiny for safety that a variety of medical procedures are under, is futile. And again, I love my patients. It's been a privilege to serve the women who are my patients in Missouri, and I would like to continue to without undue interference for one specific procedure that by its safety record is truly one of the safest and most common procedures in our country.
Questions from the committee? Representative Rude? To inquire, you may.
Thank you. Thank you for being here today. So I just want to go back to what you stated, that abortions are simple and medically safe, and that it's one of the safest practices. So I'm going to call your attention back to what we've been discussing. When I look at this list, where it says hemorrhage dangerous, hemorrhage dangerous, hemorrhage dangerous, hemorrhage possibly dangerous, on down the list, that does not sound like it's very safe to me.
Sure. Unfortunately, in the medical field, there are no medical procedures or treatments that lack all risk.
But you just said this is simple and medically safe.
Correct.
I don't see how it's medically safe when there are all of these cases of possibly dangerous hemorrhages.
Sure.
To me, that doesn't sound simple and it doesn't sound medically safe. And I know that anytime you have any type of medical procedure, there are possibilities and issues and dangers, but to make that statement as a physician, that bothers me, that you say that abortions are simple and medically safe. You also stated that, you were here representing and being able to treat constituents, citizens of Missouri. We all here too, as the chairwoman said earlier, we represent our constituents as well. And I'm here today representing my constituents who overwhelmingly in my district are very pro-life, and they also at the same time want to make sure that women's health are safe. And I think that if we can put a regulation in place that is going to increase that safety for women, I just don't see why there are so many people saying we don't need this regulation. And I can't believe as a woman that we have other women out there saying we don't need this regulation when we have evidence that there are issues and that we need to regulate this to make sure that this is safe. So that's my comment and my inquiry as to how you would defend the fact that from an abortion makes that abortion simple and medically safe.
Sure, yes, I'm eager to address this question. So all procedures have some risk and do have a percentage of complications. First trimester abortions have a 0.05% risk of complications. That is far, far smaller than other very common medical procedures. One such medical procedure that most people should obtain, that we all recommend everyone over 50 obtain, is a colonoscopy. The medical complications from a colonoscopy outweigh the medical complications from a first trimester abortion. The reason that I'm arguing with these proposed increasing the health and safety of women is we don't have any proof that what's being proposed today decreases when a expected possible medical complication that happens in a small minority, less than 1% of patients happens. So will these new laws prevent many less than 1% of women from having the complication of hemorrhage? And the answer to that, in my opinion, without seeing data, because there isn't some, because this is being proposed right now, is no. The fact that there were ambulance trips from Planned Parenthood to a hospital, in fact, proves that patients were getting the medical care that they need. That when they experience a complication, in which every medical procedure will have a complication, there is nothing, a procedure that has zero complication. That includes carrying a pregnancy. That includes a small in-office treatment procedure for pre-invasive cervical cancer. Everything will have a complication. Question is whether these regulations that only apply to abortion, that already excellent safety record even further, and I would call that into question, and I would, in my medical opinion, I believe that because there were ambulance visits means that appropriate care was taken of patients. I have had ambulance visits visit outpatient clinics in multiple areas of the hospital for complications or the medical campus. Outpatient clinics in the medical campus where a variety of outpatient procedures were being performed who had complications, and an ambulance is called. The correct care was taking care of the patient who was transferred to a higher level of care. There is not a medical procedure that's going to risk a 0% rate, and 25 ambulance calls in 5 years out of tens of thousands of visits is actually a pretty fantastic safety record. As Representative Newman stated, we don't have the data for other outpatient centers who perform small procedures. I'm not going to say ambulatory surgical centers because those are higher level of care procedures. Abortion, and especially first trimester abortion and medical abortion, are a level of care that does not warrant being performed in an ambulatory surgical center. So I think the better comparison between ambulance visits would be to routine physician offices where outpatient minor procedures are being performed.
What is the negative then, in your viewpoint, of regulating these facilities? Why is this a negative in just ensuring the safety, well-being? You think this is such a negative, other than the fact that you feel that it's a shot at abortion? Because obviously, as you believe in abortions, you perform abortions. So when we're trying to make a step to make this safer, how is that a negative to make this safer?
I can answer that in 2 ways. First, as a Missourian, a downside is the waste of taxpayer dollars for this special session.
Let me ask this real quick. I'm going to interrupt you there. We keep hearing a waste of taxpayer dollars. The 20,000 thrown out over and over again. When we're talking about the safety and welfare of a woman, do you put a price tag on that?
Absolutely.
You put a price tag? Would you put a price tag on the life of a baby, a life of a person, a life of a woman? So throwing $20,000 out there and saying it's a waste of taxpayer money. It's a waste of taxpayer money to ensure the health and safety of women, you're stating. It's a waste of taxpayer money to ensure the life of babies. Well, I keep hearing this over and over and over again because we've heard it. We've heard it several times to have this special session to spend $20,000
and taxpayer money, it's a waste. So what other way are we to take that? Then you're saying it's a waste of making sure women have the best health care, that they're safe, and we're protecting the lives of babies. I cannot personally put a price tag. I have spoken time and time again. I have done legislation for newborn screening, and you cannot put a price tag on that. So to keep throwing that out there as a soundbite for the media, for people, as it's $20,000, a waste of taxpayer money. It is not a waste of taxpayer money if we are providing for the safety and health care and protecting lives.
I agree that there is definitely no cost to protecting the health and safety of all people and women's lives. What I wish as a healthcare provider and physician is that those costs and those dollars go towards medical care that are evidence-based and proven to actually protect and make women's lives healthier. Things like affordable access to birth control, things like access to insurance and medical care, which many of my patients lack. Those things things like to lactation counselors and services, to social workers, those improve the life and wellness of women and children. Extra regulations, abortion, that are medically unnecessary because they are already in place and it's already extremely safe procedure, and or what I believe is unnecessary. So I'm sorry that it was misconstrued as I'm sorry that the way you interpreted my words was that I believe this is a waste of time to protect women's health. That's not what I meant. I wish the use of funds went to things that were already proven to increase the health and wellness of women.
So did you say that it was a waste of taxpayer money? Or a waste of taxpayer money? Did you say that? Yes. I'm asking the question, yes or no. Did you say it was a waste of taxpayer money?
I would have to refer back to what I said. I can try to.
Yes or no? Did you say that it was a waste of taxpayer? $20,000 was a waste of taxpayer money.
To have this hearing about this issue with these proposed bills, I believe is.
Can I defer a question to Representative Swan?
Yes.
Representative Swan, earlier in your testimony, you talked about some of the violations and issues at these. Can you just, since we're on this topic and we're talking about the safety, welfare, and we keep hearing how this is safe and there's really not a need for this regulation, can you state again some violations that were found?
Absolutely.
Upon inspections?
Representative would be happy to do so. They're not following infection control prevention protocol as established by CDC guidelines. Also, there were rusty surgical tables, rusty suction abortion machines, rusty IV stands, and the equipment that were there that was rusty. There was a lot of dust in the surgical suite itself. There were leftover single-use drugs that should be destroyed after they've been used on a single patient. There were expired medications that should have been destroyed because the expiration date was beyond that point. There were also expired postpartum balloons there to reduce hemorrhage after abortion. They were expired. Lack of appropriate drug handling policies, just to name a few. So if you would choose to have your gallbladder removed at a surgery center and escorted into a dusty surgical suite on a rusty table with medications administered to you that had been expired by an individual who was not following proper infection control protocol, that's what we're talking about.
Thank you. Thank you, Madam Chair.
All right, questions from the committee. Representative Barnes.
In court.
You may.
Thank you, Doctor. You'd agree with me that you're not that not every doctor in the world would come to the same conclusions, right?
Absolutely.
Okay, so there's a Dr. Andrew Steele. He's an OBGYN in St. Louis, and he submitted testimony in the case in the Western District of Missouri. And his testimony is quite different than yours. So, Dr. Steele references a study of 40,000 abortions that found that abortion-related hemorrhage occurred in 5.6% of cases, right? You'd say that's a known complication.
Not familiar with that particular medical literature.
You're ready for cross-examination. That's all, that's the safe answer always, is I'm not familiar with that. And I don't mean that to be coy, that's, I've heard that answer before. And that's how I advise my client to answer it. So, that same study, I will posit to you, said that it found 1.8% of those 40,000 abortions resulted in significant injury. There's another study from California. You said that the rate of complications in first trimester abortions was 0.5%.
I believe it was 0.5% or 0.05%.
Okay, well, there's,
for first trimester.
0.5 would be 1 in 200, 0.05 would be 1 in 2,000. There's a study from California on 55,000 abortions in California Medicaid that found a complication rate for first trimester abortions of 1.3%. And that's a pretty large sample size. So my way of going here is you would concede that there are other experts, there are other doctors, there are other studies that have come to different conclusions than the ones you stated here today.
Yeah, my comment on that would be that complication can be defined in multiple ways. Complication on one hand could be something that would be life-threatening, or complication could be cramping or having spotting afterwards. I'm not aware of that study. I would have to read it and see what they included when they wanted to capture the word complication.
Okay. There's another study you talked about. I think you mentioned colonoscopies. There's a study that showed it's a 0.02% complication rate for colonoscopies in 2011. And to be fair, there's a different study on colonoscopies that shows there's a 2% rate. My larger point is some of these things are disputed. I don't want to have a long battle of the experts, but these things are disputed. Now, let me ask you, you have stated that a hemorrhage, and you'd agree with me that a hemorrhage is a known complication of abortion.
Correct.
Surgical abortion.
Both medical, surgical abortion, and miscarriage, spontaneous miscarriage as well.
Okay, so you go outside the context of abortion. If you're performing a procedure and there's a known complication, does your standard of care require you to have some sort of contingency plan if that complication occurs?
Absolutely.
Absolutely. Okay. So some hemorrhages are dangerous, right?
Yeah.
Okay. In fact, there's at least 3 that are listed on this form from Planned Parenthood that say hemorrhage dangerous, and then there's 20 of them that say hemorrhage possibly dangerous, and one that says hemorrhage on the quiet, which is on the quiet response. Require the calling of an ambulance. Do you think it was good practice to have a contingency plan that if a known complication becomes dangerous and requires hospitalization, to in fact have a plan to get the patient to the hospital?
I do, and I think that list shows that there already is one.
It does. But you know what state law was in effect at the time that all of that occurred? It was the state law that required a physician to have admitting privileges at a hospital. And so I would argue to you that when you say this shows that they were considering safety, that the only reason it does so is because of existing state law that now is in question in the wake of this decision from the Western District of Missouri. And in the absence of a requirement either for admitting privileges or what I keep going back from the Hellerstedt case, a plan for transfer to a hospital, in this case, of a known complication that becomes dangerous, that's what ensures that this happens. And
but we already, as a medical professional, whether it be an abortion clinic or my regular outpatient clinic where a small outpatient procedure is being performed, it's the same result. You would still have something in place as a medical provider to recognize when a complication occurs and transfer a patient.
Then you should have no objection to a regulation which says you should have a plan in place. Because if you say that's the standard of care,
so
then,
you're asking me about
you're
one
saying that that's not
specific part of this bill, and I will say I think a plan in place for a transfer of a patient can be appropriate for any medical procedure outside of obstetrics and gynecology, medical procedures on men, on children, anything. Yes, I agree. A plan in place in any place where medicine is being practiced for transfer to a high level of care in the event that a complication happens is appropriate. But that's not the only aspect of the bill in question.
Okay, thank you for that. Thank you, Madam Chair.
Further questions for the committee? Representative Newman.
Yes, to inquire, Madam Chair.
You may.
Good afternoon, Doctor. Thank you for being here and giving us a much needed, medical viewpoint on these two bills. Going to go back real quickly. You were talking about, transfer of care to a higher level of care if there was any type of complication, and you mentioned, any procedure, any even if you said, anything even happening in patient and physician offices, and I'm not sure if you're familiar with this list that we just received here in mid-hearing, but there are numerous, again, very, very basic information in terms of what we have of why the ambulance was called. 4 of them were possible falls, 6 of them were faintings. We've got 1 allergic reaction. Again, when you have an ambulance that you are calling to transfer to another, like you said, higher level of care, aren't they for a variety of reasons?
Sure. In my medical experience, I have not been involved in a complication relating to an abortion and the need for transfer of care related to that. I have been involved in transfers of care with an ambulance from other outpatient services for a variety of other reasons. So I really can't speak to the numbers or what causes. I know in my medical experience, there have been a lot of different reasons why when I'm in a clinic, I have called an ambulance to transfer a patient. Some were related to a patient who had cardiac disease, even though she was in an OBGYN clinic and needed to go to the hospital. Some had an expected complication in their pregnancy and needed to be, emergently transferred to the hospital. So there's really, ambulances are called to outpatient clinics all the time when patients who, show up to their doctor visit are sicker than they expected to be or didn't realize how sick they are and the physician judges otherwise. I've also been involved where small outpatient procedures had a complication, and I'm not speaking about abortion, I'm speaking about other outpatient procedures had a complication and needed transfer. So there's a variety of reasons that patients can be in an outpatient facility and then have to go to a hospital. The important part is the patients get the care that they need instead of accumulating more risk by staying in the outpatient procedure. And I think a list of, like you had mentioned, any place that administers medical care in the city of St. Louis or the state of Missouri, getting all of their ambulance lists would be sort of superfluous and to me show that, doctors take action when action is needed.
So if you take action when action is needed, there obviously is a plan in place.
Correct.
Correct. And then can you also say, you can't probably go through the list in your head, but could you hemorrhage for a variety of reasons?
Absolutely.
And would they be, like you said, these variety of reasons, would they only apply to abortion, or could you hemorrhage for, again, numerous procedures?
Numerous procedures and even spontaneous occurrences, miscarriage, pregnancy, postpartum, even older women who have fibroids or abnormal periods can sometimes hemorrhage to a life-threatening extent, ectopic pregnancies, etc.
So again, this list that we see here, and again, I think, and this list goes from January 09 to April 6th of 2016. In terms of the actual hemorrhages here, I didn't count, but it looks like there's even less than 20 incidents where an ambulance was called in that 8 and a third year period. So many of these are sick, unknown, psychiatric, seizure, like I mentioned, fall, fainting, allergic reaction. There's only 3 or 4 on this list or 5 that actually says deals with pregnancy. Now this, again, these are 5 ambulance calls in over 8 years. And again, it doesn't say if it was a patient you could have been a staff member and had a reason that you needed in your pregnancy to go, like you said, to a higher level of care. So again, knowing that, you know, if we're going to talk about that this came specifically, which we know from Planned Parenthood, the address is right on our list. 8 1/3 years period of these ambulance calls. Again, and also knowing that this particular health clinic provides many more services, abortion procedures. I mean,
Correct.
I don't want to lead you, but you know,
Absolutely.
I think that's pretty well known that over 90% of the care that they do give are for a variety of health reasons for men and women.
Correct.
So again, just because it says hemorrhage, you could be hemorrhaging from a lot of other types of, not just procedures, but from anything, can you?
Sure, I think what you're trying to ask to relating to just hemorrhage call from Planned Parenthood, could a patient who wanted medical care for her heavy periods get to the clinic and be lightheaded, and the providers there think she might need a blood transfusion, we should call an ambulance to get her safely to the hospital? Sure, there's a variety of, you know, just like in our outpatient clinics where we don't provide abortion, Planned Parenthood provides abortion, but provides comprehensive health care. So pap smears, screening exams, et cetera. There are a variety of patients and people who work there who could faint or have a seizure disorder, and patients could present there for problems other than the termination of a pregnancy.
So is there a medical definition for hemorrhage that you use or that you could, you know?
A definition I would use, it certainly depends on the individual patient and the individual situation.
So but that, like you said, a level of loss of blood may not pertain to an abortion procedure on this list because we don't have that information.
Yeah, so that, I don't have the
Hemorrhaging doesn't.
It doesn't specify that the hemorrhage was due to an elective abortion from that facility. It could be another gynecologic issue that a woman's having.
So if this is what we're basing, I mean, this, I just read you basically what I have in front of me that I just received mid-hearing. And this is what we're basing, changing a statute. You are putting into a bill for the governor to sign, again, back to that, you know, how much more this is going to cost us. Would you really consider this medical evidence in terms of this is the reason, because there already is a complication plan, as we would assume most medical entities in the state have, because most of them have complications that come up, like you said, from doctors' offices to even, like you mentioned, your medical campus, where you've got to be transferred to a high level of care. So there already is a procedure, whether it be state regulated, whether it be just a hospital procedure that you do on your own. So again, knowing what we don't know, knowing what we do know, is there any reason?
In my opinion, I feel as a physician in both my practice as an abortion provider, when I have the privilege to take care of women at Planned Parenthood in my residency, and in my residency when I take care of patients in multiple outpatient places, when I have been involved in the care of patients at any of those places and their level of care exceeds the level of care provided in an outpatient clinic, appropriate measures are taken to make sure the patient has transferred to the hospital or a facility with a higher level of care.
And since you are in the medical profession and you are dealing with your other medical professionals, aren't yours there first versus legislators on a legislative hearing? Wouldn't you be alarmed first that the level of care that's already in place is not adequate? Wouldn't you be the first ones to know that something needed to be altered?
Correct, and as I kind of stated, I think a record of the fact that ambulances are called to any outpatient place providing medical services is proof that when patients need it, their providers are making the right call to get them a higher level of care.
So we wouldn't know unless...
I would never want to discourage any medical facility from calling an ambulance because they believe that they'll be under scrutiny for transferring patients to a higher level of care.
But you want them to do it, don't you? I mean, don't you want to be able to have to follow what you need to do in terms of your own medical ethics, in terms of what you need to do next.
Yes.
Professionally. So again, not having any information on any other type of ambulance calls from any other medical entity, whether it be a private physician's office
Yeah, or our private OBGYN clinic.
to anybody. So we have nothing to compare this to. Is this normal? Is this whatever? But you see no problem why we, as legislators, need to adjust a statute to give you what you don't have.
It would be my, I could only conjecture about what it would be from other outpatient facilities that provide outpatient procedures, but I would think that it would be similar.
So in your
Targeting
medical,
specifically an abortion facility would be unfounded.
so in your medical profession, in your medical opinion, because that's what you are, this is not necessary, and is it punitive?
I'm not sure if it's punitive. I don't know that I can answer that. But I do believe it is targeted specifically at abortion providers simply because of the way certain people feel about whether the morality surrounding abortion, which other people don't share in those opinions.
So last question, do you feel like you need, as an abortion provider, additional regulation to provide?
I believe that the health and
care for women.
safety regulations that are in place that govern my medical care of patients, whether that is taking care of a pre-invasive cervical cancer lesion by a small outpatient procedure, taking care of, a small medical procedure for heavy vaginal bleeding or heavy periods, and abortions included in all of those things. Already I keep patient safety as my highest priority, and I think that it will truly increase the health and wellness of patients, and I don't believe that these restrictions do that.
Thank you very much.
I think, we focused on this word hemorrhage and call for an hemorrhage and et cetera, and certainly calling an ambulance when necessary is the appropriate thing to do. So in that call, the ambulances have been directed to quiet their sirens and turn off their lights and come around to a specific entrance. Why do you think that is?
I really can't speak to that. I've never been involved in a situation like that.
Okay.
In my professional life as a physician, so far I've never been involved in an experience like that, so I can't speak to that.
Yeah, okay. So in your training, in medical school or in your residency, is that where you learn to do abortions?
Correct.
Okay, is that an option for students that are pursuing the gynecology, OB/GYN gynecology route, or is it a requirement?
Can you repeat the question? Is it an option or a requirement is the question? Sorry. It's an option.
It's an option, okay. That's great. I know how you feel about this, that you feel that these are additional regulations. If you went into a situation as Representative Swan has described, where you were to perform an abortion and the condition of the room, the instruments, the medication, and et cetera, described, what would be your course of action?
I've never been in that experience before. I certainly expect the highest level of safety and cleanliness for my patients.
Yeah. Mm-hmm. So what would you turn to if you came across that? Your expectation is there, your patient is there. Do.
I would do whatever was necessary to ensure the health and wellness of my patients.
Yeah, and so you would no doubt look to some sort of a standard, some sort of a regulation, some sort of enforcement to make sure that in the future you do not walk into that situation.
Sure, and I share in that with any of the variety of medical conditions that I treat.
Right, right. I think, yeah, everyone would want that. Okay, want the best outcome. All right, are there further questions? I think Representative Cookson was
Okay, so I can assume that all of your testimony about these issues is about what you do for, at least partially, for profit, for your practice, in which you're paid for. And that basically, let me finish, and that basically less restrictive you are, the better it would be for a business person to profit from it.
That is absolutely wrong. I am not reimbursed or nor do I take any profit from any abortion procedure, neither do I take any profit from delivery of infants. I actually don't get, as a resident physician, I'm paid by Barnes Jewish Hospital. I don't get any reimbursement for any specific procedure or medical treatment that I provide.
But you do get for abortions. You do,
No.
You do not get any,
No, I don't.
will you in the future?
I really can't say. I'm not sure. I have not applied for jobs yet.
But it's possible you could.
Yes, it's possible. Doctors are paid for providing services.
All right.
It's possible I could end up
Thank
in
you,
one of
thank
those
you,
jobs.
thank you.
I don't know what job I will have yet.
Required briefly. First, Madam Chair, I have passed around, I think it's making its way up to you. I talked about it briefly. I just wanted the rest of the committee to have it, which is the declaration of Andrew Steele from the case in the Western District of Missouri that talks about the complication rates of abortion. It's the purpose of why I'm inquiring again, but I want to make you aware of what has been passed around. Representative Newman asked you about this chart, but first you said this was the only evidence. I passed this around and showed that there's a lot more evidence than one page of paper. But I want to ask you about this page of paper. Planned Parenthood facility in St. Louis performs thousands of abortions a year, right?
I believe so.
And hemorrhage is a known complication of abortion, correct?
Correct.
Which do you think is more likely? Representative Newman posited that none of these are related to an abortion procedure. That's position number one. Or position number two, that some of them are related to an abortion procedure. Which do you think is more likely true?
Let me rephrase your question back to you. So your question is, do I, in my medical opinion, think it's likely that hemorrhage is related to an abortion?
Given the fact that this is a facility that performs thousands of abortions a year, that at least one of these is abortion related?
Yes.
Okay. And you know that Planned Parenthood has not submitted any complication report to the state of Missouri that they're required to do.
Yeah, I had briefly been in conversations about the complication reporting, and I was under the understanding that the way the forms were from the Health and Human Services, that there was some adjustment, not specific room for it, and that's been adjusted. I can't speak to that. I'm not a legislator. I'm not in the Department of Health and Human Services, so I can't really comment on reporting for complications.
Don't worry, nothing you say can be held against the
Well, I'm just trying to
facility.
say, your question was, do I?
It seems likely that at least some of these would be related to abortion in a facility that provides
Sure,
thousands
and I
of
think that
abortions a
20
year.
out of tens of thousands over 6 years is actually a pretty great safety record that would be enviable for other medical procedures.
But here's the problem. If not a single one of these were ever reported to the Department of Health and Senior Services, we have no basis to believe a claim of safety by that facility, because if they're not reporting, you agree when a patient goes to the hospital for hemorrhage relating to an abortion, that's a complication, right?
Yeah.
If you've got to refer on somewhere else, that's a complication.
Understanding the question. Is it about the reporting of complications?
Well, it's the fact that you agree that this is a complication. That if any of these are related to abortion, that these are complications.
Yes, and every
Okay.
medical procedure has complications.
I know, I hear that, I've heard that defense a lot, and medical malpractice case, that's the first line of defense, is to say, well, it's a known complication, therefore we can't be responsible for anything bad that happens. I don't want to get on the medical malpractice soapbox. I'll go back to, my point is, when you talk about an exemplary safety record, there's no evidence that there's an exemplary safety record, because we have evidence that there are complications that have not been reported. Thank you, Madam Chair. Thank
You're
you
very welcome.
for your patience.
All right, are there other questions for this witness? Representative Walker.
To inquire?
You may.
Thank you. Thank you so much for your testimony and the work that you do and providing your medical opinion here today. Many of us are not doctors. I am just a lawyer like Representative Barnes, and so I do want to talk a little bit more about just kind of some of the evidence that you come across, just kind of what the actual medical research and the medical literature says about abortion complications specifically. So has been distributed here in this committee. We've got this list of ER calls or ambulance calls that have occurred over the past 8 years or so. Over the past 8 years or so. And as Representative Barnes has mentioned, Planned Parenthood performs thousands of abortions each year. I tried to do the math. I guess 58 or so ER calls or visits over the course of 8 years. Is that a number that is something that you would consider a high prevalence of complications, just in your experience as a medical professional?
So I can't speak to the evidence about that because we don't record them from other outpatient where outpatient procedures are being performed.
Okay, so that's one question. And then secondly, so there were 58 calls, but 23 of those were related. That's what keeps coming up here. Out of the 58 calls that were made and 23 of them being hemorrhage related, just again, what's your opinion on just whether or not that is a
Sure. So my opinion is 23 divided by tens of thousands over multiple years would be a very small percentage, which I think is consistent with existing medical literature. Very safe, has a far less than 1% complication rate.
Sure, great, thank you. And just in terms of the actual statute itself and the complication plan that for medical abortions, not surgical abortions, but medical abortions, can you again just clarify, as a licensed physician or a resident physician, you are required to have a complication plan put in place, or some sort of complication plan put in place already. Is there anything that this proposed legislation would add to what you are already required to do and bound to do as a resident, as a medical professional?
I don't think so.
And final question. There's a lot of different provisions and standards that relate to ambulatory surgical centers and the attempt to apply them to abortion facilities. In your medical opinion, do standards related to the width of a hallway improve the safety or health of a patient?
In my medical opinion,
At an abortion facility.
Right, in my medical opinion, no. Similar to what was brought up earlier in the hearing, ambulances make calls to many different places, including people's homes where they, take people out of their homes, other physicians' offices that don't abide by ambulatory surgical center restrictions, and abortion has a safety record that's similar to other outpatient procedures.
In your medical opinion, do standards related to the paint on the wall, the paint color or the number or the amount of lights that should happen or occur in an abortion facility,
improve the patient's safety?
No.
Opinion, do standards requiring organ or tissues removed at the time of abortion being submitted to a pathologist and the resultant organ or tissue report being made a part of the patient permanent record, does that improve a patient's health or safety?
No, examination by a pathologist does not increase a woman's health and safety during having an abortion.
Okay, so going back to the question about whether or not this is a waste of taxpayer dollars, in your opinion, is there anything in this proposed bill, either HB 3 or HB 6, in your medical opinion, that would somehow improve patients' safety outside of what the current, I guess, very, very low levels of the complication? Is there anything in any of these proposed bills that would
make it safer for women and improve their health?
Yes.
No.
Thank you. Thank you, Madam Chair.
Other questions for this witness? Seeing none? Thank you very much for your testimony. Leave your witness form, please.
Good afternoon. My name is Rabbi Jonah Zinn. I am a rabbi at Congregation Sharon McLean Creek Corps, which is a Reform congregation of 1,700 families, making us the largest in Missouri. And I have some comments that I'd like to share. If who's the chair? So Jewish tradition places the greatest value on the preservation of life. In fact, a woman's life is paramount according to Jewish tradition. Women are commanded century Jewish law code, really the foundation of Jewish jurisprudence. The Mishnah explains that a woman is actually forbidden to continue a pregnancy if it threatens her own life, that she is commanded to have a medical procedure necessary to end that pregnancy in order to preserve her life, because Jewish tradition views the life of a woman as being paramount over that of potential life. Legislation that is being proposed and discussed this morning, it serves to privilege the religious beliefs of those who oppose abortion over the religious beliefs of those who and therefore the move to limit women's access really flies in the face of what we as Jews understand to be our moral and religious responsibilities. I'm happy to take questions.
Thank you for coming. I'm just maybe a little confused. Okay, so did you say that in your faith, if a woman's life is in danger, then abortion is the right thing to do, the direction of your faith?
What I said was that in Jewish tradition understands that a woman's health needs to take precedent over the potential life of a fetus. And therefore, Jewish tradition mandates that a woman have this medical procedure should her life and health be placed at risk.
Okay, so that's what I thought you said. So her health is a factor in whether or not she should have an abortion? That's what I hear you saying.
Yes, if her health is placed at risk.
And her health is placed at risk.
Then having the abortion is the appropriate recourse.
Okay. So how do you feel that this legislation is, if there's a medical diagnosis for the woman, that it is necessary for an abortion to take place to lose the child in order to preserve her health, where would this legislation affect that?
I think this legislation limits the access of women to abortion by putting in place unnecessary restrictions that prevent women in certain geographic areas. And I think we've seen across the country, when there have been attempts to place similar legislation in place, that the ability of women to access these necessary reproductive services are reduced, and as a result, it infringes upon their religious commitment to have these kind of procedures.
So are you expanding your testimony to say that elective abortions for any reason, you're objecting to that?
No, I'm not. What I'm saying very clearly is that a woman's health, and therefore, but women need to have access to these necessary reproductive health services, and that the legislation for the committee is limiting women's access to these services by putting in place medically unnecessary restrictions that prevent women from accessing the health care that they need and the Jewish tradition teaches them that they should seek. Would you like me to state it again?
Yeah. No, you don't need to say it again, but if a woman's life is in jeopardy, in the state of Missouri, there's an abortion in line for her.
I think it's important to understand that it's an issue of women's life and health, right? So there are situations in which, by not having access in her own community to these, as we've stated, there's a single abortion provider in the state, and a woman's inability to access those services in other parts of the state lead her to not have access to those for a range of different factors. And as someone who views access to that as something that is necessary based on my religious commitments, I find the inability of women to access those as an affront to my religious tradition.
Well, in that case that you stated, the hospitals across the state of Missouri, there are hospitals that do abortions. Abortions are not only done in a Planned Parenthood setting.
I think that it's important to understand that we're talking about a range of different health situations that would lead a woman to choose to have an abortion.
So health, but not life.
No, both. Life and health is what I've stated all along. Right, and Jewish tradition understands that life and health, if we want to focus on that aspect of my testimony, is defined in many different ways. It can be emotional health.
I see. Right? Okay, I understand. All right, thank you. You've answered my question. Are there other questions for the witness? Representative Newman.
Yes, to inquire, Madam Chair, very briefly.
You may.
Thank you, Rabbi, for making the drive here and sitting through this. It's very important that we hear other religious viewpoints. Can you expound a little bit on, you mentioned that you were a Reformed Jew and you were a rabbi of the largest, you said, Reformed Jewish congregation in the St. Louis area. In terms of Reformed Judaism is, I don't want to put words in your mouth, but are the majority of Jews, not just in the state of Missouri, but in the United States, are they Reformed and do they have these same beliefs?
Yeah, the Reformed Jewish movement is the largest Jewish denomination in America. It counts 1.5 million members, Reformed Jews, and the Reformed Jewish movement has been on record since the 70s in favor of access to abortion. The Central Conference of American Rabbis, which is the Rabbinic Association of Reformed Judaism that counts over 2,000 members, has gone on record several times over the course of the past decades in favor of a woman's access to make her own healthcare decisions. And in fact, in 2008, the Central Conference of American Rabbis passed a resolution about this very issue, state restrictions on access to reproductive health. I have part of it in front of me. It reads in part that these laws and programs intrude upon a woman's reproductive health rights and infringe upon our country's guarantee of religious freedom and personal liberty. And it's really, the Reform movement is committed to this issue and believes, I think, very strongly as a collective body that this is something for us to raise, and it's important for us to provide a religious perspective in this conversation.
Thank you. And then, as we, hear quite a bit, I mean, like you mentioned, I don't know what your number was. Did you have a number for Reformed Jews in the state of Missouri? I mean,
I don't know the state of Missouri, but in North America, it's 1.5 million.
Okay, and so from that, we can see that there are other faith groups that are much larger, and there are other faith groups, sometimes being larger, have a larger voice, within legislatures, sometimes, which, again, we should not be basing, our legislative intent on one religion over another. So, but you also pointed out that any of these restrictions, and not just restrictions that have just been struck down, restrictions that we have seen in place for a number of years that have limited the number of clinics that, can provide just healthcare access in the state, the number of clinics, like you mentioned, for low-income women, regardless of faith. And that is something that you feel your faith background and your organizations of rabbis feel very strongly that healthcare should be available for everyone?
Yeah, absolutely. And I think that part of what our faith guides our lives. We don't want to impose our faith on others. And we also want to respect the decisions of all people. And recognizing that we are a religious minority, Jews make up a relatively small percentage of our that while this is our belief based in our tradition, we're not the only ones that feel this way and that have the right to have access to these essential medical services.
So healthcare access should be accessible to all.
I mean, healthcare. Judaism says that one of the most important things is the preservation of life, and this particular issue is consistent with that, given that Judaism understands that a woman's life and health take precedence over the potential life of a fetus, and that's how the tradition has spoken about it for 2,000 years.
Thank you very much. We really appreciate your viewpoint.
Representative Kelly,
To inquire, Madam Chair.
you may.
If I get my mic to work, thank you for being here today. I just wanted to clarify something you said, that Judaism does teach that one of the most important things is the preservation of life, correct?
I think it's important for us to understand the definition that Judaism provides for life. It understands that that a fetus does not understand a fetus's life; it understands it as potential life. Whereas the woman it understands as a living human being, and that there's a moment during the childbirth when a fetus transitions from a fetus of a state of potential life to being a human being, and that's how the tradition has explained it for, as I said, since the time of the Mishnah.
Okay, I respect your constitutional ability to, and both of us have a constitutional ability to think differently on these issues. However, just wanted to affirm what you said, that is a key component, the preservation of life. And I am curious, we're in this legislation, that we aren't seeking to preserve and protect the mother, because I have yet to find that.
Yeah, so I think one of the roles of being a person of faith and of a clergy person is to speak truth. And I think that for me, the truth in this legislation is that one of the unfortunate outcomes is that, or perhaps one of the intended outcomes, I don't know, but certainly one of the outcomes of this legislation is to limit a woman's access to abortion, which our tradition views as being a necessary healthcare option at times, and by limiting women's access to that, jeopardizes their health. And that is, as we said, where we share a common sense of religious obligation that a woman's health is really paramount.
Thank you for your time.
Other questions? No? All right. You have one, Representative Casey?
To inquire.
You may.
I'm just still trying to understand here. You indicated that you would support an abortion as it relates to, in your religious view, as it relates to the woman's ultimate health. In other words, if her health is in danger. Is that correct?
I'm not a physician, so I don't want to use the term danger, but I certainly, our religious tradition understands that a woman's health is primary. So, I think danger is an interesting question, but that's really a determination for a woman to make along with her doctor.
Okay, so, so it could be, we could define that in a number of ways, I suppose, and you would say then the tradition then would define the women's access to an abortion being anything they would choose.
I think the tradition is not univocal on what constitutes the appropriate risk to a woman's health, but certainly contemporary Jewish legal scholarship would indicate things such as both physical health, issues of physical health, and also issues of mental and emotional health as being causes that could make this a religiously necessary and permissible procedure.
You would agree that, certainly for physical issues, anytime that an abortion is necessary for the safety and well-being of the mother, that's available at any
I'm actually not sure that it is. I think that what we see with regulations like this is that one of the consequences of this type of legislation is that it leads certain groups of women to not have the access they had before, and as a result, limits their ability in a functional way. That may not be the intent of the legislation, but that's the outcome.
Well, okay, I'm from Kansas City, and Truman Hospital is a pretty big place, and they've got a lot of doctors, and a lot of doctors that provide women's services, and actually they do a lot of deliveries there, but if the medical, if it was necessary for the life of the mother to provide an abortion or a pregnancy, and because of some imminent danger that the woman's life was getting ready to end as a result of that, something that could be provided at some place like a major hospital like Truman?
Well, as I said, imminent danger is one particular medical standard. Judaism understands the obligation of a woman to pursue this particular type of medical health, of reproductive health differently, and understands that it's not only about imminent danger, but it's also about other conditions that would impede her health. And I think that standard that it sounds like the standard that Truman Hospital would use might be different than the standard that Judaism would advocate.
I'm certainly not a medical professional. I can't speak to their medical decision process, but I would suspect that they would be able to do that if the mother health was in imminent danger. But thank you.
Representative Cookson? To inquire. Thank you. Okay, Rabbi. Well, did I do anything wrong?
I took no offense.
No, I'm sorry. I'm sorry if I did. No.
Maybe it was the playing with the microphone. I don't know.
Okay. Well, you have stated your beliefs. Now, religious beliefs, from my knowledge, are always based upon some documented book or something along those lines, like Christianity is on the New Testament and the Quran is for Islam. The Jewish, would that be the Old Testament?
So Judaism has had a development of literature rooted in what we would call the Torah, or the Hebrew Bible, which you probably would call the Old Testament. But that has been developed over the course of the past probably 2,500 years through a series of literary developments, and the text that I referenced is a 2nd century text known as the Mishnah. So it's contemporaneous with the New Testament. It may even be older, which is only to say that Judaism has had this view for a very long time, and that is the origin of the position that I present today.
Okay. Could you give me?
Oholot. It's Oholot, chapter 7, Mishnah 6. You can Google it. But I'm happy to.
Would you provide that to me?
I'd be happy to. Oholot 7:6.
Thank you. Thank you. I would be, just for my own knowledge, would like to.
Well, part of being a rabbi is being a teacher, so I'm happy to share with you that information.
Sure. Well, I appreciate that. Thank you. since you're speaking, what is it that you said a while ago? Truth. So I can see that written down. Thank you.
Representative Ruth, proceed, please.
Thank you. Thank you so much for being here today and for sharing your views with us. I just have one question. In your statement that protecting the woman's health, safety of the woman is important to you. Am I correct? Is that kind of what you said? Could you restate that again?
I'm happy to restate it.
Sure.
Judaism believes that the life and health of a woman are paramount and take precedent over the potential life of a fetus.
Okay, thank you. So keeping along that line of that statement, then we've heard what Representative Swan said about conditions that were found. To me, I think that would be a matter of concern. Would you agree then for a woman to be treated in a place that has those types of rusty instruments, out of date medicines, basically not, it sounds like it's not sanitary. To me, that sounds like it would potentially harm the safety and well-being of the woman's health.
You know, I'm not a physician, I'm a rabbi, so I'm happy to speak to the Jewish textual tradition, but without more information about that, it's hard to really know, you know, what those statistics and that data is about.
I'm not a medical professional either, but I, as a woman, that gives me concern to think that women would face having those conditions in a very sensitive medical situation, such as an abortion, and that would possibly harm then that woman's health and safety. And so that would lead us to do basically what we're doing with asking for regulations of that, so that those conditions do not exist, to try to ward off those conditions and make sure that the women are receiving adequate health care.
Yeah, I mean, I think, I think that something I've sort of observed is that oftentimes data points and statistics can be used in many different ways. And those sound scary to me, but without more context, it's really hard to know what they really mean. And I think what I have heard today, as I've been with you, is a heartfelt desire to protect the healthcare and the health of women. But what I've also heard is that from medical professionals is that that's not what this legislation does, but rather this actually impedes the ability of women to access the healthcare that they and their doctors choose, and that's what's of concern to me as a person of faith.
Well, I would think that, it's not just simply data. What Representative Swan shared with us, those were actual inspections and a report from what they found as a result of those inspections. So that gives us a true moment to pause with cause and caring for that situation and trying to resolve that situation as best as possible. And I don't think putting those regulations in place in terms of caring for the health and safety of women is an impediment for your views. I don't know, I'm not, I'm of the Christianity faith, so I haven't studied your faith, but I do respect, your rights and your beliefs to your faith. So I just wanted to point that out, that it's a great cause for concern with those conditions existing, that women shouldn't possibly be treated in those areas, and that we need to have a better regulation, guidelines in place, and oversight to make sure that those conditions do not exist. Thank you.
Are there other questions? Representative Moon.
Maybe follow up with a question to give me a response. Thank you for being here, Rabbi. I'm glad that you're here back because you're a man and you're speaking from your biblical heritage, or your faith and your heritage. It's often that I've done the same, many of those who support your position are, well, they're full of vitriol, actually. I went up to my office a few minutes ago and I had some really interesting notes plastered on a wall. I doubt they're part of your synagogue. But I guess what I'm wondering is, you mentioned that your faith says that you are to protect the health of women. Am I correct in that?
What I've said is that our faith teaches us that a woman's health and life are paramount over the potential life of a fetus. So that is what I've said.
Okay, and so you could surmise, though, to say that your faith teaches you to protect the health of women. Would you say that?
I think that's an oversimplification.
Okay. Well, in any case, I guess what I'm glad to hear you say is that a stance, and it's based on your belief. Is that right?
My view is rooted in my understanding of Jewish tradition.
Okay, is this related to your Jewish faith, though, right?
Yeah.
Okay, good. And so what I'm wondering is what the backlash will be from those who support my position towards you. You know what I bet it will be? Zero. Because we respect your ability to come in here and testify. And I'm grateful that you did. So I'm interested to pick up the Twitter feed and the Facebook post and see how now that people are saying to keep my religion out of my beliefs and stay out of women's healthcare decisions, when you're doing the same thing just from a different point of view. So I appreciate you coming in, and thank you very much. Madam Chairman?
Well, I'm happy to respond, because I think it's important to recognize that part of our American society is ensuring that the religious beliefs of all Americans are protected, right? That's what the First Amendment's all about. And in my case, my religious beliefs teach me that women need to have access to these necessary medical services. And I respect the personal decisions that you may make or others may make to elect not to choose those, to take advantage of those services. That's fine, that's your choice. And I think that that's a choice that I respect, and I have tremendous respect for people of faith from across the spectrum. What I find challenging is when people of faith attempt to impose their faith, their particular religious beliefs, on the religious beliefs of others. So what I'm simply arguing for today is, yeah.
Excuse me, I'm so sorry. I need to talk to the room again. Now, I think that we all like the First Amendment right and the ability to express, and I'm happy to do that, to allow you to applaud to do that. But this disruption of continuing to applaud for comments that are made from witnesses is not something that I'm willing to put up with. All right? Everyone has the ability to come and testify in this way, but let's respect everyone's ability to do that. I'm sorry, go ahead.
No. So I think that the core point that I hope we can agree on is that we live in a society that guarantees the free exercise and expression of all different religious beliefs. And that on this particular issue, that's particularly important, that people who believe that women should have access to abortion should be afforded that opportunity. And people who believe that that is not something that their faith teaches them, that that's not appropriate, not something that's appropriate, that they can choose not to pursue those types of procedures. That's their choice. But it needs to be a choice that I believe needs to be a choice that a woman makes for herself.
Answer points to my point in that we could probably have a good conversation as we're kind of having now. We may not agree, but at least we can discuss it. And you're not using language that is inappropriate. It's civil. And maybe that would change outside. I doubt it would, but there are lots of folks who believe the same thing you do, and they're full of hate, and it doesn't make sense to me.
Yeah, well, I think there's vitriol on.
I'm glad that you came in today in a kind spirit and are able to talk in calm tones. And I just think that it would probably do better for your side if you could kind of preach that message to others. And I know that's not going to happen because I guarantee it's probably going to increase, and that's okay if it does.
Well, I think there's vitriol in all different parts of this debate, and I think that I share your hope that we can live in a society that is that is more respectful of divergent views and minority opinions, right? But I think that it requires people who hold the full range of opinions on this issue and really a whole range of issues to sort of share in that desire to create a more civil society. So I would challenge you on the assumption that it's that vitriol emanates only from those who believe that women should have access to healthcare without government intrusion.
Right, I didn't say it did, but I guarantee you one thing, we're always going to disagree on the killing of a human life. And, but thank you for your testimony today. Madam Chairman, thank you.
Are there other questions for this witness? Seeing none. All right. Thank you. Thank you very much. What we're going to do now, we've had equal votes in favor of the legislation. We've had equal testimony. Individuals testify in opposition. We've covered the legal aspects, the medical aspects, and the religious aspects. Unless there's a perspective here that we have not heard, we're going to move on to informational purposes only. Is there an aspect that we have not heard? Your aspect we've not heard.
I don't believe that we've spoken in quite enough detail about the specific health regulations that do pertain to the situation. And if I could have 30 seconds to address those, I would promise to be extremely brief for the committee.
All right, let's do that.
Thank you very much.
Thank you. Thank you. Thank you very much.
Thank you. I recognize that the committee has had an extremely long day, and I will be as brief as possible. My name is Linda Racklin. I am a professor at Washington University in St. Louis. I am a lawyer. I am also a professor of public health law. I promise that I will not take up the committee's time to discuss Hellerstedt once again. I did want to, though, address the fact that I think we've had the impression here in our discussions today that Missouri is somehow an environment without many regulations that address the issue of abortion. In fact, Representative Barnes, I think, used the phrase this morning, which now seems like several days ago, I think, to most of us, but he used the phrase a regulatory desert. And I really wanted to just speak and address the fact that Missouri is not a regular, with all due respect, Representative, Missouri is not a regulatory desert when it comes to abortion. In fact, Missouri is one of the 3 states in the country with the most stringent abortion regulations. So we can cite Missouri, South Dakota, and Utah as the states with the most restrictive laws and regulations on the books with regard to abortion procedures. As the committee, I'm certain is well aware, any abortion provider here must be fully regulated by the Department of Health and Senior Services as a licensed state medical provider, even if that facility is not additionally regulated as an ambulatory surgical center. It was through its inspection as a state licensed medical provider that some of the violations that were raised today in the list read by one of the representatives, some of the rust that was found on tables or whatever, or those other minor things that were found, occurred exactly through the regulations that you already have in place, and that must be corrected under existing state regulations. So those regulations are in place and they are working. So we have some good protections in place that are doing their job. And please be mindful also of the fact that with Missouri's 72-hour waiting period, with its requirement that minors who seek abortion care must get the consent of a parent, with the fact that any medical provider who works at an abortion facility must be fully credentialed and licensed, that mandatory disclosures must be read to patients so they know exactly what kind of will be provided, even though there are many in the medical community who find some of those disclosures not to be entirely truthful. But leaving that aside, those are stringent regulations that are in place. So I did want to stress for the committee that this is not a regulatory desert, that Missouri has in fact some extremely strong regulations in place to provide for the health and safety of women patients. I'll stop there and take some questions because I know that we're very pressed for time.
Yeah, and I think that part of the response from the governor in the call is the lack of really follow through on those regulations from the department. I know in our hearings a couple of years ago, we found that 16,000 abortion pathology reports had not been turned into the state. So I think that the regulations that we're looking at and the reason for them are not only for taking care of the things that Representative Swan is really advocated for many years, but it's within our own department to be sure that they follow through on the regulations and the laws that we have in place.
Madam Chairman, if I may, as a state licensed medical provider, Planned Parenthood is required if a state comes in and finds any kind of a deficiency or violation in the course of an inspection, they are required to go back to the state and show exactly how they have corrected any of those violations, or they're not permitted to continue operating.
Yeah, and that's what happened. It happened to them because of the legislature's investigation and how they came in and really looked at what they were doing.
Excuse me, Madam Chairman. I did want to add that when Attorney General Koster did complete his rather thorough investigation, was it 2015 or 16, he also did not find any evidence of wrongdoing on the part of Planned Parenthood.
Yeah, and we saw that he looked at 30 days. You know, his investigation was a 30-day investigation. It wasn't a year's worth of investigation. There wasn't anything that really would have perhaps produced more information for us. Questions? Representative Barnes? Yes. Thank you.
Comment, and I can leave this open. I'm going to have my LA go make another copy. I have in front of me the March 16, 2016, and the first paragraph of said survey says that the survey was done to determine compliance with 19 CSR 30-30.050. Those are the ambulatory surgical center requirements that apply to abortion facilities whose continuing viability is in question as a result of the opinion from the Western District. And so to the extent we're talking about, well, that only happened because it was a Medicaid provider, there are certainly witnesses correct that we're not in a complete regulatory desert. And I thought I had the caveat that as it related to the ACS requirements, but that particular inspection came from the existing ACS requirements, C requirements. And so I'm going to have Brian go make another set of copies so that we can have it in front of us. Thank you, Madam Chair.
Okay, thank you. Other questions for this witness? Right, seeing none, thank you very much. Be sure to leave us a witness form. All right. With that, we will move to, is there anyone here to testify for informational purposes only? All right, seeing none. Would the sponsors like to make closing comments?
Yes, very briefly, Madam Chair. This is regarding healthcare, and we can all agree that we want the citizens of Missouri to have access to healthcare and access to high quality healthcare. But I do fail to see how this bill particularly prevents access to high quality healthcare. You know, is it the requiring a physician be licensed in Missouri? Is it requiring physical requirements on a part of the facility? Is it because we would require a plan for complications or physician referral or annual inspection? So yes, we do have current established healthcare guidelines and procedures and regulations. That's for safety procedures and infection control procedures. The problem is they've not been followed. We are simply trying to ensure that our current established procedures based upon medical research and evidence, not court cases, are followed. Thank you.
Madam Chair, I'd like to quickly add that I would request that the documents that I have sent around to the committee be included for this bill. I'm also going to reintroduce them should we get a Senate bill, and I would like them kept as a permanent record of the committee.
We'll do that for you.
Thank you, Madam Chair.
All right, thank you. All right, that closes the hearing on House Bill 3 and House Bill 6. And again, if you want to provide written testimony on this bill, you are welcome to do so. All right, now we're going to move to House Bill 9 with Representative Kelly.
Good afternoon, Madam Chair and members of the committee. My name is Representative Hannah Kelly. I represent District 141. Thank you for your time to hear this bill today. Something that I think we'll all appreciate. I bring this bill before you because no one should be discriminated against because they do not want to participate in abortion. House Bill 9 protects the First Amendment rights of individuals, property owners, and pro-life centers. The Declaration of Independence reminds us that every individual is guaranteed a God-given right to life, liberty, and the pursuit of happiness, protected by our Constitution. In turn, it is our responsibility to maintain this protection for every Missourian. Thank you for your time. I look forward to answering any questions you might have.
All right, are there questions for the bill sponsor? All right, seeing no questions, are there witnesses in favor?
Madam Chair, members of the committee, Todd O'Clair, Missouri Catholic Conference. I want to go and recommend support of House Bill 9. This bill was heard at length during the regular session, so I don't want to spend too much time going through it, but I do want to say that this relates to the Senate, or the City of St. Louis Ordinance PB 203, which was passed back in February. And as the committee knows, the Archdiocese of St. Louis, along with Our Lady's Inn and O'Brien Industries, has filed a lawsuit challenging it in federal court. These concerns relate to the lack of a complete religious exemption from the ordinance. And specifically, the ordinance would exempt them from having, the Archdiocese from having to perform abortions on property that they own. It would also prevent them from having to include abortion in their health plans for their employees. The concern the Archdiocese has is that the ordinance as written, because of the broad and vague nature of it, would prevent a Catholic elementary school principal from inquiring of a prospective employee about that prospective employee's position as well as pro-life or choice. That under this ordinance would be actionable as discrimination. The very asking of the question, putting out any statements that would say we prefer to hire pro-life people would be actionable under the ordinance. And so that the Archdiocese is concerned about as being a violation of their First Amendment free exercise rights, their freedom of association, their right to equal protection under the law. And so this bill would essentially preempt a subdivision from passing a law that would require the Archdiocese to have to follow those provisions or to be subject to suit and then have to go to court and defend themselves for being, not hiring someone, for example, that wanted to come to the school and promote that pro-choice agenda at the school, for example. So that's our concern. We support the bill. Thank you for hearing it.
Are there questions for the witness? Representative Walker.
To inquire.
You may.
Thank you, Madam Chairwoman. I'm trying to get up to the microphone here. Okay, thank you so much for coming and testifying about this
Bill, and you are absolutely right that we have definitely discussed this bill to some great length already. There have been a couple of developments since we heard this bill earlier on in regular session, specifically around the Supreme Court's decision here in Missouri on St. Louis City's raising of the minimum wage. I want to get to that in a second. But first, I just wanted to a bit more about your statement that both your First Amendment freedom of speech rights and your free exercise rights to practice religion under the Constitution would somehow be jeopardized by this ordinance. Now, is it your position or contention that the Constitution does not supersede all of this or preempt all of this? The United States Constitution.
I don't think that the First Amendment would absolutely protect everything. It's not, free exercise, freedom of speech, it's not an absolute. You can't cry out fire at the crowded theater, for example. There are limits to free exercise as well.
Sure, but for the purposes of what it is that you are saying that you all as the Archdiocese are hoping to do in terms of being able to hire only pro-life people,
or people that are following the Catholic teaching, for example. That's really what it boils down to. And I think that's the concern.
And you think that this bill would somehow, or this local St. Louis City ordinance would somehow supersede what is constitutionally protected? And
I think if it's there's been a lot of talk in regard to discrimination laws around the country. If it's a neutral law of general application, it can supersede First Amendment rights, and so that's part of the concern. This could be viewed as a neutral law of general application that would potentially override a First Amendment right.
Along those same lines, RFRA, do you, or is it your position that, again, the same sorts of conduct and activity that you all are hoping to be able to do as Archdiocese would not be protected by RFRA as well?
Statute is not as broad as the federal RFRA statute, and as you know, the federal RFRA statute doesn't apply to state law. So there is a concern that our RFRA statute would not be protected.
Okay, thank you.
Further questions for this witness? All right, seeing none, thank you for your testimony. Sure to leave the witness form. Others in favor?
Chairman, members of the committee, my name is Patty Skane. I'm the Executive Director of Missouri Right to Life. I'm just here to testify in support of this bill, and also because I believe also for House Bill 7. Obviously, Missouri Right to Life represents thousands of pro-life Missourians across the state, and we believe that this kind of an ordinance could violate some of their constitutional rights, and therefore we oppose that ordinance and support this legislation.
Are there questions for the witness? All right, seeing none, thank you. Others in support? All right, thank you. All right, we'll go to opposition now. Anyone here to speak in opposition? Good afternoon, members of the committee and Madam Chair. My name is Melissa Alper. I'm the Missouri State Policy Advocacy Chair for the National Council of Jewish Women, St. Louis. NCJW is a nonprofit organization located in metropolitan St. Louis, representing over 5,000 members and supporters across our state. We focus our work on community service, advocacy, education, and philanthropy to improve the quality of life for women, children, and families while supporting individual and civil rights. I'm here to testify in opposition to House Bill 9.
Are a person's beliefs or opinions regarding reproductive health care a litmus test for hiring someone? Firing, renting or leasing, selling to or buying from? Are they relevant at all? HB 9 seeks to make it legal for a political subdivision, like the city in which you live, to choose with whom to do business based on their reproductive health care choices, based on the opinions of real estate agents, of healthcare providers, and others. In doing so, this bill takes away the ability of each political subdivision to legislate for the good of its residents. A state should allow political subdivision local control. I'm here as a representative of our organization because we believe in supporting the rights of political subdivisions to stand up and make the laws that our state owns. Women urges the committee to vote no on House Bill 9 and keep it from passing out. Thank you for your time.
Thank you. Questions for the witness? Representative Brew.
To inquire.
You may.
Thank you. Thank you for being here today. We've heard quite a bit about your religious beliefs, and I respect your religious beliefs. At the same time, I would ask that my own religious beliefs also be upheld, because I'm a real estate agent, so I know quite a bit about real estate. And if I held some property, if I own some property, I don't believe that I should be forced to rent to someone that is, possibly doing abortions in that property if it goes against my religious beliefs to do so as a property owner. So I think when we talk about our religious beliefs and upholding those religious beliefs, I think that it has to go for all of those and not just simply for one. Because you stated that you support an individual's rights. Well, I too believe in my pro-life position, and I would not want to be put into a situation where I was forced to rent to someone that could possibly perform abortions in my property, which goes against my religious beliefs. Would you support that statement? And my right to my religious beliefs as a property owner?
I would absolutely support your rights to any religious beliefs that you have. And I don't think, to my knowledge, that this legislation or legislation that's currently enacted forces you to do business with anyone with whom you choose not to do business. And I don't believe that this legislation would change that. All it would allow you to do is to ask someone about their religious beliefs, or about their choices regarding reproductive health care. And I don't think that that is what we stand for as an organization.
This bill would make sure that my religious rights and freedoms were protected. So that's why I'm supportive of this language. Besides that, when we talk about real estate, some of the and I don't have that right in front of me with the St. Louis ordinance that was passed. They talk about the MLS and what's being entered into the MLS and who can or can't. We already have the Fair Housing Act, which already controls that. And as a real estate agent, I have no clue whenever I go to list a property and I enter that property into the MLS, our office enters it in, what that person's reproductive choices are. That's not on my list. And I could actually get in trouble, ethically for asking that. So I think that the St. Louis ordinance has way overstepped its bounds there. As I said, we've already got the Fair Housing Act, and I think this bill does make sure that we are protecting everyone's religious beliefs and their right for their freedom of speech to be able to say, no, I don't want to be forced into this situation. As the gentleman from the Archdiocese said, they have their right to have that belief. I'm not Catholic. I'm very pro-life, and I would not want to be forced into a situation if I owned a business that was founded upon my religious principles to have to do that. And I think we've seen some of these cases when we talked about like the Hobby Lobby case and other things like that, where we should have those rights and those decisions. So thank you.
Thank you. And if I may respond, I don't believe that this legislation that was passed in St. Louis, the St. Louis ordinance, overstepped its bounds. I think this legislation could potentially, by allowing discrimination based on reproductive health care choices and decisions.
I'll have to disagree with you on that. I think this legislation isn't discriminating. I think it's protecting everyone in this case. So, and Madam Chair, may I ask Representative Kelly a question along these lines that we're talking about? So, Representative Kelly, you also are a realtor, and you and I have had these discussions about the MLS and about the listings and the renting and property ownership. Could I ask you, because I know you have that ordinance and I don't have it in front of me, can you please address that?
Yes, let me get to that section here just very quickly. On page 7, section 17, subtitle H, for any person to deny any other person's access to or membership or participation in any multiple listing service, real estate brokers organization, or other service, organization, or facility relating to the business of selling or renting dwellings, or to discriminate against him in the terms or conditions of such access, membership, or participation on account of reproductive health decisions or pregnancy status, parentheses, including childbirth or a related medical condition. You mentioned earlier, if I might add, this is already covered by the Fair Housing Act, which we as realtors must abide by, which clearly says that Title 8 of the Civil Rights Act of 1968, as amended, prohibits discrimination in the sale, rental, and financing of dwellings and in other housing-related transactions based on race, color, national origin, religion, sex, familial status, including children under the age of 18 living with parents or legal custodians, pregnant women, and people securing custody of children under the age of 18, as well as anyone with a disability. So we, as you and I both know, have to abide by these guidelines. It's a very serious thing in our industry. As well as I might add the Missouri, let me get to my notes here. But the Missouri Human Rights Act also covers portions of this as well, where it's very clearly outlined that discrimination will not be had. Thank you.
Thank you.
That just it makes me, if I may ask the witness.
Of course.
So having heard of the realtors exchange this information about the fair, why do you think then this additional board bill, I guess is what we're calling it, is necessary in St. Louis? What's happened there where it's necessary to have this?
Well, I don't know that I have all of the answers to that question. What I can say is that as an organization that speaks with and on behalf of people of faith who use that faith to guide their decisions, including those regarding reproductive health care, I think that legislation that specifically spells out, or an ordinance that specifically spells out that you can't discriminate against someone regarding real estate ventures because of their reproductive health care decisions. I think that if it wasn't specifically spelled out in other pieces. So I think that that is something that was necessary, and there's no reason in my personal opinion that a bill should take that away.
Okay, so the ordinance, you can't, there's no incident that happened that you can recall that makes the board bill necessary. It's not responding to an incident that you know of.
I'm sure there are, and I'm sure that there are people in this audience who can answer that question.
Okay, all right. And so then in your experience, what the ordinance pertains to, how does that become knowledge? How does that become knowledge of an employer, or how does that become knowledge of someone that is going to rent, or how does that become knowledge that someone has had an abortion? Is that a question that's asked, or?
It's a great question, and my guess is that that would be the way that it would be found out, is if somebody is asking the question or doing research into someone's personal decisions and their personal choices, which I can't think of any ways other than that it would be found.
Okay, So you don't agree with this bill, but you don't have anything to tell me as to why this occurred, why you got behind this movement, what specifically took place.
I can't point to a specific incident. I can tell you why we stand to support the ordinance,
Yeah.
which I believe I have, and I can tell you why we oppose House Bill 9, which I think I have, but I don't think the particular incident is as relevant as the reason and rationale for our opposition to this legislation.
All right.
I'd be
Thank
happy
you.
to find an answer for you.
If you don't get your yeah. Thank you very much. Are there other questions for this witness? All right. Oh, yes, Representative Walker.
Thank you, Madam Chairwoman. Actually, I'd like to inquire of Representative Kelly if it's possible.
Sure, yeah.
I wanted to go back to the specific provision of the board bill that you read about what you have said.
Section line 17 on page 7.
Yeah. Okay. And I just want to be clear about the language here and my interpretation of it doesn't exactly, it doesn't match what you seem to be interpreting at all. I'm not sure where in any of this it says that real estate broker, real estate agent is anyhow, or any sort of situation required to allow for an abortion provider to rent at their facility. This board bill is regarding a person's private reproductive health decisions. It doesn't seem to have anything to do with whether or not a real estate agent, a landlord, a broker is somehow mandated or prevented from doing business with, interacting with, renting their real estate to an abortion provider. Is there something in here that I'm missing? I still, and specifically as it relates to that section that you just read in response to Representative Ruth's inquiry, it's very clear here. It's participation on account of reproductive health decisions or pregnancy status, including childbirth or a related medical condition. That doesn't have anything to do with an abortion provider, an abortion facility, or anything like that. Is that
to clear? Okay, so again, we're talking about section H, line 17.
the section that you just, the section that you
All right,
just
so you're
referenced
asking
in
me,
order
where do
to
we get the concern that this
you
would
might be
involve
required,
abortion
that you might be
providers?
required to rent to an abortion provider, yes.
Well, and I think that the very fact that you express, in my opinion, the ambiguity and the lack of clear direction here as to, and let me finish if you don't mind.
Yeah, let me be clear. I don't think it's ambiguous at all. I think that the text is pretty clear.
We are sitting here looking at a section, to repeat, as obviously you have the same language in front of you. For any person to deny any other person's access to or membership or participation in any multiple listing service. So I want to cover that section first. I've been in the business for 10 years. I have yet to see that as a requirement to access a multiple listing service. What's required to access a multiple listing service is to go through certification, licensing, and training, etc., to obtain a realtor license, which in turn means that I ascribe to the values stated in the Federal Fair Housing Act. And so I quite honestly, I'm confused. I was talking with a very successful broker last night in regards to this section, and he was the same as myself. He said, I don't even know why or how that would come up. I have yet to meet a realtor, and I know very, very many across the entire state where this would even come into play. It doesn't make any sense because it contradicts, again, back here, what we're talking about, that is our main core value of service. Then you go on to real estate brokers, organization, or other service, organization, or facility relating to the business of selling or renting dwellings. Okay, so I'm not a lawyer, you are. So I'm going to respectfully digress to you when it comes, and Representative Barnes perhaps when it comes to these legal terms. But when we're looking at this section as a realtor, what I see is potential for somebody to interpret that when, because see, here's a real life issue. I'm not a lawyer, but I can give you a real life issue. If I have client A, they have commercial property. I come to them and I say, hello, client A, I have a prospective first client that wants to lease your property. And they are an abortion provider. And I give them all the information of the transaction. I am hired by my client to represent their wishes, keep in mind. And if they come back to me and they tell me that this contradicts clearly their religious belief, that they do not want this to happen on the property because it is a highly volatile social issue or whatever might come up in the conversation.
And aren't they absolutely entitled to do that?
They currently can do that, but
What you mentioned that this section,
the fear is that this section would invade on that.
and that's what I'm not understanding. It's participation on account of a reproductive health decision or pregnancy status. I'm not sure of an abortion provider that has made a reproductive health decision or has a pregnancy status, the provider itself.
I think what's been made very clear here today is that we have very different opinions on this very issue, and I hold to the opinion that's been expressed and respect that we are looking at the same thing and seeing two different.
Well, all I'm doing is looking at the text and reading the text, and I think as legislators, that's something that we absolutely should be able to do. But let me get to this, your specific bill, House Bill 9, and I'm trying to understand what part of your proposed legislation addresses what your concern is, and what Representative Ruth has, I guess, expressed her concern is as realtors around somehow being forced to rent to an abortion provider or an abortion facility. Where in your bill is that concern addressed?
If you'll notice on page 1, section 1, there's very clear language that it begins with, and it says it is the intent of the General Assembly to acknowledge the right of an alternatives to abortion agency to operate freely and engage in speech without governmental interference as protected by the Constitution of the United States and the Constitution and laws of Missouri.
Yeah, so the alternative to abortion agency, is that a realtor? I'm not, again, I'm not.
Obviously not.
Right, so how exactly does that piece address this piece?
So to clarify, we're looking at a situation here where there is great concern by many individuals as citizens of the state of Missouri that there could be undue discrimination had against people who choose not to participate in abortion for religious reasons or perhaps just personal reasons, whatever it might be. And the intent of this bill is to clarify the right for the alternatives.
So my question is specifically about the housing and the realty, and so yeah, that's the real estate and the housing is what my question is.
All right, so give me just a second here. Let me get to that section. And on just a second, I'm afraid I'm missing a page. Bear with me just a minute, please. In section 5, page 2, it leads into a quite lengthy paragraph here, and it says the political subdivision of this state is preempted from enacting, adopting, maintaining, or enforcing any order, ordinance, rule, regulation, policy, or other similar measure requiring a real estate broker, real estate salesperson, real estate broker salesperson, appraisal firm, or appraiser as defined in chapter 339, property owner, or any other person to buy, sell, exchange, purchase, rent, lease, advertise for, or otherwise conduct real estate transactions for, to, or with an abortion facility, or for, to, or with a person for the purpose of performing or inducing an abortion not necessary to save the life of the mother. If such requirement is contrary to the religious beliefs or moral convictions of such real estate broker, real estate salesperson, real estate broker salesperson, appraisal firm, appraiser, property owner, or other person.
Okay, and so that provision and the language in that provision relates to the specific section of the board bill 203. How again? Because that's
All right, so I can very quickly
has-
tell you
yeah,
how. It's the same reason that we each represent 34,000 people respectively back in our districts. As realtors, that's the main title of our job, is to represent folks' wishes. And the concern and the whole reason why this special session is called is because there's individuals that feel like their First Amendment freedoms are under attack because of government overreach. And because realtors are even pieced into this, I personally believe, again, I'm not a lawyer, so I concur to those who are, but it's because of the fact that we represent the same way that we do here in this body and have diverse individuals who hold different beliefs, which are part and parcel to the American structure of government.
Okay, so yes, I am absolutely honored to represent the 35,000 or so folks that I represent from St. Louis County. I'm not seeing how this bill that is proposed relates to or addresses any of the concerns that you are saying that you have. This Board Bill 203 is about, as we heard from the Archdiocese earlier, them wanting to be able to ask questions about whether or not someone had an abortion or whether or not someone is pro-life.
Which is the main premise of the intent here.
Sure. That is something that's very different and separate. And again, the only thing that I'm specifically referring to right the realtor would somehow be required because of the provisions of this board bill to rent, lease, do any sort of business with an abortion facility because it violates your religious beliefs. That is, I'm having
that
trouble.
I can identify maybe where our miscommunication is happening, and that is our concern isn't so much for ourselves as realtor professionals as much as it is, I believe, I'm presuming I can speak on behalf of representative group, that it's in concern for the individuals that we represent.
Could you elaborate on that? What exactly?
The individuals that we represent who lay claim to issue in regards to religious beliefs as to why they can or cannot lease a facility or a property to an abortion provider.
And so that's okay. So let me just go to the Fair Housing Act for a second, and the Missouri Human Rights Act as well. So it's my understanding that the Missouri Human Rights Act does not protect or have any sort of relationship to reproductive health decisions or pregnancy. Is that your understanding as well?
The Missouri Human Rights Act prohibits discrimination in housing, employment, and places of public accommodation based on race, color, religion, national origin, ancestry, sex, disability, age, and employment only, and familial status in housing only.
Okay, so not reproductive.
That is correct.
So I thought I heard you say earlier that some of the concerns were already addressed by the Missouri Human Rights Act as well as the Fair Housing Act, but I did not recall in my reading of the Missouri Human Rights Act that reproductive health decisions or pregnancy fell under that.
And again, I would lay the question on the table that in 10 years of business, I have yet to see that question arise because of, it's a whole other conversation that we don't have time to get into here. But obviously, we both know the documents that we're looking at.
Okay, and then finally, the Fair Housing Act, the federal standards that you were saying that basically renders this specific section, that again, this section H on page 7 that you're referring to, renders it moot essentially because you're already not allowed to do that as realtors under the Fair Housing Act. Isn't it, and maybe I'll refer to the other lawyer, but the federal standards, I mean, that's the floor. If the state or a local or a municipality decides that it wants to implement additional standards, they absolutely are entitled and able to do that. Is that not correct?
Obviously, by the document that you and I both have in front of us in regards to the St. Louis Board Bill as the chairwoman so kindly put that we are referring to, obviously there is opportunity to enact local things, but then it is a responsibility to, with the different branches of government, to hold the constitutional balance, again, which is why we're here.
And so the constitutional, the local bills, local ordinances state laws that we pass absolutely have to pass constitutional muster. I completely agree with that. And if there are conflicts, then obviously the Constitution supersedes any sort of state or local ordinance. And so, again, where the conflict exists here, the Fair Housing Act, as you just said, already says that you can't discriminate against and because of pregnancy or their familial sort of situations or anything like that. And so there doesn't seem to be a conflict that exists here. Again, it seems like this St. Louis Board Bill and St. Louis ordinance is just adding additional protections as opposed to what the federal floor is, the federal standard is.
At the end of the day, we're going to have to agree to disagree. We've hashed out the facts. We have the bill in front of us. We've discussed the reasons why realtors cannot discriminate. We've discussed the reason why there is not allowed, housing discrimination is already been taken care of at the federal and state level. So
if a local ordinance wanted, or a local municipality wanted to put in additional protections, if they felt like the federal and state protections against discrimination in housing were not enough, can they not do that? Are they not granted the ability to do that if they're a charter city under our state constitution?
I would love to defer that question to Representative Barnes, who I think can add some substance to the conversation potentially.
I'm happy to yield.
Representative Barnes,
I'm not
do you
sure
have a
what the
question?
question on the floor is. I think I'm being asked a question. I'm not even aware of what the question is.
I think that you have a question. It has to do with, what section of the bill was that we were discussing there?
I lost my
Well,
here. Representative Walker,
We're
what was your
discussing.
question?
There you go.
Representative Walker, what was your question?
So
pertaining to?
just very generally, my question is if there's a federal housing act standard and there's state Missouri Human Rights Act that prohibits discrimination in housing for various reasons, are local municipalities not also able to enact additional protections? Basically, is the federal standard, is that not the floor? And then if local ordinances or local municipalities want to create additional protections, are they not constitutionally able to do that?
Okay, I think, sure, except there are questions.
Sure.
And I think, so, two cases come to mind. One I don't have in front of me. I think it's called Hosanna Tabor, which talks about the ability of religious employers to determine who works for them. And I don't know that there's a case directly on point. I don't think the question has been asked about if a religious discrimination laws don't apply to a religious entity as it relates to employment. The question is, do they apply where they're outside the ordinary context of federal discrimination laws? Does it apply to the rental of housing? So, and abortion status, one's view on abortion, protected class, except for in St. Louis and Boston. I think the impetus for this legislation is a thumb in the eye of the legislature, but that's the answer to a different question. The other case is the Burwell versus Hobby Lobby stores. And I think the board bill defines a person to include a corporation. Burwell versus Hobby Lobby was whether RFRA, the federal RFRA, prohibited a closely held corporation, prohibited a requirement that a closely held corporation do something against its religious beliefs. The Supreme Court said the federal RFRA protects closely held corporations from being required to do things that violate their religious beliefs. This board bill applies to corporations, would purportedly require them to do things, which I don't think anyone can argue is against the religious, sincerely held religious beliefs of many closely held corporations. And her bill says, no, we're not gonna do that. We're gonna take this rule from Burwell versus Hobby Lobby, we're gonna apply it on a state level. I think there's some open questions of laws to whether existing law is enough to invalidate the ordinance. And Representative Kelly's bill makes clear that you can't force a religious institution or a closely held corporation to abide by these laws that violate their sincerely held religious beliefs per the Hobby Lobby case.
Thank you,
Madam
Representative.
Chair, yeah, may I have an opportunity to respond, or
So your inquiry, Chairman,
Yeah.
thank you, ma'am.
I guess I just wanted to, thank you, Madam Chair. To your point, that there's certain questions that have not yet been answered yet, or that still remain about the board bill and whether or not, in its, application, whether or not it would be invalidated because of the Tabor case, as well as the Hobby Lobby, the Burwell case. That's the point that I was trying to get to, whether or not this bill is even necessary, because it seems as though that there's still a lot of legal work to be done and litigation to be done around the specific board bill.
Well, there are two ways to invalidate a local ordinance in this state. One of them is to win a court case. The other is to get the legislature to pass a law that invalidates it. And we can speed up the process.
Yeah, we definitely do that around here. Okay, thank you.
All right, are there other questions for the witness, actually? Thank you for your testimony. Be sure to leave a witness form. Are there others to testify in opposition? Oh, okay, good, thank you.
Good afternoon. My name is Christina Gracia. I'm the Alderwoman of the 6th Ward in St. Louis City. Thank you for the opportunity to speak today. I just wanted to come to, again before you to make sure that some of the misinformation and misunderstandings about what Board Bill 203 does and doesn't do are answered. To the gentleman, Representative Barnes, I was involved from the very beginning of this legislation. It was definitely not designed to stick our in the state legislature's eye. It was designed to, as a call to action from some of our constituents. We have a number of protections in St. Louis City that are also protected under federal and state law, but because of certain situations with respect to maybe the number of employers or certain other restrictions, we have a level of and a possibility for constituents to air grievances and concerns through our Civil Rights Enforcement Agency. We had not received a number of complaints regarding certain issues like LGBT issues, gender identity, but as soon as those protections were added, we did see an influx of requests to look into situations come into city government. Since Board Bill 203 became an ordinance, we have in fact received complaints with respect to employment discrimination for miscarriages and a number of other items that I'm not particular to with specificity because I'm not allowed, obviously because of close right to privacy, what those actually are. In this board bill, the Archdiocese, who was the main opponent of this bill, despite the fact that we have state and federal law that prevent religious organizations and churches from being subject to the laws, we did add with specificity the exact verbiage that the Archdiocese wanted. So there are Board Bill 203 specific exemptions for religious organizations. And I also do have a concern just with respect to St. Louis City being a home rule charter city and the attempts here at the state level to preempt that over and over again, which I think sort of defies what we're able to do and how we're able to connect with our constituents on the local level. And I'm happy to take questions.
All right, thank you very much. Questions for the witness? All right, Representative Newman.
Yes, to inquire, Madam Chair.
You may.
Good afternoon, Alderwoman. I think that thank you for being here, and also I noticed that you also introduced your you were one of those sponsors of this board bill, which is now a St. Louis ordinance. And clarify, I mean, we're talking, you know, I guess this whole day has been the abortion day, but can you tell us specifically, and it's contained in the first two sentences of the ordinance, is what this actually does?
It prevents discrimination on reproductive health choices, including pregnancy, contraception, abortion, number of children that you choose to have, and employment and housing.
Okay, so what it does, this is a anti-discrimination ordinance.
Correct.
Correct. So, and as you also pointed out, and I think that inquiry, there was a section of your ordinance that was left out in terms of the exemptions.
Correct.
Correct. So again, you know, we can focus on one part of the ordinance, but it's important to read the entire ordinance. But yes, at the top of page 5, you said in conjunction with the Archdiocese, and I guess there was a lot of help in terms of drafting this, correct? In terms of carving out and, you know, religious institutions, corporations, associations, societies, healthcare facilities, or education institutions, correct? So, I mean, you worked very, very hard, I mean, the team of you in conjunction with the Archdiocese into making sure that this was going to be a fair ordinance, but at the end of the day, be an anti-discrimination.
Absolutely.
Yes, and because we know that we do not have anything in statute, I've filed a similar bill to take care of this at the state level. We also know that we don't have a, you know, the Missouri Non-Discrimination Act. We're still lacking our state after, I don't know, 17, 18, 19 years of the same type of, not just ordinance, but a state law prohibiting discrimination, particularly on someone's sexual identity or orientation, correct?
That's true, and that's something that our constituents find troubling.
Find very troubling. So this really is just dealing with anti-discrimination on reproductive health choices. And like you said too, you know, it's hard to, you know, people say, is there a reason why you had to do this? And I know that the reason is preemptive, because again, if there's nothing, no one is even collecting any information, how are you supposed to find out if discrimination actually happens? And yet I know that since this has been in effect, there has been some situations that have come to the St. Louis City's attention of people who would have been affected if this was not.
Right, that's correct. In similar situations, we've experienced the same thing. Now we're able to collect data that's, I think, pretty important to address the each of our constituents.
Well, but currently it is law.
Yes, it is.
It is currently law in the city, only in the city of St. Louis, so it doesn't matter if, you know, those of us who represent other districts are not affected by this ordinances in St. Louis City, right?
That's correct. We're responding to our constituents, which is in need.
So again, so if anybody in my district is, which I represent nothing in St. Louis City, is concerned about what's happening with this ordinance in your city, it doesn't apply to them. It doesn't affect them. This is not state law. So I just wanted to clarify that this was an anti-discrimination, and really by, you know, us trying to at a state level come in and tell St. Louis City, no, you cannot do this, and we'll make sure that no one else can have an anti-discrimination ordinance in their own, like you said, a charter city specifically. What we're saying and what everyone else is saying, that it's okay to discriminate.
That's correct.
So again, with all of the religious prohibitions, and can you tell us a little bit about that procedure? I mean, wasn't the Archdiocese at the table? I mean, I know you have probably a lot of religious organizations, institutions, whatever that fits in this in your own certain ward. Were they as concerned?
I didn't hear with specificity concerns from any of the organizations in my ward. That being said, originally the bill did not include any language that specifically exempted religious organizations or corporations. But at the Archdiocese request, we did add this specific language that is in the bill, despite the fact that there are already state and federal protections.
So there was a mutual agreement when this was drafted to include those exemptions, correct?
In the committee substitute, which became law, yes.
Okay, so is there any other valid reason for the state to come in and to repeal this?
I can't understand why that would be.
And then to also, the House Bill 9 also includes additional protections, freedom protections, whatever, of crisis pregnancy centers that would actually, under this ordinance, they would be exempt if they're religious based.
Yes, they would already be exempt under the ordinance, yes. And the other thing I find concerning in this bill is the exemptions that are allowed, to me, look like something even like trespassing, a local ordinance that we have, or trespassing, we couldn't enforce. They're very broad. It's really just zoning, land use, building, and fire code. So I have a level of concern outside of the discrimination factor as well.
So even though, you represent your own ward in St. Louis City, and you're, the co-sponsor of this, this ordinance, what are your thoughts on also yourself as a Missouri citizen of what we're doing today in terms of how it relates to your own work and this work in St. Louis City?
It makes my work much more difficult and makes it almost impossible to respond to the wishes that my constituents communicate to me on an everyday basis. I represent way fewer folks than you do, so I come into contact with the people that I represent on a daily basis. It's about 12,000, and this board bill passed overwhelmingly in the city of St. Louis. I'm assuming my colleagues have similar experiences, and I think we have to be very careful about preemption and the level at which it's occurring currently in the state.
So there were 5 co-sponsors of this ordinance, so it's really beyond your own ward, correct?
Absolutely, and the votes that we had in support were overwhelmingly
And
in favor.
it was signed into law by a mayor?
It was.
So there was actually approval by far more than the co-sponsors in terms of this being a good thing for St. Louis City.
Right.
And so what do you think they think about us spending money here on day 3 of trying to repeal? Obviously, that's in the governor's call that, we want to supersede.
Well, I should be at home in St. Louis catering to the needs, being of service to my constituents and working on legislation that I currently have pending, but they thought it was important for me to be here and be their voice,
So isn't this a slap in the face of St. Louis City?
I'm not a fan of it.
Because of saying what you all did, including, mayor signing into law, which is an anti-discrimination. This is not an abortion ordinance. Is it?
Correct.
Thank you for being here and clearing up for the fact that if people would read all pages of the ordinance, you would discover which you guys worked very, very hard to include, the religious exceptions.
I'm happy to be here.
Thank you.
Questions from the committee? Representative Ruth.
To inquire. Thank you. Couple of things. You had stated that we have to be careful about preemption, yet this bill, you had also stated, is preemptive.
The bill
I'm a little
that you
bit.
have before you, 9.
Well, you said the St. Louis bill was preemptive. I mean, can
you
you
don't have the
point
ability
to?
to preempt any laws. We're a local government, only the state.
But you said it in the fact that you're trying to solve this problem. Do you have specific cases that you can point to where this has occurred that led you to enact that bill, the St. Louis City bill?
As I mentioned, with previous protected classes that we now cover in St. Louis City, we heard mentions of people having issues, but no one was collecting data on it. And when we started having people with a process and the ability to file a complaint and be able to see that through fruition, we saw those complaints start coming in, and we've already seen that since this bill became law.
Have those complaints been investigated?
They're currently being investigated.
Okay, so they haven't been substantiated yet?
I'm not part of that process. I'm not allowed to really know exactly how that process is working because of privacy issues. And did the law?
So at the time the bill was enacted, we didn't have any substantiated cases. So in essence,
There's no way that there could be a substantiated case because there was no process.
So in essence, the bill was more preemptive than anything, even though you said we need to be careful of preemption. Thank you.
Representative Barnes.
Too far. Your bill is going to create a 108-foot buffer zone too?
108-foot buffer zone?
Yeah, I'm reading about a new bill to create a buffer zone, and it says you want to file a bill that creates an 8-foot zone around the interest in those spots within 100 foot of the doorway to a facility.
I think you're looking at a copy of maybe an old bill, but I have something similar that was heard in committee yesterday. I'm happy to answer questions on
That's
House
already,
Bill 9.
that's already public. That bill, you filed the bill. You have filed the buffer.
Right, as I just said, we had a hearing on it yesterday.
Okay. Madam Chairman, I would hope the committee would entertain an amendment later relating to buffer zones that are not that are not identical to the law in Colorado.
All right, thank you, Representative Barnes. Other questions for this witness? Seeing none, thank you very much. Please leave your witness form. Others in opposition? Good afternoon.
Good afternoon. My name is Sally Hunt. I wanted to talk today about crisis pregnancy centers because I know there is an exemption carved out in this bill to give more fewer regulations rather to them, less oversight from the state to crisis pregnancy centers. Many Missouri residents are very concerned about this. Crisis pregnancy centers already are receiving so much of our state tax dollars. So much of it, in fact, $5.8 million from TANF, Temporary Assistance for Needy Families, is supposed to be helping families in poverty, children in poverty, and it's actually going to these crisis pregnancy centers such as Thrive in St. Louis, a well-known one in St. Louis, so that they can use this money to intentionally mislead, deceive, and lie to women, outright lying to women. It's medically inaccurate information that they are giving to women in these fake clinics every day, and they still, as healthcare clinics somehow that's legal. But they truly are healthcare clinics in the same way that Trump University was a real university. It's pretty much exactly the same way. Truly, these crisis pregnancy centers are con artists. That is very much what they are, with our taxpayer money, again, that should be going to families in poverty, children in poverty who are hungry. And so we have Representative Mike Moon here show us pictures of fetuses, and he's very emotional about them. I wish that same emotion could be felt for these children in poverty. Wouldn't that be nice? Because they need that taxpayer money that is going to these fake clinics.
Madam Chairman.
So that is what I wanted to talk about today. They are telling.
Ma'am, do you have some? You kind of made some statements. And so do you have some information then to give us about you feel very passionate and very strong. Do you have some information about what it is that's done that is inappropriate?
Absolutely, yes. Thank you for
Okay,
asking.
please try to refrain from mentioning, attacking basically folks in the room, okay?
Okay, I didn't feel like it was an attack, but I understand.
Okay,
You don't want
thank
me to
you.
talk about members in the room. But that was
Well, it's
not an attack.
kind of a waste of time, okay?
Well, it's okay.
Okay.
I feel like this entire extra session is a waste of time, but I understand that is your
You don't
opinion.
want to, if you feel that way, you wouldn't want to contribute.
Well, I have no choice because we're here.
No, but to the waste of time, you wouldn't want to contribute. So just.
I'm hoping it
give
can be
us
less
your-
of one by
Give us your
pointing out these
information.
facts. And the emphasis on fetuses instead of children in poverty. So that's definitely not an attack, but I understand what you're saying. So I would love to talk about facts regarding crisis pregnancy centers and their lack of facts of what they tell women. So they tell women that abortion causes cancer. It doesn't. It doesn't. So that's scientifically inaccurate. It does not cause cancer. And I am happy to leave you with articles about that. I mean, the National Cancer Institute says that it doesn't. The World Health Organization, American College of Obstetricians and Gynecologists says it does not. So abortion does not cause cancer, just so everyone is clear. Does not cause infertility. This is something else that crisis pregnancy centers, fake clinics, this is what they tell women, that abortion causes infertility. It doesn't. And again, we've heard a lot. I've been sitting here listening to talk of the complication rate of abortion, and that's very, it's very silly to talk about that so much because it is incredibly low. The complication rate, for the record, so that we're all clear, is incredibly low for abortion procedures. It's lower, in fact, than for wisdom tooth extraction. That has a much higher rate for wisdom tooth extraction than for abortion procedures. Very safe. So they're telling women that there's a high risk of complications. That's not true. They are telling women that there are serious mental health consequences of abortion, long-term mental health consequences of abortion. Not true. That is not true. That has been shown to not be a factual statement. Again, I can leave you with articles about that as well. That is definitely, the American Psychological Association states there is no credible evidence that a single elective abortion causes mental health problems. So that is not true as well. So the point is that we're giving all of this money to crisis pregnancy centers. They're not regulated as medical facilities are. They bill themselves as healthcare. They are fraudulent. That is somehow legal for them to advertise as healthcare. They are not medical facilities. They trick women into going there, and once those are considered their legal choice of an abortion, a lot of shame, a lot of judgment, a lot of lies, a lot of inaccurate statements come from these crisis pregnancy centers, such as Thrive in St. Louis. So they need to be up front. They need more regulation. They need any regulation, please. Some regulation, some laws requiring truth in advertising, requiring factual information to women would be very, very helpful and would benefit us all in society. I don't understand why requiring facts is not something that we can all support. Information should be medically accurate, scientifically accurate. It should be required to be so, especially when they're using our taxpayer dollars. Truly, they're the biggest welfare queens in the state, these crisis pregnancy centers, using money, again, that should be feeding hungry children in poverty. So why are we here with a bill that is stating that they should have even fewer regulations and that we should treat them even better, as if they're not already taken care of by the state with our welfare dollars to them every day, to lie, to use their political agenda to lie to women, to fulfill their personal, religious, political agenda of being against abortion. And they're entitled to that. But here we are. We give them all of these taxpayer dollars. They tell lies every day. And somehow that's legal. We should be presenting a bill that requires more regulations, any regulations, as a medical facility. They're not a medical facility. And we're here talking about regulating medical facilities that do already have regulations. Meanwhile, Thrive and other crisis pregnancy centers don't have regulations. They're the ones that need them. That's what we should be talking about here in this session. I can tell you more about them because it seems as though there's a great lack of education from many legislators about crisis pregnancy centers. Or there's an intentional ignoring, because I have a feeling you probably know a lot of this already,
but it definitely needs to be focused on, that they are being dishonest every day with our taxpayer dollars. And that they are not healthcare. And that is the true injustice, that somehow we want to take greater care of them and give even fewer regulations. We just want no more lies. We want this scam to end. $5.8 million, again, of TANF money. That's not all the money they received, but that's just the TANF money in fiscal year 2017. $5.8 million. Instead of shaming women, I think that's the part that needs to be shamed, is that money that should be going to hungry children and families in poverty is going to them to lie to women each day. That's shameful. I think that is very shameful.
Are you ready for questions?
I'm ready.
All right. Questions for this witness. Representative Ruth.
You may. Thank you. I'm sorry, can you please, and maybe I missed it, maybe you stated it, who do you represent? Where are you from?
My name's Sally Hunt. I'm from St. Louis, Missouri. I represent Expose Thrive, which is a grassroots activism group where we have been talking about Thrive in St. Louis, a crisis pregnancy center, fake clinic that not only does all of this that I talked about, but is also somehow in our public schools, abstinence only until marriage, sex education, sex ed.
So you represent a company who is
not a company,
a group, organization that is just against Thrive. Did I understand that correctly?
Are for fact-based sex education.
Name of your organization is?
And again, Expose Thrive. I don't know if you could call it an organization at this point. It's a group of people who are exposing your group. At this point, all we are is a Facebook group, a grassroots activism group. We've got over 1,600 members in the group.
On Facebook, but not necessarily all of them then from Missouri, since you're on a Facebook social media site.
They're pretty much all
1,600 members?
Pretty much. There could be 2 or 3 that are
but you're not positive.
The vast majority are right here local, and we go to school board meetings and we speak, and yes, they're local. But it's Facebook.
And
so.
Have you spent time in a pregnancy resource center?
I've done a lot of research.
No, have you personally gone into a pregnancy resource center and
I've
spent
done a
time?
lot of research.
But you haven't personally walked into a pregnancy resource center?
I am very informed on this.
But you haven't never walked in. Yes or no? Have you ever walked into a pregnancy resource center? It's a yes or no question.
Actually, I don't think I have.
No, so you haven't. You've only done research, but you haven't actually.
I walked
gone
into
in
their Best Choice School office, and they kicked me out when I wanted to see their.
But you
curriculum.
haven't actually gone into a pregnancy resource center to see the work that they do, or listen at that resource center for the people that they've helped, or talk to the people that they've helped, and spent time there. So
I'm very informed on this.
Well, I think
subject.
if you're going to be very informed, you have to be very informed on both sides when you look at something objectively. And I think seeing both sides of the issues and spending time in those pregnancy resource centers, I can say I have spent time in my local pregnancy resource center. I've gone in hand pregnancy resource center. I've spoken with the director. I've spoken to people that have been there. So I think to say that you're very informed, sounds like you're very informed on one way.
Have I said anything inaccurate?
Yes, I would agree with that. I don't believe that the pregnancy resource centers lie. I think that when you said that there is no mental health issue as a result of abortion, I could say that I have spoken with people that have gone through an abortion who later have mental health issues as a result of that, and what has happened to them from going through that process.
I'm not a mental health provider. I can.
Those are anecdotes.
No, those are actual.
Have you spent any
stories. Those are
time in the American
actual-
Psychological Association's offices? Have you spent any time?
I'm not a
Madam Chairman.
psychiatrist, but ma'am, I am conducting the inquiry here,
So you
so I'm
disagree with the American
asking.
Psychological
I disagree
Association?
with much of your statement, ma'am, and again, I'm making the inquiry, so it's up to me to ask the questions, and as a member of this committee, I'm asking you questions, and I'm asking for your response. So I'm not asking, you don't get the chance to ask me the questions, I'm asking you the questions.
Okay.
So my point is, no, I'm not a psychiatrist. Yes, I do disagree with much of what you've said.
Psychiatrists
and
disagree
unlike
with you and agree with me.
Excuse me, ma'am, Madam Chair. Okay, now, y'all know what we need to do here, right? We need to, let each other finish their sentence. We don't agree, we're not gonna agree. But, let each other finish their sentences, okay? Simple thing. Well, and Representative Cookson thinks we're talking too loud. And we're talking too loud because we're getting, stirred up. So let's just bring it down, take a deep breath. I hope this gives everybody an opportunity to pause and work on our.
Can I ask a question?
Of me?
Yes.
Yes.
If something is a fact and it is already proven, such as by the American Psychological Association or scientific studies, and if someone is disagreeing with those facts, do we just let them go ahead and talk about how they disagree with the facts and don't?
Yeah, I mean, you have the opportunity to dispute what they say when they're finished, okay? I'm sorry, but I think that's the most important thing, is to let someone finish what they have to say, try to talk in a tone that communicates what you want to say, okay?
Okay.
Yeah, all right, thank you. Now, where were you? Representative Ruth, were you making?
Yes,
Okay.
thank you, Madam Chair. I am very passionate about this, so thank you very much. So my point was that I have spent time in our local pregnancy resource centers. I have looked at both sides of this, and I have personally spoken with people that have had abortions who have suffered some mental issues as a result of those abortions and what they went through and the regret that they faced much later on in dealing with those feelings and the emotions from the abortion. So while the American Psychological Association might have their opinion, I also too have an opinion on this. And again, I believe in being well informed by looking at all of the information and doing research in person. So that was my point, and thank you for, well, I'm done with my inquiry. So those were my questions, was to ask if you had spent time in it, since you have been really trashing our pregnancy resource centers and saying that they lie and everything else. I think it's important to note whether or not you've actually spent time there and speaking in person with them. I think that's an important part. If you're going to try to take a stand and try to dispute someone and call them liars, everything else and say that you're well informed, I think it's important that you have actually gone out and done more than just simply what you've read, or actually gone to, because I've seen wonderful things happen as a result of our pregnancy resource centers in my local district, and the fact that you are only citing one pregnancy resource center that you have an issue with.
I said Thrive as an example. I call Thrive by name because they're the main ones in St. Louis. They're big in St. Louis, in our public schools, as well as with all of their healthcare. They bill as healthcare, and they lie. That's another lie in St. Louis. But no, this applies to all crisis pregnancy centers. I was very clear. I said crisis pregnancy centers such as Thrive. They all say these things, and to be clear about that, you say you know people with emotional consequences from abortion. I know many people with none who are very, very happy with their decision to terminate their pregnancy. They're thrilled that they could do it in a safe, legal way. They stand by that choice. They're very, very happy they had that choice. And I'm glad that you have anecdotes that you think disprove the evidence in science, but they do not disprove the evidence and the science, which is clear that there are no long-term mental health consequences of abortion. This is not up for debate because the evidence is already in, the science is in. Again, the American Psychological Association is abundantly clear. You don't want it to be true, it sounds like, because you know a couple people who don't like the fact that they had an abortion. But anecdotes don't disprove overwhelming evidence. So if you want to talk to the American Psychological Association and tell them that
Okay, I'm going to stop you because
that's,
this is just kind of a repeating and I understand.
but again, facts are facts.
Okay, and
So
we
we have to
are
be clear on that.
going to Representative Walker.
Thank you, Madam Chair. I've just got a quick inquiry and then I think a statement. Have you heard of Nurses for Newborns?
No, I don't think so.
Have you heard of Bethany Christian Services?
I have heard of that.
Have you heard of the Adoption and Foster Care Coalition?
Yes.
Okay. Those are examples of a couple of alternative to abortion agencies or that participate in the Alternative to Abortion Agencies program. In fact, I actually sit on the board of Nurses for Newborns. And Nurses for Newborns has been in existence for about 30 or so years. And a lot of the work that they do is absolutely evidence-based. A lot of the work that they do with helping low-income mothers and babies has incredible data that supports their approach, and they have been working to actually get their model adopted by, I guess, on a national level to get the evidence-based, I don't know, its designation from one of the federal, from a federal level. I think that it's very, very dangerous to paint in with a broad brush all what you're saying are crisis pregnancy resource centers or alternative to abortion agencies, because there are several that I know of in around my area that do a lot of really, really good work and a lot of evidence-based work as well. And I am I take incredible issue with the disparaging sort of tone that you're taking with all of these, because I know personally, I sit on the board, I've looked at the data, I've got a background in public health policy, I've got a background in quantitative research. There's several that actually do work. And so just like every doctor isn't the best doctor, you've got some that are out there. I would encourage you to perhaps change the way that you are thinking about it, because sure, are there several that have issues? Absolutely, but to sit and to say that all of them do, and I know that there are several that do incredible work, a lot of really good work in my district, a lot of work that is not really available from state agencies and state organizations. I just wanted to make clear that there are several that exist that are doing really, really important work. Thank you, Madam Chair.
Sure, and I can clarify who I'm referring to, because maybe there are some that don't qualify for the, like the fake, I'm referring specifically to the fake clinic ones. So maybe some of them are not trying to fool women that you're talking about. You might be talking about some different ones that are not trying to fool women into thinking that this is a medical facility where you get women's health care. But that is what I'm referring to, specifically the ones such as Thrive. Birthright is another great example of this, where the entire purpose is designed to trick women into thinking this is a legitimate medical facility. but of course it's not. And I talked about that they get all these tax dollars and they're not regulated. They're not regulated like medical facilities because they aren't medical facilities. They're not required to have medical doctors. So it's the tricking when women think that they're entering a healthcare, a medical facility, but it's not. That's wrong, and that's unacceptable, and that's what I'm talking about. And it's those places that do definitely give the inaccurate information that I listed about that they lie and say abortion causes cancer, and they lie and say abortion causes infertility, and they lie and say abortion causes long-term mental health consequences, and all of those things. And I would say that I'm not saying that they don't do any good work. I have not said that. So maybe that's part of what also you're taking issue with, is maybe it sounds like I'm saying they don't do anything, but I have not said that. I think there are some good things that they do, but what I'm asking for is that they be required to be honest about their agenda. If they have an anti-abortion, anti-choice agenda, I don't know that anyone can be opposed to the honesty, the truth in advertising, and honest, accurate, medically accurate information. Instances where they don't. So if the places that you're referring to don't do that, then they don't have any reason to be concerned. If they don't give medically inaccurate information, I'm not talking about them. And if they don't try to trick women into thinking they're medical facilities, I'm not talking about them. I'm talking about the ones that do that. And so those are who the crisis pregnancy centers are. Maybe there are other places that are in the alternatives to abortion program that aren't those.
Thank you. We have some other questions for you, and I want to reiterate to you, ma'am, that you have said the same thing kind of several times to, the representatives. You repeated about 2 or 3 times. Just one time we'll answer their question. Okay?
Okay.
Good. Representative Barnes.
Attorney Clark,
You may.
I wanted to ask about psychology. Is your testimony, there's no single abortion has led to mental health problems, right?
It's not that it has never happened to any individual person, but it is that the evidence shows.
So I pulled up another study. It says, it's clear that some women do experience sadness, grief, and feelings of loss following termination of pregnancy, and including clinically significant disorders, including depression and anxiety. Do you agree with that?
That long-term or short-term?
That's what they experience. Clinically significant disorders,
There's a
including
difference.
depression and anxiety.
Are we talking long-term or are we talking
Do
short-term?
you agree or disagree with that statement?
I think there's a difference between short-term and long-term, and I think the
Let's
women
say-
who carry a baby to term and who give birth, number one, there's emotional consequences for giving birth, giving a baby up for adoption. What are the emotional consequences of that?
There's a study talking about women experiencing sadness, grief, and feelings of loss following termination of a pregnancy, including clinically significant disorders like depression and anxiety. Do you agree with that?
What about giving babies up for adoption?
It's a yes or no question. Do you agree with that? Because you just said there's no cases where you have these.
I didn't say there's no, I
You
never
said there's no single case.
The
You
overwhelming.
said no single case.
No, I didn't say that. I said the American Psychological Association has stated that there is not evidence that a single elective abortion leads to long-term mental health consequences from their study. Do you want me to read this? I'm sorry, I wasn't reading it just now. Do you want me to read the exact
Sure,
statement?
because actually, you know where I got that sentence from? I got it from the APA report. The sentence that I asked whether you agree or disagree with it. And I think a fair reading of the APA report is that the current evidence regarding mental health issues following abortion aren't significant enough that they can state with scientific certainty one way or another, because they have problems with adequate controls for controlling for the other thing. You also agree, same study notes there is a correlation between multiple abortions and mental health problems, correct?
I'm sorry, I was going to ask that again, please.
So in the instance of a single abortion, they say, look, there's not the strong evidence, the APA concludes there's not the strong evidence to prove that there are mental health problems greater than that which are suffered by women who bring their children to term, right? That's the conclusion. It's not that there are never psychological consequences. It's that looking at they're saying there's nothing in the literature that says those consequences are greater for one single abortion than it is for women who come to term. That's what the APA study says. And it also says that it's a little bit more, their view of the evidence is a little more complicated for multiple abortions, don't they?
Okay, so again, the quote from the American Psychological Association is, "There is no credible evidence that a single elective abortion of an unwanted pregnancy in and of itself mental health problems for adult women." And that's not short-term or long-term. They're saying
You know, it's
none.
interesting. The sentence before that says, "It is clear that some women do experience sadness, grief, and feelings of loss following termination, and some experience clinically significant disorder, including depression and anxiety." Sentence 1 says this happens to real people. Sentence 2 says that the problem is, it indicates the problem with the studies is an inability to distinguish, to have adequate control groups and for this information. I think we had a battle of the facts, a battle of the experts on the other bill. It's hard to get good facts because of reporting of abortions. So there's a study of 40,000 abortions that finds a hemorrhage rate of 5%, that's a bad study. When there's a study of abortions in Medicaid in California and complications in the ER surrounding them, that's a bad study. That's probably one of the most accurate because it comes from Medicaid data that can't be.
And we're back to debating the complication rates of abortion, which are incredibly low. So facts are facts. Abortion complication rates are incredibly low. It's a very safe procedure. That's a fact.
Do you think that a woman who has what's been characterized as serious hemorrhaging that requires hospitalization ought to be in a facility that has a plan on what to do if a serious hemorrhage starts occurring?
Have that. So yes, I think that they should have
So
a plan of what to do.
So that's a fair regulation. If we require a facility that performs any procedure that might result in serious hemorrhaging, to have a plan on how to get that woman to the hospital, that's a fair regulation, isn't it?
I think they've got that.
That's
They're
good
taking
for
care
women.
of that. I think they're doing an outstanding job of taking care of
That's
that
good
very
for women's
rare
health.
circumstance.
All right,
You
okay,
want that
okay.
requirement to happen.
And
Is
it's
that right?
good. And
We're on House Bill
Right, we're on.
9. Thank you very much.
All
Which
things
has
being-
to do with, okay, I'm gonna go to Representative Mann, who's gonna behave as
Thank
well.
you,
I
Madam Chair.
know he's
I
gonna behave well.
appreciate your strong hand in shutting me down. I actually do.
We'll see about that, I guess. I would like to make a request. I'd like to make a request. I'm not familiar, I haven't seen the studies, Representative Barnes alluded to them. Would you please provide to the committee proof in the pudding, the APA studies that prove your point?
I'd be happy to. I have the
Need to have
link.
it- Need to have
Yeah.
it done by Tuesday though, because we'll probably take this
I
up.
have the link
Thank you
typed
very
up right here to leave with you.
And then, is there more than one? You only have to, you're relying on one source?
I have the link to the American Psychological Association. That's the one you're referring to?
That's the one you've given.
I mean, Google will give you lots more. I read lots more. The one I brought with me today is the American Psychological Association.
Pass it on, that'd be great. Thank you.
Oh, I'd be happy to.
Thank you, thank you. I see no further questions for this witness. Thank you.
Thank you very much.
I think you did bring a witness form when you came forward, didn't you? A witness form, did you leave? one?
Yes, I've got it right here.
All right, thanks so much.
And that has the link and all the information. Absolutely.
Okay, we are on House Bill 9, which has to do with freedoms guaranteed under the United States Constitution. Testimony in opposition.
Good afternoon. My name is Alexandra Rubin. I'm a medical student at Washington University.
Okay, I always ask when you have your coat on with the insignia on it, are you representing the university?
I'm not representing the university. I'm representing myself. I'm representing the WashU Medical Students for Choice and my future patient.
Okay, all right. And why did you feel the need to wear your lab coat today?
I feel that, I worked really hard to earn this coat and it's my privilege to wear it. And it's symbolic to me. I want to show sort of what I'm passionate about and what is such an important part of who I am as a person.
Okay, so it's a symbol for us to understand.
I'd be happy to take it off if that would make you more.
It's not a matter of being comfortable or not comfortable, it's a matter of, what it is that you're trying to convey with your presence, but you can keep it on. We've established what it is that you're wanting to convey. So please continue.
Okay, thank you. So thank you for the opportunity to testify. As future healthcare providers training at one of the country's top research institutions, my fellow classmates and I are taught the importance of rigorous medical research and the appropriate translation of that research into clinical practice. We learn how crucial it is to make sure patients understand all of their options and our role in helping patients understanding their own healthcare. I chose to spend years of my life and hundreds of thousands of dollars on my in medical school so I can do just that, so that I can train to become an expert in medicine and go on to help my fellow community members who don't have the same knowledge as me have access to scientifically proven, evidence-based, and medically accurate information and treatments. So with that being said, I'm greatly concerned that this proposed bill does not include language that guarantees that patients receive medically accurate information from alternatives to abortion agencies. It is not possible for a patient to make a well-informed decision that is best for themselves and their family if they do not receive scientifically proven, accurate information. It is bills like those proposed today that future physicians like myself take into consideration when choosing where to practice. And so in the interest of patient autonomy and the integrity of the medical profession itself, please consider what is at risk for citizens in our state and vote no on this bill.
I appreciate that. Did you bring some of the medically inaccurate information with you today for us?
I did not. I am not claiming anything. I'm simply concerned that this bill would not require medically accurate information.
Okay, I understand. Thank you. Are there further questions for this witness? All right, seeing none, please leave your witness form. Thank you. All right, are there others to testify in opposition?
Good afternoon. I am not testifying in any official capacity or any capacity whatsoever other than a Missouri citizen. So
okay, you need to
adjust the microphone. Sorry.
Yes, thank you.
All right, how's that? So if the committee, sure, my name is Ian Mackey. If the committee would indulge me, I would like to time travel just a bit back to 2010, which I believe was a celebratory year for most folks on this committee, particularly back to Tea Party summer and the image of the bright yellow flag with the coiled rattlesnake and the terms, "Don't tread on me." That's why I'm here. I'm here on behalf of, I guess, folks who couldn't make the drive or who feel the same way as I do and aren't in this capacity. With the request that Jefferson City stop treading on St. Louis and its local policy. Representatives, you're tasked with creating state law. When and if the law that you create is in conflict with local law, your law wins. Your law preempts local law. You're a higher level of government. So why are we here? You're here to nullify a law. You're not preempting anything. You're nullifying a law and you're telling a city that they don't know what's best for them. You're telling them that you and your constituents in other parts of the state know what's best for the people of St. Louis and not their own representatives. That's wrong. That's treading. That's one level of government treading on the other. And that's what I watched since 2010 to now, all of you rail against to no end and claim Washington, D.C. was doing to you. So please, stop doing it to St. Louis. That's all.
Okay, questions from the committee. Representative Moon.
Probably more of a statement. Interesting concept, though, Madam Chairman, may I?
Yes.
Okay, interesting concept. We talked about state treading on local government in the city. And I first thought came to mind, Washington, D.C. So if Missouri decided to say, hey, we're a sovereign state to the feds, how would you take that?
A sovereign state as to all laws? What do you mean? Like you get to create the laws you want to make regardless of what the Congress says? I don't really know how that would be. I don't think that would work.
Go back into history and you look at the way the word state was used. When founders used the word state, it was the state of Great Britain. the state of Germany, the state of France, and we all know there are countries. So when we talk about the state of Missouri in that same context, think about it. Thank you, Madam Chairman.
I will reflect on the different definitions of the word state.
That's okay.
I will. Thank you.
All right. So how did you like the Uber law that we passed?
You mean expanding the rights of citizens to access services? That's great. I suppose maybe we should quantify the difference between expanding rights and restricting rights. Maybe that's an important conversation to have here.
However,
the idea that, sorry, still answering your first question, but go ahead.
Right. So what it did actually is restrict elected officials who made decisions over different municipalities, different jurisdictions within the state. So sometimes it's all right for the state to come in and say,
but this law affects only St. Louis. What you did when you told certain cities who didn't want Uber that they were going to have Uber and you were going to give Uber to citizens across the state, that's a totally different story than taking away one ordinance that affects only the citizens of one city. And not only that, but in a way that restricts rights to those citizens. I know that the burning question is, why do we need another protected class? Why do we need to keep adding different groups of people that are asking for, I guess you would say, special rights? Because as long as people can't find fair housing or fair employment, as long as they run into realtors who tell them that their religion isn't going to allow them to rent a home to them, then we're going to have to find a way to protect them. And if that means drawing up a class of similarly situated people, then that's what we'll have to do. Because when a realtor enters the public marketplace and decides to start renting houses and they're not religiously affiliated with an institution, they shouldn't get the right to discriminate.
they don't have that right under the federal law. The federal law protects realtors, renters, etc.
Chair, could I interject something?
Yes.
If I might, just to add a little point of clarification, a reminder that we represent individuals who have the right to make choices, and to reaffirm your statement that the federal fair housing does already cover that issue, but the individuals that we represent have a whole other set of rights.
I don't think they do. I think she was right that that individual realtors don't have the right and shouldn't have the right to discriminate against individuals based on their personal beliefs, unless they're affiliated with a religious institution. Then fine. This ordinance carves out all the exceptions that already exist under the Freedom Restoration Act, Religious Freedom Restoration Act. That already exists. You're attached to a religious institution, go ahead and discriminate, hire and fire who you will. But if you're a realtor who happens to be a Christian and you want to discriminate against me, who also happens to be a Christian, but who happens to be a gay Christian, and you're going to tell me that you're not going to rent me a home, or if I were a woman who had an abortion and you're not going to rent me a home, you shouldn't have that right. You don't have that right.
All right. Are we going to hear from you again, Representative Barnes?
I guess not.
Thank you. Please leave a witness form.
Okay.
All right. Is there anyone else here in opposition? Good afternoon. Thank you for your witness form.
I appreciate the form. Hi, my name is Thomas True. I'm from St. Louis, and I'm wearing my veteran pin. I'm a combat veteran, and my atheist pin.
Thank you for your
I'm an
service.
atheist. So I'm basically here to. I'm also part of Exposed Thrive. I'll keep this real short, and I do appreciate all your service here, even though we're in a special session. My representative is Bob Burns. So, yeah, Bob. He's my neighbor too, though. Basically, I was wanting to answer this representative's question about going to a crisis pregnancy resource center. And I actually helped one of those begin in Kansas, so I'm very familiar with what they do. As a matter of fact, if it wasn't for my plumbing work, it wouldn't even got started. So the supervisor or leader, I forget what he was called, but he was very grateful, very nice gentleman. Didn't try to pressure people. So I'm also have a background that at one time I prayed around the Women's Health Clinic in Wichita, Kansas. That was the one that Dr. Tiller worked at when he was assassinated, in a church, by the way. So I have a very diverse background when it comes to this issue. And when, states try to get involved, that always involves money and rights and so on and so forth. And I was going to say now I've come to the point that I'm organizing an atheist conference. Everyone come out July 28th to 30th in St. Louis. Yay! So I was concerned about your point that you never been, Sally had not been to one of those centers. I wanted to stand centers, and I wanted to stand as a person who had been to one of those, understand what they do, and not all of them are bad. Some of them really try to help women in crisis. Thrive, not so much. I'm not an expert as well as Sally. I'm coming in. I wasn't going to speak at all, but when I heard you say that, I said, well, somebody has to come and say, hey, I've been to those. I know what they do. I've heard what Sally's done. And minds can change. So I think that it's incumbent upon us as legislators and a legislative body is best for all people, we the people in Missouri, and not our special interests. So I'll take any questions if you have them.
Thank you for your testimony. Thank you for your service. Is there any questions? Representative Cookson.
Very quickly.
Yes.
And who do you represent?
I'm coming as an individual citizen. I'm not representing anyone. There's a section in here where it says individual, so that's who I'm representing.
Okay, I just wanted to clarify that because you talked about representing atheist groups or something like that.
Well, I'm organizing of a conference in St. Louis called Gateway to Reason. It's July 20th to 30th. If you want to come, you're welcome. All right. We are inclusive as long as you're nice.
That's a great request. All right, any other questions? All right, seeing none. Thank you for your testimony. Is there anyone else here to testify in opposition to House Bill 9? Okay, looks like there's two more. We'll take these two and then we'll close on House Bill 9.
Wonderful, thank you very much. So I'm actually here representing the organization NARAL Pro-Choice Missouri. Our original lobbyist, Allison Reef, is out, so I'm kind of her this afternoon now. And so NARAL Pro-Choice Missouri, if you're not aware, we are a statewide grassroots organization with more than 50,000 members dedicated to promoting full and equal access to reproductive choices, including preventing unintended pregnancies, choosing safe legal abortion, and bearing healthy children. And so I do have testimony prepared, but I will submit that because I think we've really kind of gone over that component of our concerns with this bill preempting Board Bill 203, the ordinance in the city of St. Louis. But actually, one of the reasons that I wanted to come up here too was Representative Franklin, I know you had a couple of questions that were posed a little bit earlier in this hearing that I wanted to be able to address to give a little bit more background about the bill and the intentions behind that as well, and why we do have those concerns of the preemption. And so to kind of give a little bit more background about Board Bill 203 and why we brought this forward, again, and Representative Newman, I think you made a strong point at this earlier, that again, the full intentionality of this bill was to make sure women and families are protected in their reproductive health decisions. Again, just as you had stated, it was about an anti-discrimination ordinance. That was the intentionality behind it. I wasn't here whenever we crafted the language of the bill, but in talking with the bill sponsor and the co-sponsors as well, this bill was developed following, it wasn't anything that was passed, but it was something that was introduced. It was called the Russell Amendment. The Russell Amendment, it was going to be attempted to be added to the National Defense Authorization Act. And what this amendment would have done, again, it was not passed, but it would have allowed for the firing of an employee because she used birth control or had an abortion, and it would have allowed for the firing of a pregnant woman because she used in vitro fertilization to become pregnant or because she was unmarried. So that was kind of the intentionality behind this bill of, this amendment, if it was considered, if people really were
pushing this amendment forward, what could that mean on the local level? What could that mean on the statewide level for the protections of women and families within our reproductive health decisions? And so that's where this bill came from. This was something that, again, the citizens of St. Louis really articulated wanting. This is something that the Board of Aldermen worked strongly on being able to pass. And that's where our concern of that preemption came in at. One other point that I wanted to address too real quickly, and then I'd be happy to take questions, is the question of where have we seen discrimination take place? I wanted to be able to address that because I have actually been the person who has spoken with this woman who has made the complaint. The previous people who have testified have not gotten to speak to her. But in speaking with her again, she's made a complaint. She's someone who was fired from her job for having a miscarriage. She was someone who worked, she had complications, she had bleeding, she had cramping, and ultimately at the end of the day, she was still fired from her job. So she's in the point of being able to make that complaint, file a grievance within that. And so that's a little bit of that story. Again, as Alderwoman Gracia stated, we didn't hear the stories as frequently because that wasn't data that originally had to be collected. Now that we are collecting that data, we're hearing these stories. We're understanding these experiences that women are facing. And so, again, I'll submit what we have written. Those were some of the questions I wanted to address that you had posed earlier, and I'd be happy to take any questions.
All right, Representative Barnes.
I believe your one example is protected by the Missouri Human Rights Act, and I would hope that your organization would refer them to a law firm to represent her in a case under the Missouri Human Rights Act.
Yes, and we absolutely have.
Okay. Thank you, Madam Chair.
I guess I'm curious how then that, having a miscarriage why did it grow? Why did that concern, where there's a place to take that complaint, then why has it grown on to these other issues?
So one of the reasons that we wanted
discrimination.
So one of the reasons that we wanted to have this on the local level as well is to be able to kind of have that structure and that complaint structure within place for people to be able to make that was still an avenue that people are able to go. So currently, for example, even though we do have these local protections too, even locally, CREA did encourage her to also make a complaint federally as well. So we wanted to make sure that she had multiple avenues to be able to make this complaint through, because sometimes we know within federal cases, which is why we try to pass things locally and statewide, so you're able to get these resources at a much quicker speed as well. So that's a little bit about the reasoning behind it. And again, we're definitely working on her being able to go through multiple avenues to be able to make that complaint.
All right, and the next question, just in your introduction, just a brief answer will be great. That NARL is interested in, I guess, women bearing healthy children, or yeah. So what kind of programs do you have for that?
So primarily we are a reproductive rights advocacy organization. So we do support different organizations like Planned Parenthood, for example, in supporting the work of other Title X clinics as well. Or more on the advocacy side, not necessarily on the patient side.
Okay, so give me that introduction again. You're NARL, and tell me that again.
Yes, so we're NARAL Pro-Choice Missouri. And we're an organization, we've been around for about 50 years now in Missouri and have been actively working to defend reproductive freedom in the state of Missouri.
Yeah, and then what is the part about women bearing healthy children that you said?
Let me just read that on off then.
Yeah.
Dedicated to promoting full and equal access to reproductive choices, including preventing unintended pregnancies, choosing safe legal abortions, and bearing healthy children.
Bearing healthy children. All right, thank you very much.
Thank you.
I'll look into that. Can you send me any information about the Bearing Healthy Children programs and portions? Okay, I appreciate that. Are there any questions for this witness? All right, seeing none, thank you so much. Be sure to leave us a witness form. Good afternoon, evening, good afternoon. So, yes.
It feels like evening. Hi, my name is Anita Cleaver, and I live in St. Louis. I'm mostly just representing myself, but I wanted to see if I could provide any helpful information regarding the question about psychological sequelae to abortion. I wrote a paper on the subject when I was getting my master's in counseling, and what I found was that it's far more common for women to experience relief after getting an abortion than regret. And there is a certain percentage, although I don't know it, there's a certain percentage of women who do regret their abortions. And there are women who do experience grief and sadness. To be perfectly frank, there are characteristics that these women have. For example, one of the characteristics is the belief that abortion is murder. There are certain characteristics that these women have that make them poor candidates to start with to get an abortion. So these women, if they go to a clinic seeking an abortion, they will be speaking with a counselor. The counselor has an opportunity to try to identify any of those characteristics that might lead a woman to the experience of regretting her abortion. And so I think it's fair to say that it's a big choice, and that, like any other big choice that could change your life, people can be glad that they made the choice, or they can regret that they made the choice. But if most women regretted their abortions in the United States, there would be tremendous public outcry over it, because I think it's about 30%, I could be mistaken because I don't have the figures with me, about 30% of women seek abortion at some point. About half of pregnancies in the United States are unintended, according to what I've read. So I think it's only common sense to realize that abortion does not lead to psychological damage for most women. So that's really what I wanted to address.
All right, well, thank you for that information. Are there any questions from the committee? All right, seeing none. Thank you for sharing the witness forum with us. I appreciate that. All right, is there anyone here to testify for informational purposes only? All right, seeing none. Do you have a closing statement, Representative?
Thank you, Madam Chair and members of the committee, for your patience in hearing this. I do just want to close with a simple phrase that was given to me by the manager of the Pregnancy Care Resource Center in my district this morning when I asked her to tell me in 5 seconds what their mission was every day. And she said, Hannah, we wake up every day seeking how we can help these women and these children, give them hope and a chance for the mothers to heal, whether that be from a previous abortion or from unfortunate circumstances in their life that they're dealing with. And with that, I just ask for your support and vote, and thank you for your time.
Thank you. That will end the hearing on House Bill 9. Now we'll go into House Bill 7.
Madam Chair, proceed.
Thank you very much.
This is House Bill number 7, Representative Franklin.
Chair, I appreciate that. So I'm Diane Franklin. I represent the 123rd District, portions of Camden and Macleod counties, and this is on the governor's call list. House Bill 7 is number 12. We're amending the section of 188.47 to modify the law relating to the requirements of the pathological examinations and the reports to the Division of Health and Senior Services, to ask them to adopt rules, regulations that govern the examinations and reports. The bill requires that all organs and tissue removed at the time be submitted to the pathologist. Okay. I'm going to back up just a little bit. So what this bill addresses is the record keeping and the accountability of the results of abortion. For those surgical abortions, where there are identifiable tissue and organs. It creates a circle that can be followed between the abortion, everything that is removed, then sent on to the pathologist. The pathologist then makes an accounting for the correct age of the fetus, the tissues and the organs, and then that goes on to the disposal, and the disposal then is accounted for and when that takes place, and all of this is reported to the department. As part of the folks here were on the committee in 2015, we learned from the pathologist and from the department, and I've said it here today, that there were over 16,000 of these records. When an abortion is done and is sent to the pathologist, both of those places are to send a record into the department, and they're to be reconciled. They were not reconciled, and as part of our investigative committee, I asked the department in October to provide me with as much reconciliation as they had, and even today, I don't have anything. So there's no oversight, there's no, there's really no accountability for the human being, the human tissue, the human organs that are being really moved from one place to another. And in that process, because there's no accountability, things could go, the possibility is that things could go missing. And that is not the intent of the individual who is there for the abortion. So with that, you all have heard this bill. This is your third time. You've heard it twice on the floor. We passed it out each time. And with that, I'll take any questions.
Thank you. Thank you. Representative Cookson, proceed.
Thank you, Mr. Chairman. Is there a defined penalty in your legislation for failure to do this?
Yes, and if there would be, first of all, the first thing that would happen is the abortion facility would trigger an inspection to take place. And then to see if they have to be in compliance, come into compliance with
But if
these
somebody
regulations.
violated the law, could they be sent to jail? Could they be charged with a felony?
Well, that process of reporting them to the department and their license that they have to provide abortions, it is affected by being non-compliant.
Okay, but
Well, the problem, so what you're asking me is.
individuals that would be responsible for doing this or not upholding the law.
Sure, so probably the motivation for not doing it would be selling or would be some sort of financial gain for those parts, those tissues.
Sure.
And there is penalty for that, state and federal.
Okay, thank you. But it's not in this
It doesn't
legislation.
need to be defined in this legislation because it is already law.
Okay, thank you.
You're welcome.
Thank you. Any other questions for the sponsor? If not, we'll move on. Anyone here to speak?
Oh, one second.
I'm sorry. Representative Walker, proceed.
Thank you, Mr. Chair, to inquire. I just have a question. I'm a little bit concerned about the release of the report to the General Assembly and just kind of what the rationale behind that was. As though I know that there are provisions in here that say that PHI, personally identified health information would be redacted. But I guess
My two questions are, one, what's the rationale behind the report being released to the General Assembly? And two, what sort of guarantees or protections, I guess, or penalties even, are available if there is personally identifiable health information that somehow is not redacted?
I'm going to answer your second question first. Because this is a procedure that is like done in a medical arena, then the HIPAA is in place, and there's penalties within the HIPAA for releasing personally identifiable information.
Sure. I think that you have to be, I don't remember the exact terms, but there's only certain entities for which HIPAA applies, clearinghouses, those sorts of things. So I'm not.
They apply for any time that you see any medical professional, any place that processes your lab information, anyone that deals with any of your identifiable information.
I'll get back to you on that, just because I think that that's a common misconception. So like we as a General Assembly, if we got access to this information and somehow the personally identifiable health information was not redacted, I do not think that we are bound by HIPAA to not release that information, because we are not.
I agree with you.
Yeah.
The entity that released that information to you would
be subject to HIPAA penalties.
Yes.
But there's nothing.
We
so,
would, yeah. I mean,
yeah.
We don't want to see anything that identifies an individual, and under those penalties, I think everyone's going to be very careful to be sure.
Yeah, I would absolutely hope so, and I guess that gets to my first question about the release of the report to the General Assembly itself, and just kind of what the rationale is behind that.
Sure. So the report is data gathering information to know what is transpiring in this realm. The first look that we were able to obtain as the investigative committee was really the Attorney General's report. We had made requests and actually asked abortion providers to come and testify so that we could have some information from them. And, you know, they didn't come to testify before us. We asked the director at that time to help us with some information so we can see, you know, what is the data, what's happening in our state. And we were unable to get that. So the report would help us as a legislature to understand what is going on in this arena.
Okay, that makes sense. And I guess, you know, kind of macro level data that would be included in the report, that does make sense. But here with things like unique identification numbers that are tracked to the abortion facility or the hospital, and that sort of more drilled down data that could potentially be included in the report, I have some serious concerns about privacy of patients in that sort of an instance or in that situation.
I don't think you should be.
Could you tell me why?
Well, it says the report shall not contain any personal patient information, the disclosure of which is prohibited by state and federal law. That's line 62.
So it shouldn't, but let's say,
It shall not. It
yes,
shall not.
that there's
There
a shall, not the may. But let's say that with these large facilities, large hospitals, this is applicable not just to abortion facilities.
Hospitals deal with this every day.
Mhm.
Large facilities deal with this every day.
And there have been instances before of data breaches of
Yeah.
and so that's what I am. Yeah, that's.
I agree.
So I guess kind of to Representative Cookson's point, just about certain enforcement penalties that are there. I guess your point is that if personal patient information is released, then whatever the entity is that might mistakenly release that would be subject
and so
to
the state will not possess any information that personally identifies anyone, because even the abortion forms that are turned in don't release the names of the individuals. Only the clinics in their patient files have that information. Everything else that moves or transfers anywhere else is done, I wouldn't say redacted, but I would say there are identification numbers that go with it.
What about information outside of names, like dates, like addresses? Like, I mean, all of that falls under PHI, but just
The forms that they have do not list. You know, there will be a, you know, you can say, okay, in St. Louis, from that abortion facility, they will have their information. If there are other ones that arise in Missouri, then we'll have the information from there. But I guess I don't understand. I feel like I've answered this. I feel like
I'll explain to you why that's kind of what my question or what it is. And it really I think relates to a lot of the discussion we had about CDMP and the registry there, and a lot of the privacy concerns that many members of the General Assembly had just with tracking that sort of information. And that's for prescription drugs. For something like this, like abortion, like reproductive health decisions that are, I would argue, even more personal, even more, I guess, should have even more levels of privacy. I am concerned when there could possibly be situations where that privacy, that information could, kind of the same way that some members were concerned about PDMP and the registry. Does that help you a little bit?
Well, it doesn't help me.
I mean, just put my rationale for my question.
I understand your rationale, because your rationale, although, you know, it might be a requirement going forward with the PMPP, that rather than my name, I'm a number. And so number so-and-so has received a prescription here and is getting it filled, and it's, you know, if that's the concern with that. Here, we already have HIPAA in place, penalties are already in place. The patient's name, address, et cetera, do not go forward. They are kept within the clinic records. Now, there's electronic records, and those can always be, you know, hacked. I mean, that's a possibility.
Okay, great, thank you.
Okay, thank you.
Thank you. Any other questions for Bill Swanson? If not, we'll move on with folks in favor.
We just got cleared the room. I don't know. And I don't know if the Senate's in, because if they've gone in, maybe some of the folks in favor will be over in the Senate, but good to see you. Please.
Good afternoon, Mr. Chair. Tyler again on behalf of the Missouri Catholic Conference. I want to go in support of House Bill 7. This is a bill that's been heard here before. Obviously, I don't want to belabor the point, but I think it goes back to 2015 when you all were examining the practices of Planned Parenthood and the pathologists and everything else. As I recall, Dr. Miller, who owns the Pathology Services Lab, was not able to say definitively that he received all the pathology tissue from abortions performed in St. Louis. And I think that was part of the impetus for this legislation, to ensure that all are sent to them for examination. But in terms of sending tissue out to other places for inappropriate purposes, we would support the bill.
Thank you. Are there any questions from the committee? Representative Cookson, proceed.
Thank you. And this is just a broad question. We've heard a lot of testimony today about pro-life and pro-choice. And live fetuses are live. My question is, what choice does the fetus have in all this process? What choice does the fetus have?
The fetus has zero choice.
the only, who has the choice?
The woman carrying the fetus has the choice.
And the fetus has no choice.
Correct.
Thank you.
Any other questions? If not, thank you. Anyone else to speak in favor? Anyone here to speak in opposition?
Good afternoon. I think I get to speak in opposition just based on the fact that we've been sitting here 6.5 hours and we're still here. So thank you all for your time. My name is Ellen Alper. I'm the Executive Director of the National Council of Jewish Women. And I'm not going to go into who we are and what we do because someone else testified and already said that. What I do want to share is that we are opposed to the expansion of the provisions in this bill. We think it creates another unnecessary burden on those organizations that perform abortion. We also think that it creates an unnecessary barrier for women who may want to consider this procedure and think, oh my God, I don't want to have to go through this. I don't want parts of me to have to go through this. And that's a very private and personal thing. And to have that kind of data reported out to the state legislature can be a very scary thing. I'm also here to drop off testimony from the 12 people or so that could not stay for the 6.5 hours about this bill. There is some written testimony here from an assortment of folks, some who believe that, again, that these are just more trap regulations, that they're unconstitutional, that these things are guided by religious ideology, and what do they really do to improve the health and safety of women? And what does that look like? And how does this help that? If that is the issue of this committee, to protect the health and safety of women in our state, how does this do that? And so, again, I'm here to express our opposition to HB 7, and I'm happy to take any questions that you may have.
Thank you. Thank you. Are there any questions? Representative Newman, proceed.
Yes, thank you, Mr. Chair, and I'll do this briefly because we all are much skinnier. In terms of I agree with you. I see no reason to advance legislation that we already pretty well highly suspect, based on precedent, that this will be litigated, challenged, and be, also proven unconstitutional. So what reason would there be for someone who's had an abortion for, the variety of reasons, from a miscarriage to, a pregnancy gone wrong to anything, what would be a reason to do this besides an attempt to track abortions?
I'm not sure I know of a reason.
And so, again, we do know, you and I are very close to Washington University, back in St. Louis, who is one of the leading research facilities in the country, and yet this is saying that now all organs along with the tissue, has to be sent to the pathologist for further examination. And so, again, not heard of any reason why we need to include this. And like you mentioned, it's invasive. It's invasive to the patient and their families. And can you speak a little bit in terms of what you and I know of women, the reasons they might be needing to get an abortion based on their positions?
Well, there are a lot of reasons. There may be, it's an unintended pregnancy. It's for whatever reason. There could be medical reasons for the woman, as I come from the Jewish faith, as the rabbi stated earlier. There could be any number of health reasons that would cause someone to get an abortion, and to make them go through something like this, which is even more invasive, is really problematic. And one of the things we tried to find in Missouri statute, which we could not find, is there any other statute that affects a surgical procedure that requires whatever is taken out of your body go for a histopathological examination? And we could not find any other example of that. So the question is, why are we singling out procedure and just adding an undue burden both on the provider and undue stress on the woman that's going through that procedure, who probably doesn't necessarily want to go through the procedure, but has to for some reason. You know, I believe in the ability of a woman to choose what she wants to do with her body. We have to make extremely difficult decisions based on our own medical situation, our family needs, whatever the situation may be. And I don't think we should put any undue burden in front of that to make a difficult decision even more difficult for them.
So you can see the, again, this would include those receiving a DNC, a D&E after a miscarriage, a pregnancy that is probably most likely tried very hard for and completely wanted. And so we would be telling those patients, if this was to become law, that their DNC, their D&E then would require their
Distribution of that tissue.
Correct. I mean, there is a lot of, like you mentioned, a lot of reasons, and there's a lot of medical procedures that actually fall under the term abortion that actually this would apply to. And, is there any other purpose besides this in terms of to be punitive?
I'm not sure why it's necessary in the first place. We opposed the law when it was originally brought forth because, again, there's no real need to have it. Why does the legislature need to know this information? This is private, personal, medical information. There's no need to report it out to the legislative body.
Well, and then to even go into current statute and add all organs. So therefore, you're talking about more of specimen that has to be presented. And this is not just, and I know this is written to be an attack on Planned Parenthood, but yet this would actually apply to every physician.
I would think so.
Every physician that does any type of any procedures that are called medical abortion.
OBGYN that does a DNC in their office or any other procedure would have to go through this exact same process.
And do you think these women are going to know this is what?
No, I don't think they are. And I will tell you personally, as someone who had a miscarriage and had to go in and had to have something done about it in my doctor's office, that would have just made an awful personal situation even worse. If my doctor would have said to me, oh, and by the way, just so you know, we have to submit this to the pathologist, and then they're going to submit a record of what just happened to you to the state legislature. And it was a hard enough situation to go through personally all those years ago, and to add that to it, I think just makes it unbearable for women.
So don't you think they should be mandated to be informed of this procedure if it became law? I mean, we mandate other even medically inaccurate information be presented. Mandate this?
You know, I'm not sure. I'm not sure. I think a woman has a right to know what's being done with things that are being removed from her body.
And we presume, particularly in hospitals and like you mentioned, physician offices, that tissue is disposed of properly. We know that the medical community has to deal with this. All kinds of reasons that this body doesn't need to know any information.
There are rules and regulations on the books already about what you have to do and how you have to deal with things, and I think that's sufficient.
For all of these things to happen, again, our 6.5, we're up to $60,000 a day now, and we don't have a bill, and yet we're still arguing over things like this that we know are punitive, that the medical community is opposed to. There's no reason for it, and we know that it most likely will be litigated.
I would agree with you.
Thank you.
Thank you.
Permission to inquire?
Yeah, proceed.
I just have a quick question. Do you support the sale of baby body parts?
No, I do not.
Okay. Well, I view this legislation as a fantastic vehicle forward to protect from the sale of baby body parts in Missouri and in the nation. And so I look forward to supporting the bill, but just wondered your thoughts on that. So thank you.
I haven't really thought about it from that perspective. Just because you can't sell body parts. It's illegal to sell body parts. So it's a non-issue. You can't do it.
We all have our opinions, but I will just say that we know that that's been an issue in this country. where people have been found guilty of that. It's happened, and we need to come to terms with the fact. And like I said, I just wondered your position on the subject. Thank you.
Sure. Any Representative Cookson, proceed.
Quickly, I heard you refer to things in a woman's body. Do you consider fetuses things in a body?
I consider a fetus a fetus.
But
But if I have a
in terms
kidney removed, would
your-
I have to go through the same process? If I had part of a lung removed, would I have to go through the same process? I don't know. I'm not a doctor, so I don't know what the rules are for that. But I would assume that if I had something removed for medical reasons, I'd want it to go to pathology because I want to know what's wrong.
Yeah.
So
And as a person that's probably going to have a liver removed from my body, I want to know things about my liver, so I don't understand that, what the objection would be to, wanting to be, looked at by a pathologist.
I'm not sure what that's going to tell, and there's no mandatory reporting back to the woman about what that pathologist has found. So what's the purpose? You get a liver removed, you want to know, is it cancer? Is it something else? You need to know so you know what your next step of your next treatment is. That's not the purpose of this.
I still have a problem with thinking of fetuses as things. Okay, thank you.
Thank you. Any other questions for this witness? If not, is there anyone else?
Thank you for the opportunity to testify. I appreciate it.
Thank you. Thank you for being here. Proceed when you're ready.
Thank you. So yeah, my name is Kirsten Polovic, and I'm the Organizing and Policy Associate with NARAL Pro-Choice Missouri. And again, we're here in opposition of HB 7 today. I believe Ellen, the representative from NCJW, she did really discuss and summarize a lot of the very similar concerns that we had. But just to kind of re-articulate where our concerns come from again, with HB 7, we feel like this is going to just be another stipulation that's going to be put on abortion providers. This is going to be another stipulation, another step that patients will need to take in an already very restrictive process for women to be able to obtain an abortion in the state of Missouri. So again, echoing several of the same points that were made previously, and I'd be happy to take any additional questions. Thank you.
Thank you for your testimony. Anyone here for questions? Any members? If not, Representative Walker, I'm so sorry. Proceed.
I think it's a little bit long. Thank you. To inquire. Thank you for your testimony, and I understand that you've got a background in policy in healthcare. Could you talk a little bit, or do you believe that there's a difference between confidentiality and anonymity?
Yes, I do.
Could you talk about that a bit? Just what the difference is?
So I don't necessarily have probably a policy background in what I see the differences, but confidentiality, I see that as being able to, with information that's published, being able to, I'm trying to describe it in not a way to include that within the definition, but to make sure that you're who you are, that's protected.
Just keeping it closely held is keeping it secret, right? Versus anonymity, which is what in your definition? Yeah. So versus anonymity, which is meaning that there's absolutely no way at all whatsoever to identify some sort of record, that the record itself is the person who's the patient is anonymous versus confidential. And so in this bill, the language says that the reports that are provided to the General Assembly shall maintain confidentiality of all personal information of patients and not anonymity. Can you speak about that a little bit?
And yeah, exactly. That right there is another concern that we have, that you don't have that anonymity, that promise that's guaranteed to you. Because again, when we already are in a state where it's already a very complicated process to be able to even get an abortion, that there are many restrictions that you have to face. I believe a lot of those were outlined earlier as well, with their 72-hour waiting period, mandatory 2 times counseling. Not having that guarantee right there of that anonymity, it again is another barrier in wanting to be able to have that access to the healthcare that you may need.
Thank you. And finally, and I'm looking through here, and I don't see any sort of time frame for when, let's say, the organs and tissues removed at the time of the abortion is submitted for this histopathological examination and the final disposition. I'm envisioning situations or circumstances where there might be women who are on late-term abortions for medical reasons, and might want to have memorial services or funerals, that sort of thing. But I'm looking through here and I don't see any sort of just time frame for that. Do you see that anywhere? And do you anticipate that too might be something that might be a barrier for, or an obstacle for women?
I did not understand the time frame in there either. I am with you on that. And absolutely, I would definitely see that as another obstacle for women, because again, whenever it's coming to that idea of bodily autonomy and not being able to have that bodily autonomy, to be able to have access to your own body and your own choices within that body, and to not have this very clear time frame, I believe that definitely inhibits that and hurts that as well.
Thank you.
Well, thank you.
Thank you, Mr. Chair.
Any other questions for this witness? If not, if you make sure you leave your witness form.
Thank you.
If there's no other questions. Anyone here to speak in opposition any further? Anyone here for informational purposes? I might speak up for informational purposes. When one goes to surgery, whether it's an appendix or a fractured hip, they do take a piece of that tissue and send it off to the pathologist. That's just standard, and that's standard of care today. Representative Franklin, would you like to close?
I close.
That concludes the hearing on House Bill number 7. And I think we'll wait for Representative Franklin to end this wonderful session.
Got no more work to do.
We're going to go ahead and conclude the public hearing on children and families for this day. Thank you all. Thank you for coming.
Please, because I don't even know. Yeah.
Yeah, I'm living the dream right now. Such a dream. Living it right now.
Where?
They're still there.
Huh?
They're not in yet.
Right now we are.
All right. We are going to take care of a couple of bills. Move those out. So we're going to go into executive session. So I move that House Bill 7 be due pass. Is there any discussion? All right. That was the bill we just heard. Mr. Secretary, please call the roll.
Chairman Franklin.
Aye.
Vice Chairman Neely.
Aye.
Representative Meredith.
No.
Representative Barnes.
Aye.
Representative Cookson.
Aye.
Representative Kelly.
Aye.
Representative Moon.
Aye.
Representative Newman.
No.
Representative Ruth.
Aye.
Representative Stacy.
Aye.
Representative Walker.
No.
By your vote of 8 ayes and 3 noes, you have voted House Bill 7 do pass. Moving on. I move that House Bill 9 be voted do pass. Is there any discussion? Seeing none, Mr. Secretary, please call the roll.
Chairman Franklin,
Aye.
Vice Chairman Neely. Representative Meredith. Representative Barnes. Representative Cookson. Representative Kelly. Representative Moon. Representative Newman.
No.
Representative Ruth.
Aye.
Representative Stacy. And Representative Walker.
No.
By your vote of 8 ayes and 3 noes, you have voted House Bill 9 to pass. And I want to thank the committee members. I want to thank everyone who came to testify and who was in attendance. It was a long day, but we did a good job. Board and committee members, we are going to wait until Monday morning. Right now, we are waiting on the Senate. If it says noon, is that right? Yeah, let me say Monday at noon. Well, you know, you'll just have to look to see when we'll have our hearing. We're kind of in a tentative space right now, waiting for what the Senate is going to do. Yes?
Madam Chair, I just want to point out so that folks, sometimes people read things into the non-existence of actions happening. That House Bills 6 and 3, votes are there. There are little things in the bill that I think need to be cleaned up. The Senate has obviously parallel language. We want to see what they do. Like when we testified, I talked about the Senate has better language on page 2 of their bill. We don't have an amendment prepped right now for that. We've got time on Monday to exec on those bills. And so I want to thank you for delaying the vote to make sure that we get the language right after having looked at some of the Senate stuff and some of the little details that are actually really big, important things to make sure we get it right.
Okay,
So
thank you for that
Madam Chair.
explanation to the committee. Okay. All right, you know, we just have to go through this process. So be watching your inbox for when our hearing will be held, and good explanation of what was going on with the other 2 bills, 3 and 6. And with that, again, my gratitude to all of you for being here. The substitutes, Representative Barnes and Representative Kelly, for being willing to come on board with our committee. And we have long sessions. We have a lot of testimony and a lot of good questions. So again, thank you. I want to thank everyone. Adjourned. All done.
That's not right.